Well, good morning, everybody. Welcome back. We're on our final countdown here. We are on our final countdown. We are so close. We can almost taste it. I've been thinking about our timeline and what we can expect over the next couple days. We've been told that the defense is only anticipating about another 3 witnesses. We've got our crash reconstructionists, and then forensic pathologist, and that is going to be that. That will be it. So, possible we could get through that today. Possible. I think it maybe just depends on how much lally-lallies. We also did get a restriction on one of those witnesses. Isn't going to be able to testify about, Dr. Wolfe isn't going to be able to testify about the medical aspects. For whatever reason, even though we had the medical examiner telling us last week, I can't testify about that type of thing because I'm not an accident reconstructionist. Can't really talk about what sort of force would be involved to inflict an injury. She's not able to do that. So they're going to have limitations on that. Might shorten it up a little bit. Substantively, I don't worry about that from the defense standpoint. Once I learned they have a forensic pathologist, they have their own expert who's going to be able to testify to medical stuff. So I expect they're going to be able to tie the loop up very nicely in terms of what are these injuries consistent with? What are they not consistent with? What types of things would cause these sorts of injuries and all of that? They have covered the universe of expertise for those kinds of questions. So we could possibly get through that today, guys. We could possibly get through that today. So then what's next? Then what do we get? Well, so I've looked up the process a little bit in Massachusetts, because states all kind of do it a little bit differently. And so what it looks like they do in Massachusetts, they have some preliminary instructions, jury instructions about the charge that the judge will give the jury. And then they will have the closings, and then the judge will give final instructions. And those are more of the general, these things apply in every case. This is the burdens of proof, the presumptions, how you process, how you're to evaluate the evidence and handle deliberations, the process, and things like that. So a little bit of instructions on both sides of that. So we've seen the Commonwealth's proposed. We've seen what they've proposed. Haven't seen anything from the defense yet. Don't know if the defense is going to be proposing any instructions, any additional lesser includeds. Typically, there's an instruction that's given if the defendant chooses not to testify. And it's just, generally an instruction that says they have the right not to testify. You can't, no burden of proof. You can't infer anything from a defendant's decision not to testify. You can't hold that against them. So if she doesn't testify, I'd expect them to be proposing something like that. But otherwise, I don't know that they're going to have a lot to ask for here. I just don't know that they're going to have a lot to ask for. The charges themselves, not really in dispute. Mentioned they might have some arguments about the lesser includeds and about exactly how the instructions are worded. The fact that the language of the indictment seems to pretty clearly limit it to intentional murder. She assaulted him with the intent to murder him is the language in the indictment. And so it could be a problem to instruct the jury on other forms of second-degree murder that don't require an intent to kill. So they might have arguments about some of those details. But I wouldn't expect that's going to take very long either. I really wouldn't. So let's think this through. Best case scenario, we finish these witnesses today. They come back in the morning and have a short instruction on short conference on the jury instructions, exactly which ones are going to be given, get that finalized. They'll have an opportunity to do objections and exceptions to the record, to the instructions. And so objections are, I don't want that one to be given. Exception is I take issue with you not giving an instruction that's proposed. And that's typically done on the record as well. So they have a short hearing for that. And then we're off. It's not going to take very long to read these instructions. Half hour, 45 minutes, maybe. Then we got, an hour each for closings, I think I saw. Jury could have this tomorrow. They could have this case tomorrow afternoon. Oh, I'm ready. So I looked up, Massachusetts has a rule for closing arguments, which is a little unusual. I mean, not that these things never exist or anything like that, but just to have it written out in a rule is a little different. But they specifically spell out what are not permissible arguments in closing. Check this out, guys. Here's the rule. Closing argument must be based on the evidence and the fair inferences from the evidence. It may contain enthusiastic rhetoric, strong advocacy, and excusable hyperbole. It is permissible to argue from the evidence that a witness, document, or other evidence is or is not credible, as well as to suggest the conclusions, if any, that should be drawn from the evidence. A party may urge jurors to rely on common sense and life experience, as long as the subject matter at issue does not require expert knowledge. This kind of goes back to a question somebody in the chat had several days back about what if I'm a computer scientist? What if I have degrees in this? I'm a programmer. I understand this stuff maybe better than the people who testified. Am I supposed to just forget that in the jury room? Under this instruction, to the extent that it's expertise, yeah, you kind of do. Same thing with the lawyers. You got to kind of just forget what you know back there if it's beyond the bounds of what just an ordinary lay person would be expected to know. Then we have, so that tells us what is what's okay to argue. That's generally what an acceptable argument is going to look like. Improper argument. The following are not permissible. We might have to do a little over-under on how many of these do we think we're going to get from Mr. Lally, just based on what we've seen of his arguments so far. First, to misstate the evidence. Little of that. To refer to facts not in evidence, including excluded matters. To use evidence for a purpose other than the limited purpose for which it was admitted. So all of those things that we got the limiting instructions on, you're only to consider this like Aruba for the purpose of evaluating motive. If he goes there and argues, look at how much she sucks. Look at what a nut job she is. Proctor called her a nut job, and here he is confirmed with this whole incident in Aruba. Things like that. Or to suggest inferences not fairly based on the evidence. Misstating the evidence, it's just been like one of Mr. Lally's calling cards throughout this case. I mean, we saw it with the argument, with the briefing that he did to try to get the experts thrown out, the misstating what happened with the pretrial hearing and Mr. Yanetti's comment about the dog DNA not being at issue. Just completely distorted that and misstated it. Little hints of this throughout with stuff like, that old reversed video, implying it's something other than it was. And then, of course, just the other day with the Dr. Russell on the stand, implying she had testified that she had a 12 to 18 month subscription to the Globe, when in fact she had not. Same testimony, 6 to 12. But just put it out there like his words are his accusation is impeachment of her. If that's his memory, it's just it's not very good, not a very good memory. And if he doesn't have a good memory for what facts are in, well, then there might be a decent chance he will misstate that. So that's something that, to be on the lookout for. I expect the defense team to be on the lookout for. You have to object in closing, just like at any other stage in the trial. If you want there to be any recourse for something like that, you have to object. You have to give the trial court an opportunity to correct it. Give a limiting instruction, jury. That's not the law, jury. You'll remember the facts as you saw them unfold in this court from the testimony and the evidence. Things like that. You got to give them that opportunity to fix it, or the Court of Appeals won't look at it. Second thing, to state a personal opinion about the credibility of a witness, the evidence, or the ultimate issue of guilt or liability. He cannot get up there and say, I think this person was full of it. I think there's major problems with Lucky Loughlin's testimony, for example. You're not allowed to do that. Nobody cares what you think. It's what you think is irrelevant. Typically, the witnesses aren't supposed to do that either, but we saw already that door just kind of got thrown open with Proctor. Proctor testifying about, we had the overwhelming evidence of guilt and, so on and so forth. Lolly can't do that, can't say, I think, here's what I think about any of this stuff. It doesn't matter. To appeal to the jurors' emotions, passions, prejudices, or sympathies, no, you don't get to pound on the table and be like, this poor grieving family, they need this closure, and the only way to get them closure is by convicting Karen Read. Yeah, no. Stuff like that would be a problem. To ask the jurors to put themselves in the position of any person involved in the case. You don't get to ask you to imagine what if this was your son? What if this was your house? No, the jurors are the jurors. They need to stay the jurors. You don't get to make those types of arguments. Another one, a little like the first. To misstate principles of law, to make any statement that shifts the burden of proof, or to ask the finder of fact to infer guilt based on the defendant's exercise of a constitutional right, such as, not testifying, such as maybe hiring a lawyer, stuff like that. You don't get to do that. Statements that shift the burden of proof, these can be a little insidious. Because they come up to there's no evidence that, the defense is implied, or the defense told you in opening that Karen Read was framed, but there's no evidence of that. You're getting close to burden shifting on that type of thing. Anytime you suggest the defense has an obligation to present evidence, it's bad that they don't. You should infer something bad from the defense not presenting evidence. That's getting awful close to burden shifting. Getting awful close. Especially here where the whole context, the whole point that the defense is making is that you can't rely on this law enforcement investigation. Their theory is nonsense. It's not consistent with, look at the guy. Look at him. That's not a car accident. And so if it wasn't what the Commonwealth says, then it must be something else. So to the extent they've even been allowed to go down that third-party culprit road, it's been under this guise of challenging the investigation. And because we can't rely on the investigation, we have to look at other alternatives. But that doesn't mean they have a burden of proof on other alternatives. It always remains on the Commonwealth to prove their version of what happened. So I'm a little concerned about this one. This is one I just don't know if Mr. Lally is going to be able to escape the temptation to try to go head to head, to try to throw hands with Mr. Yanetti, Mr. Jackson on these cases. You know, they came with this case, but they don't have anything. They don't have any evidence. They couldn't prove any of this stuff. They don't have to. They don't have to. Only the prosecution does. And if that seems a little bit unfair, tough luck. That's what it means to have burdens of proof and presumption of innocence. It's not an even-handed process. There are different standards that apply to both sides. That's just the structure of the system that we have. So I am a little bit nervous about that one. I'll be keeping an eye out for any shifting the burden of proof stuff. And then the final one, to ask the jury to disregard the court's instructions. Don't really expect that here. That's typically your jury nullification argument. Well, you know, this is what the law says, but the law kind of sucks and maybe you shouldn't do that. Yeah, no. You don't get to make those. You don't get to make those types of arguments in closing. So, yeah. We're getting really close to that time. Getting really close to that time. I've been talking to some folks behind the scenes. There, you know, a lot of people doing kind of final shows and wrap ups and things like that this weekend. And I had some invitations, couldn't take them up. I just had a very busy weekend. It was we had my mother's birthday party yesterday, and you know that'll take up quite a bit of your day. You know, I gotta clean the house for mom and all that stuff. But you know, seen a lot of commentary and comments. Boy, Turtle Boy got assaulted. You guys see that? I'm sure you guys saw that. I'm not the only one who saw that. Boy, kind of crazy. These people are so intimidated by Turtle Boy that they drive up and get out of their cars and rush up to him, screaming, and assault him. I mean, way to just go ahead and hand him a defense right there. Way to go ahead and hand him a defense. We're supposed to believe these people are intimidated? These people are the ones that are trying to intimidate him. I mean, they handed it to him. It's crazy. Running up and like he doesn't have a right to be in Canton? Yeah, he has a right to be in Canton. Anybody can go to Canton. Anybody can go to Canton and eat at C.F. McCarthy's. Anybody can, including Turtle Boy. But, yeah, like they're going to run him out of a restaurant, run him out of town. Like, could you have confirmed any more clearly what he's been saying for like a year now? About these characters in this town and what's going on here. You know, who's running the show, the little cabal of the Alberts and the McCabe's. Pretty nuts. So I don't know how all that's going to unfold. I don't know. I've seen, like I said, I have not really been super following Turtle Boy's case. It's a little collateral to this stuff. But I do appreciate the connection with it ever since we heard in that voir dire about Officer Lank pulling the same little dirty trick with I'm gonna use witness intimidation to try to hassle people I don't care about. Yeah, it got my attention. That seems to be the same kind of thing that they're doing here. So it looks like we got the judge now.
22117, the Commonwealth versus Karen Reed.
All right, good morning, counsel. Good morning, Ms. Reed.
But yeah, I really have to wonder. I saw that they're not providing discovery either. Same stuff. Same stuff. I don't know if it's going to make it to trial, if I'm being honest.
Also able to follow the instructions and refrain from doing any independent research or investigation into this case. Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left it on Friday? Everyone said no, she said. Thank you very much. All right, Mr. Jackson?
Good morning, Your Honor. Defense calls Dr. Frank Sheridan.
All right, we get Dr. Sheridan first.
From the voir dire. Those are exhibits from the voir dire.
I forget his first name.
Yeah. You solemnly swear the evidence you give the court and jury in the case now in here and the truth, the whole truth, and nothing but the truth, so help you God. I do. Thank you.
He came prepared. He's done this before.
Good morning, doctor.
Good morning.
I'm going to ask you to, when you testify, sir, please speak into the microphone if you can, loud and clear.
Very well.
All right, thank you.
Is it working?
It should be. All right, thank you. All right, Ms. Little.
Good morning. Can you state your first name and spell your last name for the record, please?
My first name is Frank, and the last name is Sheridan, Sheridan.
And if you can make sure to keep your voice up just because the air conditioner is very loud.
Yeah, I noticed that. Okay.
Dr. Sheridan, what is your profession?
I'm a physician, and my specialty is forensic pathology and neuropathology, but most of my career has been primarily forensic pathology.
What do you currently do for a living?
Nothing. I'm retired.
What role or position of employment did you hold before you retired?
Okay, I was the chief medical examiner for San Bernardino County, California, and I was in that position from 1991 until 2017. That's when I retired from that position, but I stayed on a part-time basis for another few years to help out because the office was understaffed. But a few years ago, 2021 or 22, I've lost track of the time, I finally stopped altogether.
Dr. Sheridan, if you could just pull the microphone a little bit closer. I don't know what's...
I'll put myself closer to it, I guess. Okay, is that better?
Yes,
And Ms. Little, if we need to, just let us know and we'll turn off the air conditioning.
Your Honor. Describe your educational background for the jury.
Okay, well, I was born and raised in Dublin, Ireland, and I
Dublin.
had all my initial education there, including primary school, secondary school, and then pre-medical school at the university I was at was the University College Dublin, Ireland, which is part of the National University of Ireland system. So I did my pre-med and medical school training there. And I graduated from medical school in 1971. Then after that, I did a one-year rotating internship, as it's called, of medicine, surgery, and some psychiatry as well. That was a requirement for all doctors for licensure. So that's basically my initial education. Should I go on with my CV or base or not?
Yes. What did you do after medical school to complete your training?
Well, in the years after medical school, I wasn't in training anymore. I was working in Africa, actually, as a medical officer. And that wasn't training, that was a job. And I was there for 3 years in Central Africa. And I was a general medical officer with various duties that included some teaching, but also seeing patients. So I did that for basically 3 years. I then returned to Ireland, and I spent the next 2 years. We're now talking about, by the way, the years I'm about to mention are 1976 to 78. So I was back in my home country, Ireland, and I spent those 2 years doing research and lecturing in pharmacology. Pharmacology is the study of drugs and how they act in the body. And I did that back at the same university where I had originally trained for medical school. So then in 1978, I came to the United States, initially to the University of Oregon, and I spent the next almost 3 years doing research there and lecturing in the field of genetics. It was during the time I was there that I decided to do forensic pathology. So starting in 1980, let me think for a second, 1982, I then had to start what's called a residency program in pathology. And the first part of that, the first year of that, was in Loma Linda University Medical Center in Southern California. I then had to interrupt my residency training, and I had to go and work in family practice for a year. This was because I was going through the immigration system of the United States, and they required that people in my position work for a year in family practice in a manpower shortage area, as they designated it, an area where there weren't enough doctors. So I did that in a place called Yucca Valley, Y-U-C-C-A Valley, California. But then after that year, I returned to the residency program and continued on at Loma Linda University Medical Center. And this training was in what's called anatomic pathology, which in a way you can think of it as general pathology. It involved autopsies, it involved surgical pathology, looking at slides from surgery. It involved a few other things as well. And so I was doing that there at Loma Linda. Then from 86 to 88, I went to Los Angeles County, USC, which stands for University of Southern California. So LA County USC, as it's generally known, for 2 years of training in neuropathology. Neuropathology being disease and injury of the brain, spinal cord, and so forth. So that was from 86 to 88. And then in 1988, I went to the coroner's office, as it was then called. It's now a sheriff coroner's office, but at that time it was a coroner's office, and in San Bernardino. I did my 1 year required training in forensic pathology there. When I finished that year, I stayed on at the same office. And then in 1991, I was appointed chief medical examiner for the county. And as I mentioned earlier, I was in that position up until 2017. And I'm board certified in anatomic pathology, which I mentioned before is general pathology in a sense. Also neuropathology, as I mentioned about the brain and spinal cord primarily. And then finally, forensic pathology.
In other words, Dr. Sheridan, you're triple board certified, is that correct?
I am, yes. Mm-hmm.
And that's in anatomic pathology, neuropathology, and forensic pathology.
That's correct, yes.
Wow. So all
Can
three.
you describe any relevant teaching positions that you've held?
Yes.
Just keep your voice up. I'm sorry, it's hard to hear back here.
Okay, I'm sorry. Yes, I still do some teaching, actually. First of all, I'm on the staff of Loma Linda University Medical Center, the place where I did my initial training. And I give lectures on a regular basis there to the pathology residents, like I used to be myself. And in addition to that, for a long time, for about 20 years, actually, up until COVID. I was also giving annual, well, no, actually twice a year, courses on forensics at the University of California, Riverside Extension, as it's called. And I did that for, as I said, essentially 20 years, I think. But that stopped with COVID. So I haven't been doing that since the beginning of COVID epidemic. I've also given annual lectures, or not lectures, but courses, 3-day courses, to the California Criminalistic Institute, which is part of the forensic system in California. And then in addition to that, I was associated with another university for a while, but that sort of gradually elapsed. And that's basically it. I give occasional lectures at, well, actually at least once a year at various other places, just individual lectures. I'm a visiting lecturer, in other words, and at community colleges and even high schools, actually. And then I forgot to mention one more thing. For 2 years, I was a visiting professor at a university in China, in what's called Hangzhou, I don't know if I pronounced it correctly even to this day, but Hangzhou, H-A-N-Z-H-O, whatever, H-O-U. It's a big city in China anyway, somewhere. And I was there for 2 years, on two different years, I mean, giving courses on forensic pathology.
And Dr. Sheridan, are you a member of any academic or professional societies?
Of societies? Yes, I've been a member, although I've let it lapse recently intentionally, but I've been a member of the National Association of Medical Examiners for many years. I'm also a member of the American Academy for the Advancement of Science, and also the American Forensic Institute, or the AAFS, American Academy of Forensic Science. I'm also a member of that.
And have you authored any peer-reviewed articles or publications in the areas of forensic pathology or neuropathology?
Yes, but not recently. When I was working, I was too busy to publish. But yes, I did author a few papers earlier on in my career. One of which it wasn't really neuropathology, but it was urology more than, well, it was actually neuropharmacology. And then I did author another paper on that was related to my forensic pathology work on organ donation, organ and tissue donation for transplantation. Those are the two main ones, but there were a couple of other lesser papers.
Can you describe your duties as the Chief Medical Examiner of San Bernardino County?
Yes, as Chief Medical Examiner, I had some administrative responsibilities. Fortunately, not too many, because there were other people to do it. But most of my responsibility there was supervising the medical part of the coroner's office. In other words, the autopsy section. And I was supervising other pathologists, but I was also working full-time doing autopsies myself. So I spent most of my time actually performing autopsies. But I did have, as I said, administrative roles and the role of supervising colleagues. And of course, as a medical examiner, as a forensic pathologist, I frequently had to testify in court, rather like I'm doing now. So that was another part of my duty.
And during the course of your professional experience, approximately how many autopsies do you believe you've conducted?
It's between 12 and 13,000. I think it's closer to
Good
13,000.
And have you qualified as an expert in the areas of forensic pathology, neuropathology, and anatomic?
In courts, yes. Yes, well over 400 times.
How many was that?
Over 400.
And did you review materials related to this case in furtherance of coming to an opinion and conclusion about Mr. O'Keefe's injuries?
Yes, I did. I reviewed quite a lot of materials.
What did you review?
Okay, I reviewed the autopsy report on this case. Along with that, there was the neuropathology report, which was separate. There was a toxicology report. There were autopsy photographs. These were all of primary importance to me, all these things. Then I also reviewed the complaint, in this case, outlining, in other words, the basic details of the case. I reviewed photographs taken at the scene of death of Mr. O'Keefe, photographs of the vehicle that was allegedly involved in his death, photographs of the decedent himself before the autopsy, while he was at the hospital, at Good Samaritan Hospital. Then there was also some videos of the scene of death. I also saw the death certificate, a document by CERT, S-E-R-T, police reports from Canton Police Department. Am I missing anything out? I don't think so. Yeah.
Your Honor, permission to publish what's been previously marked as Exhibit 19.
Sure.
Dr. Sheridan, is this one of the photographs that you reviewed in reaching your opinions and conclusions in this case?
Yes, it is.
Could you describe the injuries that you see in this photograph?
Dog bites?
These injuries that you're looking at here on the arm are abrasions, which are friction injuries, basically. We classify them under the general category of blunt force injury, but these particular ones are abrasions. The abrasions being where the outer layer of the skin, the epidermis as it's called, has been scraped off. These are friction injuries, essentially.
And based on your review of the information discussed earlier, can you tell, as well as your review of these photographs, can you tell whether these injuries were sustained before or after death?
These injuries were sustained before death. We call them ante-mortem, A-N-T-E, mortem meaning before death. And that's based primarily on their color. And you have to take other things into consideration, but that's the basics of it. If these had been post-mortem, they would have a more yellowish, orange color, usually yellow.
In your professional opinion, based on a reasonable degree of scientific certainty, are those injuries consistent with being struck by a vehicle while holding a drinking glass?
Objection.
Sustained.
May we approach, Your Honor?
Sure.
What, they need foundation for that? Doctor, how many autopsies of the 12 to 13,000 that you have done involve pedestrian motor vehicle strikes? And have you had an opportunity to observe the wide panoply of injuries that result from such collisions? And in your experience, have you ever seen a motor vehicle strike that produced injuries like those that we see on Mr. O'Keefe's arm? Something like that would be my guess.
I'm going to take this opportunity to ask you again to keep your voice up, please, sir.
I'm doing my best. My voice is not as strong as it used to
There
be.
we are. Unmuted. We'll stop the AC for a while, then. We'll stop
How do you
the
even
air
do
conditioning for a while,
13,000
then. We want to make sure
autopsies?
we hear you.
I want to do the math on that.
Okay.
Dr. Sheridan, are these injuries consistent with a motor vehicle accident, in your opinion?
Sustained.
I would say in general, no. I mean,
So that objection was sustained. I think Ms. Little's going to put it to you in a different way.
I'm sorry.
If you could assume for purposes of this question that this individual was involved in a motor vehicle collision as a pedestrian, based on your review of these photographs, are those injuries consistent with having been struck by a vehicle?
Objection.
Sustained. Why don't you come back for a minute?
I feel like this is foundation. I saw folks in the chat saying compound, but she's asking very non-compound questions now and still not allowing it. So 13,000 autopsies.
You are unmuted.
Dr. Sheridan, how many autopsies have you conducted on individuals who are involved in pedestrian vehicle?
Foundation.
Involved in what pedestrian vehicle?
Yes.
Yeah, well over 100.
What other experience do you have in terms of conducting autopsies with individuals who have been involved in motor vehicle collisions?
Well, I mean, if you take motor vehicle accidents in general, then they'd be probably nearly a quarter of my total number of autopsies. So in other words, that'd be close to 3,000. Yeah, that's about right.
Based on your professional experience, what is your opinion regarding whether those injuries are consistent with a pedestrian being struck by a motor vehicle?
Objection.
I'm going to allow it.
Yeah. Basic
Yes,
foundation there.
Can you answer that?
I can answer it, yes.
So go right ahead.
Okay. Okay, but the question was, to be precise, can you just rephrase it? I mean, I said yes, I can answer it, but I can't remember exactly how you phrased it.
Yes, based on your extensive training and experience, what is your opinion regarding whether those injuries are consistent with being struck, with an individual being struck by a vehicle?
If you mean struck in that part of the body, on the arm, like
Yes.
directly, I would say no, it doesn't look like that at all.
And can you explain that?
Well, if you're hit by a vehicle, or whichever part of your body is hit, if it's a significant impact at all, you're going to get bruising, and we don't have any bruising here.
No bruising.
We just have what I would call linear abrasions without any bruising. So that does not look to me at all remotely like an impact from a motor vehicle.
What would you expect to see if an individual's arm were struck by the rear of a motor vehicle?
Well, as I just said a second ago, primarily a lot of bruising, and that's what we don't see here. You might see, well, depending on the circumstances, you might see other things like a fracture or fractures, but you would at least expect bruising.
In your
Yeah.
professional opinion, based on your many years of experience, have you conducted any autopsies involving individuals who were involved in any sort of animal attack?
Animal attacks in general, yes, quite a few actually. Well, when I say quite a few, it's not an enormously common event, but I've done probably at least a dozen or so involving deaths where an animal was involved one way or another.
Have you conducted any autopsies in which any individual was attacked by a dog?
Yes, I have a few.
Can you describe that for the jury?
Well, I'd have to just refresh my memory out of the blue here. But first of all, I had a number of cases, 3 or 4, I think, over the years involving children, was primarily children who were killed by feral dogs. And the dogs attacked the kid and killed them. So I had that a few times. But then I've also had cases where an animal or a dog particularly was involved, but wasn't the actual cause of death, so to speak, but they were involved in something that was happening and left some traces of their activity in the form of bite marks or scratch marks.
In your professional opinion, are those injuries consistent with an animal attack?
Are they consistent with what?
An animal attack.
I would say they are, yes. I'm not 100% sure about this, but my initial reaction when I saw this photograph was that it was probably an animal, or most likely I would say a dog. Scrape marks with the paws, and possibly also a bite mark from the teeth as well. Possibly. I'm not 100% sure. I didn't get a chance to analyze it right there on the spot, so to speak. But my basic impression is that these are consistent with marks caused by, say, a dog using his paws or claws, if you want to put it that way, and possibly the teeth as well.
And if there's a pointer up there, would it be possible to direct the jury to the injuries that you're referring to on the screen? There should be a little laser pointer up there, I believe.
I don't know that I see one.
It's not there.
As soon as he saw it, he thought, well, that's a dog bite.
Okay.
Using the laser pointer, could you indicate the injuries that you believe just testified are consistent with scratch marks?
Actually, in a sense, they're all consistent with scratch marks in the sort of the more generic sense of their, whether it's the paws or the teeth, they're going across the skin rather than going straight into it. So they're all of these marks are generally consistent with, if you want to call them scratch marks. So I don't know if this will work on the screen, but you basically got what looks like there's one pair there with possibly a third one in the middle. There are two very clear parallel marks there with another one fainter in the center. Then you have, going closer to the elbow, you've got another 2 or 3, whichever way you look at that. At the elbow itself, you have, that part of the elbow there is what I would think is the most likely candidate here for a bite mark, because it has something of the configuration of the outline of teeth. And then the ones on the forearm are a little bit less obvious, but they're still consistent in general with, I would say, claw marks or maybe from the teeth.
Dr. Sheridan, if you assume that the decedent was standing with his arm extended in this manner, and he was struck with the rear taillight of a 7,000-pound Lexus only on the arm, such that it spun him around and propelled him 30 feet, do you have an opinion as to whether or not these arm injuries are consistent with that scenario?
Objection. All right, I'll see you inside.
Do you have any theory as to whether that scenario is ridiculous or not, doctor? Hit him only in the arm, but yet spun him and threw him 30 feet. Do you have any thoughts about that? No, he probably doesn't. That's what the reconstructionists will be for. I trust Jeff's math, and Jeff tells me that 13,000 autopsies is 1 per day for 35.6 years. That is a lot of autopsies. That is a lot of autopsies. 1 a day for 35.6 years. This man has been very, very busy. I just love that as soon as he saw it, he knew this is an animal attack. Kind of like pretty much everyone else with common sense who looks at these photos and thinks, huh, wow, looks like a dog got to him. But we need to bring like possibly the most qualified forensic pathologist on the planet to come into this courtroom to go ahead and say that. I do wonder when we get to the accident reconstructionists, are they going to be able to like hide their giggle at how silly this Commonwealth theory is? Hit him just in the arm. And yet somehow the arm remained so fixed and solid that it was still able to propel him 30 feet and into a pirouette. Just not quite how the human body works. Kind of love, well, there's no bruise. You kind of know, you know, if somebody got hit by a car at 20 some miles an hour, there's going to be a bruise. At the very least, there's going to be a bruise. He has not a single bruise on his arm, not one. They're all saying that these are pre-mortem injuries. So unless we have, some sign of a gap between when he got hit and when he died as a result of being hit, I guess there is some evidence of that just because of the brain swelling. That is going to take some time. We don't necessarily know how long. But, I think the problem is just it's a little too close to a large dog. Like, no, it couldn't have been Chloe. It must have been a coyote. Why? Why that? I wouldn't say it's impossible, but I don't think they can go down that road without opening the door for, or maybe it's the German Shepherd dog that we know is in the area. It's at least within a few hundred feet of where he was found. I think if this was a scavenger, part of the problem is they would have eaten. They would have eaten. They would not just bite and pull. I don't know why we're going to recess here. Weird. If it's a scavenger, they're not going to just bite and pull and leave these tears on his arm, right? They're there to eat. They're not just like cleaning their teeth out. So I think there are some big problems with the scavenger theory. Coyotes can be active this time of year. I don't know about in a snowstorm. I don't know about exactly how that's going to work. Lot of coyotes when I was in Tahoe. A lot of coyotes all over the place. Not uncommon to see them at all. They tend to eat people's cats. They like cats. I don't know how much they're going to like a human arm, relatively speaking. But you really would not see them out during an active storm. They would bed down. You'd see them real active right before. But yeah, I think the scavenger theory is problematic for a lot of reasons, but I also think it just doesn't suit the Commonwealth's purposes here to try to suggest he was lying on the grass and then a coyote came along and bit his arm, because it's just a little too close to the defense theory. You can't prove coyotes were there, but we sure can prove that a German Shepherd dog was pretty close by. Pretty close by. They would have been heard, you would think. Coyotes, especially if it's like a pack of them, they make quite a bit of noise. It's yip 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 kind of noise that they make. Again, I just have to. Somebody would have lost a cat in the neighborhood. Somebody would have lost a cat. That's what they go for. That's what they do. Well, I like this guy. I'm impressed with him. I love a good Dubliner accent. It's just lyrical. It just adds a je ne sais quoi to everything he has to say. Absolutely spectacular. Loma Linda University only stands out for me because they do a ton of work on vegetarians. It's a Seventh-day Adventist institution, and so they're one of the places that has kind of done the bulk of the work on evaluating vegetarian diets compared to omnivorous diets and so forth. Seventh-day Adventists, at least doctrinally, support a vegetarian diet. Friction injuries is a very interesting way of describing those injuries, but I like it. It makes sense. That does comport with, how I think of an abrasion as like a scrape or the road rash kind of scenario. Yeah, okay, it's friction. I can definitely see that. It's a little harder for me to see how that fits with teeth and claws, but I guess I guess that makes sense. You just I think of those as a little bit more cutting, but it's not like teeth are razor sharp or anything like that. They are blunt. But now I learned something new. It would be yellow to orange if these were post-mortem injuries. See, I was wondering that this whole time. Because I've been disturbed by the lack of swelling on his arm. If his arm gets real chewed up, your arm's going to swell up, and your arm's going to kind of bruise from that too, right? There's pressure with that, pressure on the tissue beyond just the cutting that happens, the abrasion that happens. And that had always bothered me about these photos, especially just given that, yeah, he had enough time before he died for the swelling to develop in his face, the bruising to come out on his hands, but nothing like that on his arm. I do wonder if, I don't know, is he going to be able to tell us a little bit more about timeline? It's just that the problem too is the environmental conditions, being out in the snow. I think that just complicates a lot of being able to figure this out, because it slows down so many of those processes, not just the ones from when you're alive, but the processes of death as well. The rigor mortis, the livor mortis, all of these processes just get slowed down because of that. Bobby Walter says, how can Jackson show jury these are FBI's experts? I don't know that he'll be able to. The FBI has been clearly off limits. Unless they can get it, they can slide it in just through resume stuff. You know, they'll mention they've worked for the federal government, worked for the Department of Justice, that kind of thing. And the jury might hear as well. I mean, I would expect the jury I kind of expect the jury is going to hear that the defense didn't hire these guys. They were hired by somebody else. That goes to bias. Who is paying for the expert pretty much always comes in, because that's the implication. Oh, if you're paying this person, they're going to say whatever you want them to say. So this really undermines that. These accident reconstructionists were not paid by the defense to put forward a defense theory. So that's going to come out. And then I think it'll just be a question of whether the jury can put two to two together for themselves, knowing that there's been this other proceeding where Mr. Lally wasn't there, the defense wasn't there. Are they going to be able to add it up? Oh, and then these are experts hired by somebody else, not the defense or the prosecution. And they probably also testified. No, I guess they didn't testify at the prior hearing because their report is new. Their report is since all that testimony happened. So, Jaragon, watch Lally open to the wolf at the door, lol, just as he did with Maria Russell. The fact defense needs 2 days says it all. I mean, people asked me, what do you think the best witness is going to be? These are the best witnesses. They had 70 some on their list, and we're getting 6 of them. We're getting just the core of what they need to prove to the jury this was not a vehicle strike. This was not John getting hit by a car. That just simply isn't what happened here. It doesn't make any sense medically. It doesn't make any sense in terms of the physics. And so when you add that on to all of the problems here with the evidence collection and the lack of documentation and so forth, yeah, reasonable doubt. Reasonable doubt. It doesn't help that the Commonwealth already put on the defense case. Trying to get out ahead of it, I guess. Trying to do that pre-buttal, but all they did was just put on the defense's case for them. So now defense doesn't have to go through and call all these people. Commonwealth already did it for them. It does raise the question of are we gonna get more rebuttal from Lally? Are we going to get that? Is the judge going to allow that? I don't know. And looks like they're going straight back to sidebar after the morning break there. OG Kush. Andrea McAlbert's had altercation with Turtle Boy last night, all on video. I saw it. Yeah, right there outside CF McCarthy's. I don't know what they're thinking. I really don't. I don't know what they are thinking. You just handed him a defense. You just confirmed what he's been saying all this time is what's going on in this town with these people.
Jimmy.
Really, really bad call for them to be making. I mean, I have to wonder, would he honestly bring Trooper Paul back to try to debunk these PhD guys, the ones who actually know what the law of conservation of momentum is?
You are unmuted.
Can probably state it in very technical terms, maybe give us the equation for it off the tops of their heads. He might. Yeah, he might. That would be nuts.
Going to touch you, soon.
All right, go right ahead, Miss Little, in a loud voice.
Thank you. And Dr. Sheridan, I'll ask you to also just keep your voice up for this question.
I'll try.
Assume the decedent was standing with his arm outstretched like this and was struck by the rear of an SUV only in his arm at 24 miles per hour. Are the injuries in Exhibit 19 consistent with that scenario?
No, I do not think so.
Can you describe that?
Well, as I think I've already mentioned before, one thing that's not there that should be there, given that idea, that scenario, is there should be bruising, at least bruising, if not perhaps even more than that, but bruising for sure. Secondly, the appearance of these injuries, their pattern, if you want to just call it that, the way they're distributed doesn't seem to fit the idea of the rear of a vehicle being the impacting object.
And at 24 miles per hour, would you expect to see fractures or breaks in the arm?
You could do. There'd be other factors involved as to it would depend on a lot of things, but it's possible, yeah.
I'd like to direct your attention to the injury that Mr. O'Keefe sustained to his head. Do you recall that injury?
To the head?
To the head.
Yes, yes. Mm-hmm.
Could you describe that injury for the jury?
Well, there were a few minor injuries on the face, but the major injury, and indeed the main cause of death, was an impact to the back of the head, slightly to the right of the midline of the back of the head, and where there was a laceration. A laceration is another type of blunt force trauma, but this is a laceration is where the skin is actually opened up or it's split, so you get bleeding from a laceration. So there was a laceration, as I said, in the back of the scalp, in what's called the occipital area, and beneath that, when the skin was moved away as part of the autopsy, there was extensive bruising, hemorrhage in other words, in the scalp at that same point. There was a fracture that started at that point in the skull, but traveled all the way forward to the frontal areas of the skull. So you have the impact. The impact site is clear because, as I said, you've got the laceration. That's where the impact was. So you have the impact with the scalp hemorrhage there, and the skull fractures. Then the brain itself had injuries, significant injuries. First of all, there was bleeding on the surface of the brain. And that's very common in situations like this. But in addition to that, there were extensive bruises, contusions is the real word actually, but they are essentially bruises of the brain substance itself. And that they were in several different parts of the brain, including the frontal areas, which are near the forehead, and also the temporal, which are towards the side, more or less. And then there was also hemorrhage deep inside the brain, in the ventricles, which are open areas in the center of the brain. All of these things were described in the neuropathology report, and you can see them in the photographs that were part of the neuropathology report as well as the autopsy. Because of, as a result of, I should say, the injury to the brain began to swell, and that's what it usually does after major trauma. And as a result of the swelling, you had what's called herniation, where the brain, if you want to think of it this way, the brain is trying to expand, but it can't because the skull is around it. So it begins to put pressure of pushing, especially downwards towards the top of the spinal cord. And eventually, as happened in this case, it's quite clear from the photographs, the brain herniated downwards, the brainstem particularly herniated downwards, and this would have been the final straw, so to speak. That's what would lead to respiratory failure and death. So this was a fatal injury for certain.
And what impact would that type of injury have had on the individual after sustaining it?
Yeah, once this injury occurred, once this impact occurred, Mr. O'Keefe would have been unconscious. He would still be capable of breathing for a while until that brain swelling took over and pushed the brainstem down. But he would from the point of impact, he would have been unconscious for sure.
So he's not walking around dripping blood down his front.
No, he would have been unconscious completely.
Do you have any opinion regarding whether that injury is consistent with having been struck on the ground on dirt or grass?
I'm sorry, I didn't quite get the question.
I'll rephrase it. That was a poorly worded question. Is that injury consistent with striking dirt or grass?
Like, for example, falling onto grass?
Yes.
No, I don't think so. If there's a fall involved here, and there could be, it would be onto a hard surface. But the grass, and as I understand from all the material I reviewed, there was also some snow, and so that might even cushion the impact even a little bit more. But even without the snow, grass is basically too soft for somebody falling and hitting their head on it to get the injuries I've just described.
In addition to focusing on the injuries that were present, what significance do you place on the absence of injuries in conducting an autopsy?
What significance do I put on what?
In addition to focusing on the injuries that are present, what significance do you place on the absence of injuries when conducting an autopsy?
Well, as you put it there, it's a rather general question, but I mean, when you're doing an autopsy, you obviously want to see what is there and what's not, and everything can be relevant, including absent things. Now, in this particular case, there are a number of features of things that are absent that are important. I've already alluded to one, and that is on the arm. If that was an impact from the vehicle, I would expect bruising. But do you want me to continue?
Yes.
Yeah. But
Yes.
if Mr. O'Keefe was struck with, it depends obviously what part of the body is theoretically involved. But if a vehicle hits you, whether it's the back of the vehicle or the front, you're going to have, as long as it's not going extremely slowly, if it's going at any speed at all, any significant speed, it's going to cause at least bruising. And that in this particular case, one of the things that struck me was that there was a distinct absence of bruising on the torso. There was the chest, abdomen, hips, whatever. And also, In most cases that I've ever been involved in where a pedestrian was hit by a vehicle, there are injuries on the legs, including fractures, which are very common on the legs. So the absence of all of these things in this case, I think, is important.
Have you conducted autopsies involving individuals who were involved in fights or altercations?
Yes, many, many times.
There we go.
Approximately how many?
Gosh, I have no idea, and it's but a lot. I mean, I've done. I said earlier that between well over 12, maybe 13,000 total autopsies. Of those, I'm only giving you estimates here, but over 1,000 would have been homicides. Of those, probably maybe a fifth, or about 200, would have involved blunt force trauma instead of, for example, a firearm or something like that. And in those cases, and of course, yeah, okay, so all of those and other cases involving sharp force, homicides involving sharp force may have evidence of a struggle as well. So it's in the hundreds, yeah.
In your expert medical opinion, are Mr. O'Keefe's injuries consistent with a fight or a physical altercation?
In a general sense, they can be. They could be, yes. He had, I alluded to it just briefly before, but the head injury, the major head injury I've described, but he also had a laceration over his right eyelid. He had some scrape marks on his face. He also had some bruises on the back of his right hand, which that kind of injury on the hands can be what we call a defensive injury. In other words, an injury that occurs when you're protecting yourself and you're hit hit either with another fist or with a hard object, and you're protecting yourself. So I would say that some of these findings I've just mentioned are consistent with the possibility of a physical altercation, yes.
Thank you. If I could have one moment.
Sure.
No further questions.
Okay, Mr. Lau?
Thank you.
Oh man, what's he gonna do?
Good morning, Doctor.
Good morning.
Injuries that you were just testifying about with regard to Mr. O'Keefe, they were on his right knee, his right arm, as well as the back right side of his head. Is that correct?
Yes, I forgot to mention the knee, but yes, there were injuries in those places, yes.
And understandable, but this isn't an autopsy you performed yourself, correct?
I did not perform myself, no.
You never saw the body, you're looking at photographs and reports, correct?
Yeah, I'm going by the photographs and the autopsy report, yes.
And contained within the materials that you reviewed, did you ever look at Mr. O'Keefe's medical records from the Good Samaritan?
Look at whose medical records, Mr. O'Keefe's?
Yes.
I looked at the medical records from Good Samaritan Hospital, where he was pronounced dead, yes.
Okay, so you did look at those as well?
I did look at those, yeah. I thought I mentioned it earlier. Maybe I forgot.
I thought I mentioned it
Now-
earlier. I love it.
With regard to what you reviewed of Mr. O'Keefe's injuries, you saw no injuries to his left arm, correct?
To his left arm? No, I don't think so, no.
No injuries to his left leg, correct?
No. Mm-hmm.
Injuries to his torso that you saw?
That's correct. Mm-hmm.
And no injuries to the back left side of his head, is that correct as well?
That's correct, yes. Mm-hmm.
Now, you indicated that you observed or reviewed the autopsy reports as well as autopsy photographs and the death certificate, correct?
I did, yes. Mhm.
Now, do you agree with Dr. Scortibello's determination as to the cause of death being multiple blunt force type injuries in conjunction with hypothermia?
I do agree with her, yes. Mhm.
And you reviewed also the neuropathology report by Dr. Stonebridge?
I did, yes. Mhm.
And do you agree or concur with the findings of Dr. Stonebridge contained within that report?
Yes, there were photographs taken during the neuropathology examination, which were independent confirmation to me of the things described in the report. Yes.
Now, with regard to autopsies that you performed in the past, well, let me ask you this first. As far as the injuries that you observed in the photographs to Mr. O'Keefe's right arm, they were not the cause of Mr. O'Keefe's death, correct?
No, they were not. Mhm.
With regard to autopsies that you performed in the past, in regard to there being some sort of animal involved, as you were testifying before, is it normal to see just injuries related to an animal attack on just one portion of one piece of the body?
Yes, in a general way. I mean, as I mentioned, I think when I was answering the question about the cases I've done involving animals, I tried to divide them into two groups because there's an important difference. Some of those cases were cases where the animals were responsible for the death itself. As I said, a bunch of feral dogs in one case, particularly that I remember. Another was a case where it wasn't a whole bunch of them, but there were two dogs, large dogs, and they killed the victims' children. So those individuals had multiple injuries, including deep bite marks that were fatal, particularly in the neck area. But they also had, and I'm stretching my memory a bit because it's a while since I did these cases, but I do have a general recollection that in in those cases, I should say, in addition to the fatal injuries, there were also some non-fatal sort of things like paw marks. And I can't remember the distribution though on the body.
Do you remember as far as whether or not these injuries that you observed in not taking the child fatalities with the dog's maul? I'm presuming that those involved injuries to significant and extensive parts of the body. Is that correct?
Yeah, those are the ones where the animals caused the death, yes. Mm-hmm.
So in the other instances that you were talking about, do you recall even whether or not those injuries that you observed were ante-mortem or post-mortem?
I'm sorry, I couldn't hear the last part.
The other ones that you were talking about as far as the other animal attacks that you've seen,
yeah.
You recall whether or not the injuries that you observed in those instances were ante-mortem or post-mortem?
Oh, ante-mortem. Well, actually, in one of the cases that comes to mind, the marks appeared to be post-mortem, and that was this person was actually a homicide victim, and they were lying outdoors, and their own dog. This was according to police, though, who came on the scene. When they arrived, there was a dog that turned out to be the victim's own dog, was pawing at the body, and the person was dead. But in another case that I can think of, the scratch marks from dog paws were ante-mortem. And they were confined to one place only. I'm trying to remember what part of the body. This case, I had to testify later on. In this case that I'm thinking of now, the paw marks were limited to just one location. I can't remember exactly where they were, though. Whether it was the leg or the arm, I can't remember.
And that was post-mortem injuries that you're talking about there, correct?
No, in the second case here, they were ante-mortem. So in other words, there's been post-mortem and ante-mortem, yes.
The injuries that you observed on Mr. O'Keefe's arm were to the posterior part of his arm, correct?
Yes, basically, the posterior.
No injuries that you observed on the anterior portion or the other side of the right arm, correct?
That's correct, yes.
No other injuries that you observed consistent with what you're talking about as far as an animal attack on any other part of Mr. O'Keefe's body, correct?
That's correct, yeah. Mm-hmm.
And from what you observed in the reports and the photographs, you can't say definitively what type of animal, correct?
That's correct, I can't.
And you can't say, even if it was an animal or was a dog, what breed of dog that was, is that correct?
No, but if I had to
Can't say the breed.
try, and if I said,
Not asking you to try, sir. I'm just asking whether or not you can say
There he
whether or not
goes
that-
again.
what breed of dog it was.
No, jury, you
no,
don't want to hear
I
this.
can't tell you what breed, no.
You can't say whether or not those injuries were inflicted inside a house or outside of a house, is that correct?
Yeah, I have no idea.
You can't say when they occurred, correct?
Only that they were when he was still alive. Yeah, but other than that, no. And they are fresh looking. I mean, in this generally, so they look like that they happened very shortly before death.
And when you say a short time, you're talking about hours,
Minutes to hours, I would say.
minutes to hours, but you can't.
I mean, I'm talking just based on the injuries themselves alone, leaving anything else out. You can't time injuries as exactly as you might think from CSI or one of these television programs, but they are generally fresh for sure. And but just looking at those on their own, I would have to say minutes to hours, yes.
Now, at some point, were you given or did you review any files from a lab at the University of California, Davis?
I'm not sure. In relation to what?
So are you aware that the State Police Lab in Massachusetts swabbed areas of the sleeve on the right arm of Mr. O'Keefe and sent samples from that in the areas of where the injuries occurred on his right arm, and then sent that to a lab at UC Davis? Are you aware of that?
I'm not sure that I remember that, no.
And so you're equally unaware then that when that was tested, there was no canine DNA found from any of those swabbings in the area where the injuries that you're describing as scratch marks or bite marks occurred?
I wasn't aware of that. I must have missed it.
Aware of any sort of bite history or a specific animal at 34 Fairview being involved in attacks on other dogs?
I'm sorry, I don't think I understood that question.
Were you aware that there was a dog that resided at 34 Fairview Road?
Am I aware that there was a dog there?
Yes.
I was informed there was, yes.
Were you also informed that that dog, months later, after January 2022, was involved in an incident in which it attacked another dog, humans intervened, and one of the humans was bitten?
No, I didn't know that.
Were you aware that there were photographs of an actual bite mark from that actual dog months after January 29th? Were you shown any of that?
No, I don't believe I was.
Now, sir, did you write a report in relation to what you observed or anything in regard to your opinion or your testimony that you're testifying to here today?
I didn't write a report as such, but I signed a declaration early on in my involvement in this case.
And that was a declaration or an affidavit that you signed under the pains and penalties of perjury back on January 31st, 2023. Is that correct?
Sorry, what did you say about that?
When you're talking about a declaration, you're referring to an affidavit that you filed with the court under pains and penalties of perjury in January of 2023.
I didn't think it was January, but however, there was only one, so whatever you have.
Now, at any point in time were you made aware that there were microscopic pieces of the defendant's tail light as small as 1/16 of an inch by 1/16 of an inch that were found in Mr. O'Keefe's clothing?
Objection.
I'll allow it.
That were found in Mr. O'Keefe's what?
Mr. O'Keefe's shirts.
I don't remember that specifically.
And that those pieces were then found to be consistent with the defendant's tail light.
Like I said, I don't remember that particular part.
Were you ever shown any material indicating that there was DNA from the defendant's tail light housing that was consistent with Mr. O'Keefe?
I asked about that myself, but I think the answer I got was no.
Now, were you ever told about a piece of human hair that was found on the right rear quarter panel near the area where there was a dent on the back right of the defendant's vehicle?
No, I don't remember that.
So then you weren't also told that that was then sent out for mitochondrial DNA testing and it was consistent with that of Mr. O'Keefe to a degree of 99.895%.
Which includes 300,000 people.
Yeah. No, I didn't have that.
Now, doctor, would you agree that in blunt impact injuries, the characteristics of a blunt object can then be transferred to the victim in the form of pattern abrasions that match the characteristics of that blunt object?
Yes.
Now, of the photographs, you reviewed photographs of the scene, photographs of the vehicle, is that correct?
Yes, I did.
You're aware that there were a number of different pieces of the defendant's taillight that were photographed as well. Did you ever see those?
I did, yes.
Do you recall seeing any piece of a clear plastic taillight piece that was recovered on January 29th, along with Mr. O'Keefe's sneaker that had dimpling on the outside of that clear piece of plastic?
I remember seeing the pictures of the glass fragments, but I don't remember any more specifics than that.
Do you know what a compression abrasion is?
What?
Compression abrasion.
Yeah, although it's not a term we use all the time, but however, yes.
And a compression abrasion can occur when there's direct pressure from a blunt object together with slight rubbing movements that produce skin and epidermal crushing. Is that correct?
Yeah, you have to have some lateral movement as well, though, to get an abrasion.
Now, when you were talking about
The dimpled plastic is their explanation
prior autopsies
for the
that
arm?
you've done involving pedestrian collisions, is it fair to say that most of those pedestrian collisions that you were doing autopsies on involved pedestrians being struck by the front of the vehicle?
Yeah, mostly the front.
So mostly it's a pedestrian sort of crossing the street or standing in the street who's then struck by the front of the vehicle, correct?
Yeah, I think they were all. I have actually done a couple of cases where children were hit by the back of a reversing vehicle. This was in the days before they had the rear videos on cars that they have now. But so those cases were impacts against the back of the vehicle. But most pedestrian cases, yeah, are, as you say, they're the front of the vehicle hitting the person.
Just briefly on that, as far as the defendant's vehicle itself, are you aware that there were rear backup cameras and a 360-degree overhead view from the back of her vehicle?
I remember reading that, yes.
Now, understanding what you're talking about as far as a rear vehicle pedestrian collision, is that typically sort of the wear on the vehicle? Let me ask you this first. When you are doing an autopsy in relation to a pedestrian collision, much of the information that you're gaining about that is what you receive from the investigating agency, whether it's the police or something like that, correct?
It varies a lot from one case to another. Sometimes you get no or virtually no information about the accident, because some of these cases I've done, some of them were witnessed and some weren't. Let's put it that way. Yeah. So when they weren't witnessed and when the person was just found later or sometime afterwards, you wouldn't have necessarily any. The vehicle would typically not be there. These would be hit and run type situations. And so in those cases, you wouldn't have all that kind of information. So it varies. It varies.
And understanding that it varies, but primarily what I'm saying is whatever information as far as the body comes in and you're going to conduct an autopsy, there would be some information from law enforcement or witness statements or something as to what type of death this is, as far as gunshot wound, stabbing, pedestrian collision, something like that.
Yeah, absolutely. But like I said, in those unwitnessed cases of pedestrians, I might be given the information that it's probably a pedestrian fatality from a car.
And when it comes to pedestrian collisions, and most of which that you've seen are, again, from the front of the vehicle striking a pedestrian on the roadway, is that correct?
Yeah. Mm-hmm.
And are you familiar with what role sort of the center of mass of that person versus the center of mass of where they're struck plays in reference to their injuries?
Yeah, could be that can have a big effect on how the body reacts to the impact.
So most of the time when you're talking about sort of lower extremity injuries or pelvic fractures or things like that, that's in a frontal collision with the pedestrian, correct?
Most of them were, yeah. I mean, the ones that involved being backed over when they were children. I can't remember the exact distribution of their injuries, except the vehicle went right over them. I do remember that. But anyway, the answer to your question, maybe I'm wandering in my mind, so can you ask me again?
I think you've answered it. So my next question, sir, is when it comes to the rear end collisions, primarily being children, you would agree with me that they have a lower center of mass than a 6'1", 200 something.
Oh, yeah. Yes.
And so as far as them being run over, they're going to get struck, they're probably going to fall to the ground, and then the vehicle's going to go over, correct?
That's right, yeah.
And so how many autopsies have you conducted in regard to pedestrian collisions where they've been sideswiped by the back of a vehicle?
I can't remember.
Can you remember any?
Not off the top of my head, no.
And so if someone is struck by the right rear portion of a vehicle and then projected away from the vehicle based on speed, based on force, based on whatever, would you then expect to see those same type of pelvic fractures or lower extremity injuries that you talked about with a frontal collision?
Well, it depends on the exact position of the victim at the moment of impact. And of course, it could be a lot of different things. They could be, the victim could be facing the vehicle, they could be sideways on, they could have their back. But you're going to see bruising somewhere in that area, in one of those areas, either on the back, the side, whatever, or the front. I would expect to see bruising, significant bruising.
But as you testified earlier on direct, it's sort of dependent or variable depending on how the victim pedestrian interacted with the vehicle. Isn't that correct?
Yes, but I'd expect bruising for sure. I mean, whether you get fractures and so forth will depend on, or for that matter, internal injuries, depends on a variety of factors. But you're going to get bruising for sure.
You did see bruising on Mr. O'Keefe's right hand, correct?
Yes, a small bruising. It looked like two,
That's where he got
possibly
hit.
three, almost confluent or close together bruises.
Were you aware from the materials that you reviewed that Mr. O'Keefe was last seen sort of on video exiting from a bar at about 12:11 a.m. holding a cocktail glass in his right hand?
I vaguely remember that, yes.
Were you also aware that there were pieces of a cocktail glass with Mr. O'Keefe's DNA on it that were found right in the general vicinity of where his body was found?
That I don't remember.
You talked about a couple of different patterns to the injuries that you observed on Mr. O'Keefe's right arm. So my question for you, doctor, is it your testimony that those, what you're terming as animal bites or scratches, were they caused at one time or multiple times, or how many times are we talking about?
You mean on different occasions?
As far as in, there are multiple abrasions as you've
The dog chomped multiple
termed
times,
them, and
yes.
you're attributing them to an animal attack, correct?
I think that's the most likely explanation for these, yes.
And so my question is, sir, is that from the dog or the animal or whatever it is scratching Mr. O'Keefe once, more than once, based on what you observed in
Well, it's more than once. Well, when I had the laser pointer here, I think I pointed to roughly, 1, 2, 3, 4 different areas. So it looks like, and you have, maybe there's an additional, the ones on the lower forearm, on the forearm, I should say, are harder to figure out. But it looks like 4, maybe 5 separate.
4 or 5 separate sort of swipes, whether they be with mouth or claws or whatever.
Yeah, that's correct.
And so is it your testimony that it's not possible that Mr. O'Keefe received that from some part of the motor vehicle, or a glass shattering, or shattering from a taillight, or any sort of metal pieces underneath contained within that taillight housing as far as his interaction with the vehicle?
They don't look remotely like that to me.
So it's not possible, is that correct?
In my opinion, no.
You tried to push it, Lally, and you got the answer that you got.
You were asked
Not
about
possible.
some questions with regard to the surface of the ground as far as dirt or grass. Are you familiar with what the weather was like at the time that Mr. O'Keefe, you testified earlier, you were familiar that he was found in the snow, correct?
Yes.
Do you know what the temperature was like as far as, my question is this, sir. Understanding cushioning of grass and dirt under normal conditions, but if the ground is physically frozen based on the temperature of outside, would that impact as far as your understanding of the injuries to the back of Mr. O'Keefe's head?
No, I mean, even if there was a small coating of ice, I wouldn't change my opinion based on that, no.
I'm not talking about ice, sir. What I'm talking about is the ground itself being physically
What, there's
frozen based
permafrost
on
in
the temperatures
Massachusetts
outside.
now?
Objection.
Sustained.
Now, as far as the hard surface that you're talking about, would that include asphalt pavement?
Yes, it could.
And as far as those injuries, the speed, if Mr. O'Keefe was struck by a vehicle and was projected away from that vehicle and then struck his head on the ground, would that be sufficient force, in your opinion, to cause a skull fracture on the back of his head?
If all that happened, yes, and onto asphalt or something like asphalt, yes, if that's indeed what happened. But like for other reasons, I don't think that is what happened.
This doc is great.
Now, you testified or you asked some questions about your opinion and as to or consistency with the physical altercation. Is that right?
Yes.
And the sort of swelling in Mr. O'Keefe's eyes as far as the ecchymosis is concerned there, that was related to the brain injury. Is that your understanding?
Well, the skull injury rather than the brain.
Skull injury, which leads to the bleeding of the brain, which then leads to the swelling of the eye. Right?
Well, yeah, but no, I mean, let's be clear about this. I mentioned the fractures earlier on that came from the back and went all the way towards the front of the skull, including what are called the orbital plates, which are the bones, the parts of the frontal bone that are right over the eye sockets. And the bone there is very delicate. It's the thinnest part of the skull. Anyway, the photographs and the autopsy report clearly show that the fracture involved that on each side, both orbital plates, in other words. And it's that fracture, it's not the brain itself, but it's that fracture which leads to the bleeding that causes the black eyes, if you want to call them that way.
And as far as what your review of the medical records, your review of the autopsy report, photographs, things that you observed nothing as far as fractures to Mr. O'Keefe's eye sockets, correct?
Well, the orbital plates, in a sense, are part of the eye sockets, but they're the roof.
Were there any fractures to the orbital bones?
There were no fractures that appeared to be coming from the front, no.
As far as the sclera, was there any broken blood vessels or anything that you observed in either the notes or the reports or the photographs or anything else that you saw?
Broken blood vessels were?
The sclera.
Huh?
Sclera of the eyes? You know what that is?
Oh, the eye, yeah. I'm sorry, I couldn't hear. I just couldn't hear what you said, yeah. No, there just, as far as I know, the eyes were clear, yeah. The eyes themselves were clear, yeah.
Now, as far as the minor injuries that you were talking about, as far as the eyelid or the nose, as far as those minor lacerations you were talking about, there was no bruising around any of those lacerations, correct?
The eyelid laceration, don't forget, is in the same area where you have the other injury, and it's a little bit hard to figure out whether how much hemorrhage, how much of that black eye could even be from related to the laceration, because you've got two possible explanations for the black eyes. One is the skull fracture I've already mentioned, but that doesn't rule out his getting an impact as well on the front, but there's no way you can separate them.
But as far as around those minor lacerations that you're talking about, you didn't observe or see any record of any bruising or any broken bones in those areas whatsoever?
No, well, the main one that I was relating to when I spoke about the altercation question was the laceration on the eyelid. That's not related to the head injury that we've been discussing. So it's a separate injury, and it is from some kind of blow to the front.
The minor lacerations that you observe, would they be consistent with being struck by broken pieces of glass or broken pieces of broken sharp pieces of plastic?
If it was indeed a laceration, as it was described, then no, because lacerations by definition although this is a term that's often misused, by the way, even by some doctors. But a laceration, by definition, is an open wound caused by blunt force, not sharp.
So blunt force, as far as what I'm asking is it possible that the lacerations
Tiny
to the
light
face
piece of
were
plastic.
caused by a blunt object that then shattered and caused the lacerations to his face?
I find that hard to imagine. Yeah, I find that very hard to even conceive of.
So it's not conceivable, is that what you're saying?
To me, no.
And from your review of whatever reports and medical records and everything else, what, if anything, did you see, or did you see anything that had to do with an animal being present on scene, or an animal being near Mr. O'Keefe's body, or Mr. O'Keefe being inside the house?
I don't know. I mean, but I heard there was an animal somewhere around the place, a dog. I think you mentioned the dog earlier.
So somewhere around the place, but no evidence that you've seen that animal interacted with Mr. O'Keefe in any way?
No, I wasn't
just
there.
the bites on his
obviously,
arm.
All I can say is what I've already said, but I don't know any more than that.
I know you weren't there. What I'm saying is, from the material that you reviewed, was there any indication or any evidence of that animal ever being near, close to, or interacting in any way with Mr. O'Keefe?
Not that I'm aware of, no.
I'd love to further.
Little? Thank you.
Thought to get out while he could.
Your Honor, if I may approach.
Sure.
Thank you.
Show Mr. Lally.
Oh my gosh, this doctor just bodied him. The nicest possible way of saying,
Dr.
Mr. Lally,
Sheridan,
that's
if you
the
could just take a
dumbest
look at that
explanation for
photograph.
these
Do you
injuries
recognize
I've ever
that?
heard.
Yes, I saw this photograph before. Yeah.
Could you describe that photograph for the jury?
It shows the decedent's knees taken from the right side, but you can see both knees. Mhm.
Your Honor, permission to mark this and then publish it.
Okay, put it into evidence. Okay, is there any objection, Mr. Lally?
No, Your Honor.
Okay.
What if he was there?
Exhibit 657. Yes, you may publish it, Ms. Little.
Thank you, Your Honor. Dr. Sheridan, you were asked on cross-examination about injury to Mr. O'Keefe's knee. Do you recall that testimony?
Yes. Mhm.
Is this the injury that you were testifying about earlier?
Yes, this has been mentioned before. It's an abrasion.
And that's the extent of the injury to Mr. O'Keefe's knee, correct?
Yeah, that's it. Yeah, in that area. Yeah.
Thank you.
That's supposed to be where he got hit by the car.
Right. All right, Dr. Sheridan, you are all set, sir.
You are
Very
all
well, thank
set,
you very much.
sir.
Thank you, Your Honor.
Give us our crash daddies. I don't care if we get the dude or the dreamboat first. I just want them both.
This way, sir. Step right up and just go step for me.
And it's the dreamboat.
Stay in the face. You solemnly swear the evidence given to the court and jury in the case now and hearing should be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, Mr. Jackson, whenever you're ready.
Thank you, Your Honor. Doctor, could you state your full name and spell your last name for us, please?
Daniel Michael Wolfe, last name spelled W-O-L-F-E.
Dr. Wolfe, what do you do for a living?
I am the Director of Accident Reconstruction at a company known as ARCA, A-R-C-C-A.
And what is ARCA exactly?
So ARCA is a forensic engineering consulting firm. We have a variety of disciplines that include human factors, biomechanics, crashworthiness, accident reconstruction, just to name a few.
Based on your title, it sounds like you're the director of the entire accident reconstruction format for ARCA, correct?
That is correct.
What sort of contracts does ARCA routinely engage in?
So we do a lot of work in civil litigation. So we work with insurance carriers, law firms, but we also consult with and do projects with the federal government as well as the National Hockey League on player safety. So we're involved in a number of research projects as well.
Is there other clientele that seeks out ARCA for accident reconstruction or biomechanics or human factors issues?
In terms of beyond the parties that I just listed?
You mentioned the U.S. Department of Defense.
Yes, the military, yes, the Army.
Tell me a little bit about the work that you've done for the Department of Defense.
Well, that was before my time, but I'm aware of projects that dealt with working on vehicles that were over in the Middle East, where they basically designed energy-absorbing seats because there was injuries when the vehicles were going over IEDs.
Is ARCA known both nationally and internationally? Is it recognized as a leader in accident reconstruction issues?
Yes.
As the director of accident reconstruction at ARCA, do you specialize in both accident reconstruction and the human factors that are associated with such reconstruction where necessary?
Yes.
Can you give me a synopsis of the professional discipline of what is accident reconstruction?
I think a simple definition in my mind would be the application of physics, engineering science, and mathematics to collision events. I always like to think of it as if you open up a puzzle box and you dump the pieces out and you've got a bunch of pieces and you're trying to piece together the evidence to see how everything fits to get a clear picture.
And what is the application of human factors to that process?
So to give you an example of human factors in the field of accident reconstruction, so I do a lot of nighttime visibility and conspicuity work. So to give you an example of that, let's say a driver's driving down the road at night. There's a pedestrian that's crossing the road. So we want to have an understanding based upon that pedestrian's clothing, the headlights of the vehicle, any potential artificial lighting in the area. When does a driver recognize that individual on the roadway? And then we can also look at literature to have an understanding of how do drivers respond based upon the hazard they're presented with. So there's different response times depending on the hazard. So it's going to be different for a pedestrian crossing the roadway or a driver responding to a vehicle suddenly stopping in front of them.
Dr. Wolfe, as an accident reconstructionist, do you investigate and reconstruct both passenger vehicle issues, commercial vehicle issues, motor vehicle, pedestrian issues, all of the above?
Yes, I see all types of accidents.
And how long have you been doing this work with ARCA?
A little over 7 years now.
What education, training, and background qualifies you to perform the duties that you've just described for the jury?
Back in 2012, I received a Bachelor of Science in Engineering from James Madison University, along with a minor in mathematics. Some of my courses while at JMU included courses in physics, statics, dynamics, kinematics, material science, along with your other engineering sciences. Subsequent to my undergraduate degree, I then went on to the University of Delaware to pursue my PhD in electrical and computer engineering with a concentration in electromagnetics and photonics.
What additional training or experience do you have as it relates to accident reconstruction in addition to the formal education and the PhD?
Certainly. So in addition to my undergraduate degree and my PhD, I've continued to take courses through Northwestern University in crash reconstruction. Some of those courses have included human factors, lighting. I've taken courses on electronic vehicle data, photogrammetry, three-dimensional laser scanning. So I've continued to take courses subsequent to graduating.
Do you also hold any accreditations in terms of accident reconstruction?
Yes, I'm accredited by an organization known as ACTAR, which is the Accreditation Commission for Traffic Accident Reconstruction.
Are you trained in photogrammetry?
Yes, sir.
Is that to determine vehicle crash incidents or the circumstances surrounding them based on map scenes, evidence from photographs, things of that nature?
Absolutely. So photogrammetry is the science of extracting information, if you will, out of photographs. So things dimensionally about an object, spatially, without ever actually physically seeing the object or inspecting it.
So you don't have to be at the scene to effectively and scientifically reconstruct it to your satisfaction?
No, not at all. And quite frankly, to be honest with you, in my world in civil litigation, oftentimes by the time a case comes across my desk, it's, the accident happened 5 years ago. Some I've even had 10 or 15 years ago. So getting access to the vehicle at that point, it's going to be a long shot.
Doctor, are you a member of any professional societies?
Yes.
Describe those, please.
So I'm a member of the Society of Automotive Engineers, SAE. I'm also a member of the National Association for Professional Accident Reconstructionists, the Optical Society of America, and also the Illuminating Engineering Society.
How many cases would you say in your experience in your career have you reconstructed or attempted to reconstruct, you or your team members?
I don't actively track that. If I had to estimate at this point in my career, it'd probably be well over 1,000.
And how many of those 1,000, I know you'd have a number specific, but how many of those 1,000 would you say involved pedestrians as well?
Several hundred. As I mentioned earlier, a great, excuse me, a great deal of my work is in the field of lighting and visibility. So there's a direct correlation between time of day and pedestrian incidents. We see a rise in the evening and night hours just due to drivers having a difficult ability to try to perceive and recognize individuals. So I certainly see a lot of pedestrian collisions in my casework.
You've done testing or research as it relates to the kinematics and the interaction between pedestrians and vehicles.
Absolutely. So we do a number of tests at ARCA to look at the interaction between pedestrians and vehicles. One of the ones I know I did most recently where we were evaluating a vehicle essentially rolling over a pedestrian. So we wanted to understand the vehicle dynamics as well as the interaction between the pedestrian and the road surface. So we conducted testing at ARCA to evaluate that.
Does ARCA have any other disciplines other than just accident reconstruction?
Absolutely. So as I mentioned earlier, we have crash worthiness. So again, that's where you're going to be looking at the safety of a vehicle. How does it perform in a crash? We have human factors, failure analysis, premise liability, and biomechanics.
As an accident reconstructionist, doctor, do you or have you studied or tested the forces that are at play between objects interacting, a human being interacting with a vehicle, for instance?
Yeah, absolutely.
Part of what you do.
Yes, sir.
Describe that.
So we use hybrid instrumented dummies at ARCA for our testing. So if we want to have an understanding that an occupant in a vehicle, the forces that they might experience, or for any matter, again, if it's an instance where you have something that ends up falling on someone's head and you want to have an understanding of the forces involved in that, we perform testing with hybrid dummies.
I'm just now
Have you ever
noticing
authored
his
any
tie.
peer-reviewed papers in the field
How
of
much I
physics?
like it.
Yes, sir.
Describe those for me.
So I have a number of papers in the field of lighting and optics. I have a recent publication that deals with Toyota and Lexus vehicle control history records as well.
Is that called Toyota Vehicle Control History, Sudden Braking History Recording Characteristics?
Yes, sir.
All right. Was that specific to dealing with vehicles and their interaction with other vehicles and or pedestrians?
It involved looking at the various triggers that system is capable of recording. And specifically, it was looking at what triggers a sudden braking event. So we were able to determine that those triggers, the sudden braking event is triggered when a driver, or I should say the vehicle, reaches...
May we approach?
Sure.
What's the problem here, Lally? Just cutting him off in the middle of his answer because he sounds too qualified. I mean, is he saying he wrote an article about this specific vehicle with the braking history? I mean, it does sound like that's what he's trying to explain. Perhaps that's confusing. I don't know. Maybe it's not exactly the same system.
You are unmuted.
Now you.
Yes, you
Thank
can
you.
move on.
You've been qualified in other courts to testify as an
Move
expert
on.
in the area of accident reconstruction. Is that right?
Yes, sir.
You were not hired by the defense in this case, correct?
That is correct.
At the time you did your expert review, Dr. Wolfe, and your consultation, you and I had never met.
That's correct.
You did not know who I was.
I did not.
You'd never met Ms. Little.
No.
Mr. Yanetti.
No.
Matter of fact, you'd never heard of this case.
That's correct.
You were hired by another agency not connected in any way to the defense, is that right?
Correct.
And not connected in any way to the Commonwealth, is that right?
Correct.
So your analysis and your conclusions and your opinions are completely independent of the defense and the Commonwealth in this case, is that right?
Objection.
Sustained. Mr. Jackson, you can ask it differently.
Is that right?
When you did your analysis and conclusions, well, let me ask it this way. You finalized a report, you and your team.
How would you characterize your
The
relationship?
report is contained in a multi-page document that was submitted following your analysis and your opinions and conclusions, right?
Correct.
The defense didn't have anything to do with that, correct?
Correct.
You had never met us, didn't know who we were when you did this.
Correct.
You'd never met Mr. Lally, didn't know who he was when you did this.
Correct.
So your analysis, opinions, testing, and conclusions were requested by a completely separate agency.
That is correct.
All right. Goes without saying, but I'm gonna ask it anyway. You haven't been paid by the defense?
You have not paid us anything, no.
And you don't work for us?
That's correct.
As a matter of fact, I've never asked you specific questions about your testing before today.
That is correct.
Good to get that out in front of the jury.
Your work product, the report that you provided, was provided both to the defense as well as the Commonwealth. Is that right?
That's my understanding, yes.
And you were equally available to both sides?
In terms of them reaching out?
Correct.
Yes.
And I called you ultimately after receiving your report, asked if you'd join us and testify, correct?
That is correct.
All right. Were you and your team asked to undertake a review for purposes of accident reconstruction of the case that's now pending before the court?
Yes, sir.
Was your team asked the case that's now pending before the court?
Yes, sir.
Was your team asked to do this by the agency that ultimately retained you, not us?
That's correct.
Who at ARCA was assigned to the team who would ultimately undertake this job of accident reconstruction?
It was myself, Dr. Andrew Rentschler, and Scott Klein.
What was Dr. Rentschler's role in this case as it's distinguished from your role in the case?
Certainly. So Dr. Rentschler is a biomechanical engineer, and ultimately he assessed whether or not there was a mechanism for the injuries of Mr. John O'Keefe.
And what was your focus? If he's talking about the injuries to Mr. O'Keefe, what was your focus in your reconstruction and your analysis?
I would simply say it was looking more at the damage to the vehicle.
Okay, so in terms of your team and the responsibilities of each of the team members, you were more focused on the damage to the SUV. Dr. Rentschler was more focused on the injuries suffered by Mr. O'Keefe, correct?
I think that's a fair characterization, although with the caveat that we worked together as a team. So we weren't isolated kind of in those areas, not speaking to each other. We certainly worked together on the analysis.
Understood. Were you provided or did you review certain materials in furtherance of your consultation in this matter?
Yes.
What were you provided?
We were provided photographs of the incident location. We were provided photographs of the Lexus. There were a couple of incident reports that we received. I could look at my report for the full list, but those were the ones.
You can go ahead and do that, Doctor.
Do you have the report with you?
Yes, sir.
I have a copy of it. Is this faster?
Sure. If you.
May I?
Sure. Bev will let Doctor do whatever he wants. Not Mr. Jackson.
Thank you.
But the doctor is free to do what he wants. What's wrong with it? I like the tie. It's modern.
Materials were you provided?
Monochromatic.
Provided it would be approximately 10.
I like
could
it.
you list those off for the jurors, please?
It would be the Norfolk SPDU homicide death report, the Commonwealth of Massachusetts Department of State Police crime scene report, OCME dispatch removal report, photographs of the incident location, videos of the incident location, photographs of the 2021 Lexus LX570, photographs of recovered evidence, crash data retrieval report from the 2021 Lexus 570, report of autopsy, and autopsy photographs.
Based on these data that you were provided, were you able to satisfactorily, to your mind, satisfactorily engage in the consultation that you were hired to do?
Yes.
And come up with some opinions and conclusions based on scientific certainty?
Yes.
Did you review scene photographs of the alleged incident?
Yes, sir.
What information were you able to glean or gather from your review of the photographs, from the scene specifically?
So from those photographs, I was able to identify there was fragments of transparent red, clear plastic. There also appeared to be pieces of chrome and black plastic. I also observed what appeared to be glass fragments along with a black drinking straw.
Did you also review some videos?
Yes.
That was out at the scene, maybe a leaf blower?
Correct. It appeared to be daytime, yes.
Okay. What did you note about the photography at the scene of the items that were being photographed?
Well, I think one thing that comes to mind is it was a little bit difficult to follow the evidence, so to speak. So typically, when I go out and do an inspection, especially of a fresh incident, let's say I've got a debris field or I've got tire marks, what I like to do is kind of step into the scene, if you will, where you take global perspective shots and then you step into a specific piece of evidence so that you can, at a later point in time, identify where that evidence is. I noted that in a lot of these photographs, I didn't see a whole lot of that stepping in. It was essentially just zoomed right into where that evidence is, but not really having a great understanding of where was it relative to all of the other evidence.
Or when it got there?
Correct.
Based on your review of all the materials that you described for the court, did you get an understanding of what the Commonwealth's theory of the case is, specifically that Mr. O'Keefe was struck by the Lexus SUV?
Objection.
Sustained.
Did you come to understand that the allegations before the court were that Mr. O'Keefe was struck by the vehicle?
Objection.
Sustained. Ask it differently, Mr. Jackson.
He's leading.
Did you perform an accident reconstruction specifically focused on determining whether or not damage to the Lexus was consistent with hitting Mr. O'Keefe?
Yes, I think that's a fair characterization.
And reversing that, was your accident reconstruction also focused on whether or not the injuries to Mr. O'Keefe were the result of being hit by a vehicle?
Yes.
Okay. During your analysis, did you note the damage to the vehicle?
Yes, sir.
Describe that, please.
So the primary damage was to the right taillight. It appeared to be fractured with the majority of the lens cover, so that clear and red plastic covering missing from it. In addition to that, if you're looking at the back of the vehicle, to the left of that, in the area above there's also another tail lamp assembly on the lift gate. So above that assembly, there was a small dent along with some paint chips on the bumper, more so on the wraparound section as it kind of curves around to the right side of the vehicle. There appeared to be some superficial scratches as well in that area.
Was there any other damage or deformation that you were able to glean from your review, the photogrammetry, damage to the Lexus, the bumpers, the panels, the quarter panel, the sheet metal, anything like that?
No, the rest was remarkably intact.
Is it common in vehicle pedestrian collisions that there's some sort of bumper displacement and or sheet metal deformation that's concomitant to that?
Absolutely. Assuming a pedestrian is positioned in a normal upright position, you certainly would expect to see damage to the bumper. In a lot of cases, what happens is, the bumper is just clipped on. So again, the force of that impact will oftentimes cause the bumper to kind of become unmounted or unclipped. You certainly could see deformation to body paneling, such as the lift gate or the quarter panel as well.
Is that especially true at higher speeds, meaning above 15 miles per hour or so?
Oh, absolutely, yes.
Was there any apparent damage to the Lexus that appeared consistent with any kind of pedestrian interaction that you saw?
No, it was really confined to just the taillight, a very isolated portion of the vehicle.
During your review and your investigation, did you note information concerning items that were supposedly found on the bumper?
Yes.
What was that?
I believe it was noted there was 2 apparent glass fragments located on the top bumper cover.
What's the significance of the presence of those items or the lack of materiality of those items in your view?
Well, again, I think it's going back to the scene evidence. Again, we knew that there was glass fragments, what appeared to be from a drinking glass, at the scene of the alleged incident.
Is there any glass consistent with the glass that was supposedly found on the bumper, in the taillight housing, the taillight mechanism, anything from the car, from the Lexus, that would account for that glass?
Okay, I think I understand. So the taillight itself is not comprised of any glass. It is all plastic. So that damage, or I should say that glass on the top bumper cover could not have come from the right taillight.
Now, based on your review of the information that was provided to you, did you undertake any testing of that vehicle? I'm sorry, any testing concerning the damage to the vehicle?
Yes, sir.
All right, can you describe what that testing was?
So we performed, again, this is with Dr. Rentschler and I working together on this again. We performed projectile testing to the tail lamp with a drinking glass as well as a hybrid head form.
Let's take those one at a time. How would you describe the drinking glass test?
Certainly. So again, from our review of the evidence, we knew that we had an isolated portion of damage to Lexus confined to the taillight. So we know that we're dealing with potentially a small object that could have created that. Looking at, again, the evidence in terms of the scene photographs, we know that we have a damaged drinking glass at the scene in the vicinity of the fragments of the taillight. So the theory that Dr. Rentschler and I put forward is potentially an individual threw this drinking glass at the back of the Lexus, causing the taillight to fracture.
I'm going to interrupt you right there. You and Dr. Rentschler formed that theory and wanted to test that theory, correct?
Yes.
You were not told that theory by the defense because you've never met us?
Correct.
You were not told that theory by the Commonwealth. You never met them, correct?
Correct.
Your theory was the product of simply having some facts extant in the data that a broken drinking glass, a broken taillight, let's put them together and figure out if the drinking glass could be responsible for the taillight and vice versa.
Absolutely, yes.
And that was your determination of, well, we were given instructions to reconstruct this. Let's look at every single angle, correct?
Absolutely. And I will note, as part of the engagement with the entity that retained us, we were asked not to do any outside research or investigation of the case. It was to be based solely on the evidence that we were provided.
Okay. As a matter of fact, and importantly, while you were doing your testing, had you ever even heard of the Karen Reed case?
No.
So getting back to that testing, and I interrupted your flow, you were looking at whether or not the glass could have produced the damage to the rear taillight that you saw, correct?
Correct.
And what did you do in furtherance of making a determination about whether or not that was possible?
Certainly. So myself and one of our lab technicians at ARCA, we designed and developed a pressurized air cannon. So it was capable of firing a projectile such as a drinking glass at the taillight. So it essentially you can think of it kind of as a giant cannon, but it had a barrel, and then there was a valve that would open rapidly, and directly behind that was a pressurized vessel. And depending on the pressure, the PSI of that vessel, would determine essentially the speed at which that glass would be projected into the taillight.
So you literally built a cannon?
Yeah, it's pretty awesome.
Yeah, it is.
Pretty cool job. Tell me what the results of your testing was with this pneumatic cannon that would fire the drinking glass.
Certainly. So we performed 2 different tests in terms of speeds. The target speeds were 30 and 40 miles per hour.
Why was that?
Well, so with consultation with Dr. Rentschler, he indicated that is a reasonable speed at which an adult male or an individual, for that matter, could throw a drinking glass at the taillight.
Had anybody up to that point, told you any specific, let me see if I can rephrase that. Had anybody indicated that there was any evidence whatsoever that John O'Keefe had thrown a drinking glass at the taillight?
No.
Was this another example of you and Dr. Rentschler and your team just exploring sort of every possibility and working a little bit in the blind?
Objection.
Sustained.
What was the reason that you decided, or you and your team decided, that you wanted to approximate how a grown man could throw a glass at a taillight?
Well, I think we wanted to have an understanding is when a projectile such as a drinking glass interacted with the taillight, would we get damage on the test taillight that was consistent with that of the subject taillight?
Understood. So based on your theory, were you able to approximate the damage on the taillight?
Yes.
Describe that for us.
So as I mentioned, we ran two tests. The target speeds were at 30 and 40 miles per hour. And there was a little bit of variability in terms of what our target was and what we actually achieved. So the achieved speeds were at 31 miles per hour and 37 miles per hour. So there's just depending on how the glass leaves the barrel and some of the rotation can affect some of the speed, or ultimately the end result speed to that. So what I will say, though, is that with the 37 mile per hour projectile into the taillight, we noted and observed that there was damage that was consistent with that of the subject tail lamp, and that the test tail lamp had the majority of the outer lens fractured and missing, broken into pieces, as well as some underlying damage to some of the internal components as well.
Are you saying, well, let me ask you a different question. You were able to replicate the damage to the taillight using a pneumatic cannon firing a glass at 37 miles an hour directly at the taillight, correct?
Correct.
All right. And that would also shatter the glass too, correct?
Correct.
Did you do any testing about whether or not that damage to the taillight could be produced by a person simply holding a glass and being hit by the car driving in reverse?
We didn't do any testing of that, and primarily because, again, if we're looking at the arm and its total length, right? We only have a narrow damage pattern, which on the taillight, if you think about where where it meets the lift gate into where it starts to wrap around to the side of the vehicle, that's only about 6.5 inches in width.
All right. When you fired the glass into the taillight was static. In other words, it was not going to move. It was immovable at that point, correct?
Correct.
All right. So the glass is hurling through the air at 37 miles an hour and hits a static object that's resisting, and that smash is what produced ultimately the taillight damage that you were able to replicate. Is that right?
Yes.
If a person were holding in his hand the glass and the taillight were to hit that hand, the hand would not remain static, correct?
Objection.
Sustained. Ask it differently, Mr. Jackson.
If the taillight were to
What would happen to the hand if the taillight hit it?
A glass. Would that replicate what you did in terms of you're firing a glass into the taillight? In other words, are they apples and apples?
No, I don't think it would be the same.
Okay. Why is that?
Well, as I mentioned earlier, again, the damage to the back of the Lexus, again, is confined to just that roughly, again, when we're talking about the taillight itself, that 6.5 inch section in width.
Right.
So it's inconsistent with the total length of the arm, and certainly from discussion with Dr. Rentschler, inconsistent with the injuries to the arm.
So given everything in your investigation was revealed concerning this testing, are you saying that the taillight was damaged by John O'Keefe holding a drinking glass that was hit by an SUV?
Objection.
Sustained.
In all the information that you were provided, you were not provided anything that suggested that John O'Keefe threw a glass at the taillight. Right?
Objection.
Sustained.
He's being very leading.
Yes.
He's just being leading. You got to open it up a bit more, Mr. Jackson. That's all. You know what's in the report, so you know what he's going to say. Sometimes what happens is you get so caught in your own, like where you're trying to go, what it is that you're trying to elicit, that it's hard to It's hard to formulate. How do I ask this guy to get on that same brainwave with me without just putting it to him directly?
Yes,
but you
thank
can't
you.
put it to him directly.
What information, if any, were you provided that suggested that John O'Keefe threw a glass at the taillight?
No information.
What information, if any, were you provided that suggested that John O'Keefe may have had a pneumatic cannon with him that night?
I'm not aware of any information regarding that.
All right. You also did some testing concerning a drop test. Is that right?
Correct.
Tell us about that drop test testing.
Certainly. So, again, through discussion with Dr. Rentschler, it was my understanding that Mr. O'Keefe had a skull fracture on the back of his head. So we wanted to do an evaluation of the interaction between the back of a head. In this case, we used again, talking about that instrumented dummy again, we used the instrumented hybrid head form to perform a drop test to evaluate the forces of an interaction between a tail light from the Lexus and the human head.
What height did you choose to perform this drop test?
7.5 feet.
Why did you choose that height?
Well, if you calculate it through physics and the acceleration due to gravity, that would equate to an impact speed of 15 miles per hour at that height.
And what was the significance of 15 miles per hour?
Well, that was essentially kind of a starting point for us, if you will. So I will tell you that in reverse, 15 miles an hour is fast. I don't know if you've ever looked at your speedometer when you're pulling into your driveway, reversing into a parking stall. Most people probably don't go more than 5 miles an hour or so. So 15 miles an hour in reverse is fast, especially when we're talking about, it's my understanding it was nighttime. There was winter conditions, potentially wet or icy roads. So again, that speed is going to be what I would say on the high end for going in reverse. So also in addition to with respect to kind of just the nature of that speed, it's my understanding through discussion with Dr. Rentschler that at 15 miles an hour, you start to see significant injuries to the human body when it makes contact with a vehicle. And I think one last point is that we needed to pick a speed where, again, this is kind of just us brainstorming, where we would have damage to the taillight, right? It would fracture it, but it wouldn't completely obliterate it. So we knew if we chose a speed, for instance, of 40 miles an hour, we know we're going to completely essentially explode the taillight. But if we do, 1 mile an hour, we may not do anything to it, right? So we kind of had to pick a middle ground to again, cause damage to the taillight.
What was your conclusion with following that testing? What was your conclusion with regard to whether or not it was consistent or inconsistent with the damage to the truck and the taillight was consistent or inconsistent with making contact with John O'Keefe's head at or above 15 miles an hour?
So strictly speaking to a damage perspective, the 15 mile an hour interaction between the hybrid head form and the test tail lamp produced significantly more damage than that of the subject vehicle. So that indicates that, again, the damage on the subject taillight was less than that of the test taillight.
So if we were to,
So she'd have more damage to her car.
There would be more or less damage to the taillight if you increase the speed to 24 miles an hour. What is your conclusion?
Well, you're talking about significantly more kinetic energy. So if you just think about it from, again, a kinetic energy standpoint, kinetic energy is equal to 1/2 times the mass and the velocity squared. So if you're squaring that velocity and you're going from 15 up to 24 miles per hour, you're going to get a significant amount of more energy associated with that. Probably, I could pull up my calculator, but you're probably looking at 2.5 more times energy than the 15 mile an hour test.
Which means 2.5 more times the damage to the taillight?
Certainly.
Which you did not see in your review of the materials, correct?
Correct.
So what is your opinion or conclusion as to whether or not the damage to the taillight was caused by striking John O'Keefe's head?
From a damage standpoint, it was inconsistent.
I want to shift gears back to the injuries that you saw concerning Mr. O'Keefe's arm, his right arm. During the course of your investigation, did you look at photographs and investigate the injuries to his right arm?
Yes, sir.
what's the width of the taillight, specifically from where it meets the lift gate to the left side? I'm sorry, to the side of the vehicle, the right side of the vehicle.
To the right. So yeah, as I mentioned earlier, that is about 6.5 inches. It starts to wrap around to the right side. So really it's, even though the taillight continues, it's not projecting out on the back end where it's again wrapping around. So in terms of the width that is facing the rear, if you will, it's about 6.5 inches.
And you noted that there was a dent and some paint chips that you identified above the lift gate, correct?
Correct.
How far away from the right side of the vehicle were those scratches and that dent?
Approximately 20 inches.
What was the significance of that distance?
Well, again, to go back to your question about, I think, if somebody was holding a drinking glass, right, and their arm was extended to cause that damage, or if it's theorized that those dents and chips were from that. Again, the thing that sticks out to me is that you have essentially the Lexus taillight.
So ask another question.
What's the significance of whether or not there was damage between the dent and the taillight? In other words, that 20-inch area. Was it dented? Was it harmed in any way?
So in terms of, again, if we're talking about, again, looking at the back of the vehicle and we go to kind of where that right tail lamp just meets the lift gate, as I mentioned, there's another lamp assembly on the lift gate itself. There's also a chrome trim piece above that, and then certainly the body paneling to the liftgate itself. And I think what stood out to me is that between that dent and the fractured taillight, there was no observable damage to that area, which I would have expected had an arm been positioned there.
Can you calculate, or could you calculate, or did you calculate the amount of force that would be required to strike a person just only on the outstretched portion of his arm in order to project him a number of feet, for instance, 30 feet in one direction or another?
Okay, I just want to make sure. Objection.
Take a distance out of it. Break it down.
What?
I'll ask you the same question, but without the 30 feet.
Okay.
Were you able to calculate, or could you calculate the force that would be required to strike a person on his outstretched arm hard enough to spin him around and project him a number of feet?
If you're talking about only an interaction between the arm and the back of the vehicle, no, there wouldn't be any projection. Again, if you think about this, the arm weighs about, again, with Mr. O'Keefe would be about 11 pounds. So you still have, another 200 plus pounds being held down by gravity, and the force is only acting on the arm. So essentially the arm would be accelerated, but the whole body, because the center of mass is not being struck, would not be projected.
Mm-hmm. Yes, thank you.
Is the absence of the damage that you described, between the dent and the rest of the vehicle, with the exception of the taillight, is that consistent or inconsistent with striking an outstretched arm of a human being?
Objection.
I'll allow that.
That would be inconsistent in my opinion.
They have just a moment, Your Honor.
Yes.
And what is your opinion, Doctor, as to the amount of damage that you would expect to see at 15 miles per hour or above on the taillight if, in fact, that vehicle were moving in reverse and were to strike something on a human body, for instance, an elbow or an arm?
Objection.
I'll allow that.
I'm sorry, can you repeat the question?
Probably not.
Sorry.
I'm trying. Physics, that's why.
I'm trying.
From your testing, what would you expect to see in terms of the damage to the right rear taillight if, in fact, that taillight were to make contact with a part of a human body, for instance, an elbow or an arm, at 15 miles an hour or above? What would the level of damage be as compared to the damage that you actually saw?
Well, if we compare it to, again, looking at the drop test that we did with the hybrid head, which weighs about 10 pounds. So again, if we're talking about now a human arm that's comparable in that same weight, we certainly would expect to see a comparable level of force and damage. So as I mentioned, if the arm is outstretched across the right tail lamp and into the liftgate section, I would certainly expect to see deformation to that body paneling, even potentially the tail light on the liftgate itself and that chrome piece as well.
Based on the entirety of your investigation, your entire team's investigation, all the testing that you did, all the biomechanical testing and the engineering and the physics testing that you did, in your expert opinion, was that taillight damaged by striking John O'Keefe from the head?
Objection.
Sustained.
What's
In
wrong
your
with
opinion,
that?
was the taillight damaged by either striking Mr. O'Keefe from the head or the arm?
Objection.
Sustained.
May we approach?
Yes.
You are muted.
What's the problem, Judge? Yes or no questions are not leading. Only if you're telling him which answer is correct. It's not leading. He is free to say yes. He is free to say no. It's fine, Mr. Jackson. Just ask him, what are your conclusions with respect to whether this taillight damage was caused by an impact with Mr. O'Keefe?
You are unmuted.
May I, Your Honor?
Yes.
Last question, Doctor. In your expert opinion, based on all your testing, is the damage to the taillight that you saw consistent with striking a human head?
No.
In your expert opinion, is the damage to the taillight consistent with striking a human arm?
No.
Thank you. That's all I have.
All right, jurors, we will take our morning recess.
All right, report, please.
You are muted.
I thought we took the morning recess already, but I guess we did not.
Call me, please.
Just to make sure something's happening here. Okay. Well. Haven't we gotten quite a bit this morning already? We are going to get these witnesses done today, guys. We're going to get the witnesses done. They might even be arguing the instructions this afternoon. This case is really moving at long last. Look what happens when the Commonwealth is not in charge of things. Unless we get an extensive rebuttal case. Are we gonna, I mean, can you imagine Trooper Paul coming out to rebut this guy? Surely no. Surely no. He used math. He used a formula that he can literally rattle off right there off the top of his head. Not a basic law of conservation of momentum formula, but a kinetic energy formula. He does conspicuity work. I would love to ask Trooper Paul. Trooper Paul, do you know what conspicuity work is? Do you know what that is? What a great word. It's relating to visibility and being able to perceive things. He's basically saying he does visibility analysis, but he used such a great word there. Yeah, we like this guy. We like this doctor. We like this doctor a lot. He's all focused on damage to the taillight, so he's not running into that problem that they had during the voir dire with only the medical doctor can testify to the cause of the injuries. And so I would expect we're going to get the same thing with Dr. Rentschler. He's not going to be able to say what injuries were or were not caused by, at least if Judge Bev sticks with that preliminary ruling. But he should be able to testify about what forces would be necessary to cause this injury or that injury, because we heard from the medical examiner that's outside her scope. That's not what she does. That's what the accident reconstructionist does. So perhaps as long as we limit it to just, what exactly is involved from a force standpoint, then it's going to be okay. But yeah, we'll have to wait and see. At this point, would it even matter? Would it even matter if they don't get to talk specifically about, the causes of the injury to John? I don't. We already know from 2 pathologists, 3 really, if you count. Dr. Scorty was just basically willing to say that the injuries are consistent with every possibility, right? She would not rule anything out. I think that's why Lally got a little bit over his skis asking Dr. Sheridan about what's possible, because Dr. Scorty Bella was pretty much willing to say anything was possible. Well, Dr. Sheridan was not. He was not willing to say anything was possible. He was very willing to say, no, that's not possible, in my opinion. So we already have testimony, from multiple medical people that the arm's consistent with the animal attack. It could be a dog bite. This is not typical injuries that you would see from a motor vehicle collision with a pedestrian. Even Dr. Scorty Bello said that these were not typical, not the classic injuries that you would see in that scenario. So, okay, if he can't, Dr. Rentschler isn't going to be able to specifically say, no, I don't think these injuries were caused by that. Is it even going to matter? We already know. We got the point. If the damage to the car couldn't have been caused by this this theory, this mechanism that the Commonwealth has proposed, then we can go ahead and apply that to what we already know about John's injuries, which is that they're not what you would expect to see. He doesn't have a bruise on him except for on the back of his hand, where he's got those 3 ones. Thank you, Dr. Wolfe. If the car doesn't hit his center of mass, yeah, it's not going to project him. It's going to project his arm. His arm is on a hinge. It's just going to swing his arm and hit his arm into his body. He's going to slap himself with his arm. I mean, this is common sense stuff. But it's nice to have that confirmed by somebody with expertise in these areas. Be rational and nice when in this global sandbox. Turtle Boy, Son, Canton, cases against CPD, DA, FBI, go. We'll see. I mean, is there going to be a sequel to the Commonwealth versus Karen Reed? We'll wait and see if there's going to be a sequel. I said at the top, at this point, I'm kind of skeptical about these charges against Turtle Boy even going forward. After what we just saw, the problems that they're having with the prosecutor not turning over discovery, once again, just dragging their feet, like a speedy trial doesn't matter, just a secondary consideration. And then that's just on top of the layers of First Amendment problems that you have with just the basic allegations and what's being argued to be criminal, and how do you get there once you rule out the things that he has done that are, whether you like them or not, legitimate exercises of First Amendment activity, going and vocalizing your opinion about a case that is in the public sphere, in the courts. You have the right to do that. So I don't know about that going forward, but the FBI stuff, I think, is what we're all real interested in. What, if anything, is going to happen with that? We're dying to know. Not Squirrel. The first responder dash cam shows Lucky's Frankentruck at 6:08 a.m. Would you try to replay that for the jury? If so, how can it be re-shown at this stage of the trial? You could do it through whoever's dash cam it was. Just call that officer back onto the stand and remind them that it's their dash cam video and ask, you know, if it depicts lights going by. And then you would just argue it. You would just argue it in closing. You could ask any of them if they had a recollection of the plow being in the area at the time. They may or may not, so don't know particularly how helpful it is. Probably can't bring Lucky back up at this point. That would have been the way to do it. It would be to just show it to Lucky while he was on the stand and ask him, is this your truck that we're seeing here on this dash cam video? And if he could identify it, that would be the obvious way to do it. But you know, he's your own witness. You've already excused him, so I don't think that's going to be feasible. All of these dash cams are in evidence, so they can just present it in closing if they want to do that and draw that link for the jury. They can just point it out. Lucky testified to this, and now let's look at the video that's in evidence. Wow, here it is. What does that look like? Gee, that looks like Frankentruck. Just like he said, just at the time when he said he was there. You don't need a witness to attest to that. You can just go ahead and present that in argument. It's an inference from the evidence, and it's a reasonable one. Automata, but will the Commonwealth be able to put 1236 on a timeline? The Commonwealth seems to have given up trying to establish a timeline. I don't know how they can fit 1236. She's back at home on the timeline when John O'Keefe is taking steps at 1231 to 1232. Jen McCabe is texting him, pull behind me at 1231, 1232. Karen is already gone. She's already gone. I mean, by their own estimates of how long it takes to get from one part of this town to the other, she's already gone. So the 1241, 1245-ish type of time frame was really what they were gonna have to work with to make that fit, right? And it just doesn't. I think the problem now with Jen McCabe's texts, they blow up the timeline. If she hadn't sent them, we might have a lot more questions still. James Brown, Trooper Paul gave his opinion on injuries. Yes, he did. But the defense didn't object. This is just kind of going down to once again, the defense is letting the Commonwealth get away with a lot more stuff than the Commonwealth is doing with the defense. And you can agree or disagree, critique that as a strategic decision or whatever, but that's the basic reason why. They didn't object and say he's not a medical expert. He got it out, and yeah, so that's that. And if the Commonwealth is going to object, then they're going to get the benefit of those rules. Coffee addiction, thank you for your explanation and expertise. Well, thank you very much. I really appreciate it. Appreciate all of you being here with me and sharing your thoughts and your insights as well. I continue to just be impressed with the intelligence and just wide-ranging expertise that we have here in the chat. All of you people who have drilled into a bone, okay, you're like my idols. That's very impressive to me. Pork Chop Expert 355. The arm injuries start at the top center of the arm and move down. A vehicle pass side swipe on the right arm would show the opposite direction. No. I think the problem is that there's only going to be one time of contact with the vehicle swipe, and so it would have to be one action that accounts for, all of these marks all over the whole side of the arm from the taillight. And that's the point that Dr. Wolfe is making here, is that the taillight, you know, even at the widest point, so even if you get like a weird angle configuration, it's only 6.5 inches. So what, maybe about like that. But the area on his forearm, you know, it's more like a foot. It's much, much larger than you can account for by broken pieces of taillight scraped him in a singular motion as the car is sideswiping him. So it just doesn't fit. Even if we get past, you know, the other problems here with the patterning of these injuries, the parallel formations, the fact that a taillight, if it's gonna shatter, it's gonna be a bit chaotic. I mean, I don't have any reason to think it's going to break into some sort of uniform pattern that would cause these parallel lines at uniform distances clustered together. It just doesn't make sense. But the bottom line is the injuries on his arm are too big relative to where the taillight would be expected to touch him. We just saw this one. S. QWERTY, isn't restricting biomech extremely prejudicial after medical examiner's statement? Jury could now see lack of explanation by biomech as defendant having no explanation. Unless they ask it and get objected to in front of the jury, and then the jury sees the ME said she can't testify to this, it needs a biomechanical person. Here's the biomechanical person, and they're trying, but the judge isn't allowing it to happen. I think, yeah, there is a risk that you're pointing out that if they aren't able to elicit that, now that the jury has heard that this is the type of person who should be able to get that testimony, it would be misleading as to why they aren't able to hear that. I think that's a very good point. And that's the issue with her having opened that door. Dr. Scorti-Bello opened that door when she said, when they asked her specifically about the type of force that would be necessary to create the head injury. I don't know that. I can't know that. That's a physics question, and I'm not a biomechanical expert. So now we know that's what we need. Entry required, 6'3", 300 plus pounds. I'd have to be in a 3-point stand on the line of scrimmage to hit upper arm against a Lexus taillight. Standing, maybe a monster truck. Yeah, something pretty lifted. I did have a case once involving a car accident where the point of impact was the lady's head. And it's because it was a massive lifted diesel pickup truck, and it was a relatively short lady. She was in a crosswalk. The allegation was that the truck just, slowed down to stop at the intersection, but it was, early in the morning, rushing to work, and didn't come to a full stop, gunned it, didn't see the pedestrian. And because of the relative size difference there, she took the impact to the head, got knocked down on the ground, hit the head on the ground, and had, very bad injuries. A lot of the brain kind of stuff like we're seeing in this case with that sort of, head knock into the ground. But it was just a double whammy, because you get hit there and it rattles your brain, then you get hit on the ground and it rattles your brain. It was not good. So yeah, a big lifted truck with big wheels, oversized wheels on it. Yeah, okay. I could see that happening. You're more on the scale of like a commercial tractor trailer. Those things can be pretty big. But Karen's SUV is not that. It's not any of those things. So, yeah, I don't know where we're getting hit by the taillight in the arm. He's crouching, he's squatting. It doesn't make a lot of sense. Seems pretty improbable why he would be in that position in the first place. Thrift with Joy. I want to see if they get back to the lividity evidence that he was moved. It doesn't look like they did. I mean, the lividity seemed to be on his back from what we could see from the photos. Not that they showed us a lot, but it looked like the lividity was on his back. So that's where you would expect it to be if he fell, hit his head and was basically in that position when the lividity process was starting. Michael Corey, according to pathologist in my recent case, rigor mortis for time of death is no longer considered a reliable science, and they do not do it anymore. Any one factor in and of itself, it's not going to be especially precise. There is variation, and it can depend on environmental circumstances. It can depend on a bunch of different things. So I'm not sure if it's really ever been the case that a medical examiner would go in and say, oh, well, because of the onset of rigor mortis, the stage of rigor mortis and so forth, we can put it at a very precise time. It's usually a combination of things that they're looking at: lividity, the rigor mortis, the loss of the body temperature, other biological processes that they can look at. And look at those in combination. And even that still is typically going to give you a range. With rigor mortis, the issue is that it goes through stages that are pretty predictable. So there's an initial period before the rigor mortis starts, then the rigor mortis starts, and it's like that for another certain period. As I recall, it's, somewhere in the 24 to 48 hour period, and then it ceases. So it can give you a general time frame of where are you at in that process. Is the person still in rigor mortis? Okay, that means it's been after this initial point where you wouldn't have any, and it's before the point where it relaxes, basically. But beyond that, it's not going to give you anything real precise in and of itself. So, yeah, I mean, it gives you a general idea of the process, but as far as putting a timeline on it, no. I don't know that it's ever been precise enough to be able to do that, which I wouldn't put it past somebody saying on the stand at some point, overstating the conclusions that they're able to draw from it. That's just kind of par for the course with a lot of what I see from scientific evidence being offered from the state. It's just a lot of times, it's overstated. Yuki Roma, if any of the jurors saw the brouhaha on Main Street with the McAlberts yesterday, could they be removed for possible bias? So first off, if they had seen it, they would be expected, I would think, to volunteer that to the court if they knew that any of the participants in the trial were involved. The main person on video was Jill Daniels, who is Julie Albert's sister. So she's not involved. She hasn't been a witness here. She's not, she wasn't at 34 Fairview. It's nothing like that. The only ones that I believe were on camera that are specifically involved, we had Colin Albert, we had Chris Albert, and we had Ryan Nagel. And so if the jurors recognized any of them and were aware that they were involved in this altercation,
Mr. Lally, whenever you're ready,
they'd be expected to bring that up, and they'd have to evaluate what do they know, what did they see, and what sort of impression would that have had on their ability to stay fair and impartial.
Morning, sir.
Good morning.
Now, you in conjunction with, Dr. Rentschler, is that correct?
Dr. Rentschler, yes.
So you in conjunction with Dr.
keep your voice up, Mr. Lally.
Yes, sir. You in conjunction with Dr. Rentschler and Dr. Klein wrote a report in regard to your analysis, correct?
Correct.
And doctor, that report was issued on February 12th, 2024, is that correct?
Correct.
And in the first paragraph of that report, the last two sentences, you or whoever the author of that particular portion indicates, this analysis is based on information currently available to ARCA and is only to be issued in its entirety. However, ARCA reserves the right to supplement or revise this report if additional information becomes available. Is that correct?
Correct.
And that's pretty standard as far as your industry is concerned. You can only work with the information that you're provided. Is that correct?
Certainly.
Now, in this instance, you were provided 10 things, and then there were 4 additional things that either you or the other doctors had reviewed as far as literature or things of that nature. Is that fair to say?
Correct.
And the 10 things that you were talking about were reports, an initial crime scene report, medical examiner dispatch removal report. Is that correct?
Correct.
Photographs of the incident location. Is that correct?
Correct.
And how many sets of photographs of the incident location were you provided with?
In terms of the number of photographs?
The number of photographs, or were there different sets of photographs?
Yes.
And how many sets?
I don't recall off the top of my head. I know that there was a series that were taken during the daytime as well as ones taken what appeared to be in the early morning hours.
And you were also provided video from the early morning hours, is that correct?
From what I recall, I think it was daytime, but yes.
Photographs of the vehicle, photographs of recovered evidence, is that correct?
Correct.
CDR report from the 2021 Lexus LX570, correct?
Correct.
Autopsy report, autopsy photographs, is that correct?
Report.
Correct.
And then some other things those would be the 10 things that you were provided with, and then there were 4 other things that you reviewed or part of your team reviewed, is that correct?
Correct.
Now, in regard to there's a section in your report called Review of Materials, and it talks about photographs and glass fragments and plastic fragments and things of that nature, correct?
Correct.
You also talk about a black drinking straw that was recovered on scene, is that correct?
Correct.
However, there's no mention in the report about Mr. O'Keefe's shoe or Mr. O'Keefe's hat. Are you aware of those items as well?
Yes.
And are you aware that Mr. O'Keefe's shoe was actually found dug out from the snow, sort of flush with the curbing in front of the area where his body was found?
Yes.
Now, over the course of your work as a crash reconstructionist, and again, I don't mean this in any way, shape, or form, but I'm just curious. Typically, you're reconstructing or you're looking at someone else's reconstruction in relation to something that occurred in the past, correct?
Not always, no.
Well, my question is, sir, how many times have you actually been on like a live scene where the vehicles are still in place at final rest, whether a body is in place at final rest? Have you ever been to a scene where those sort of conditions existed?
Certainly. We have a rapid response team that essentially we've been on site on the day of or the week of the incident, yes.
Now, how often is that?
Not nearly as often as, like I said earlier, we primarily do litigation work. So again, by the time we're retained, obviously the scene has been, is no longer present.
Scene's been cleared, items have been removed as far as evidence or other things. That's mostly what you deal with, correct?
Sure.
And as far as the hat that we were talking about before, is you aware that that was recovered as well, same day as the drinking straw on February 3rd in the area where the body of Mr. O'Keefe was discovered?
In the area of the front yard, yes.
Now, you have some familiarity through working as a crash reconstructionist with pedestrian collisions, correct?
Correct.
Is it common or uncommon for in the course of a pedestrian collision, for a shoe or glasses or a hat or something to fall off of that pedestrian in the collision sequence near where the area of impact occurs?
Well, I think that depends on the interaction between the two. If we're talking, if it's more of a side swipe type interaction, if we're just talking about an arm, for instance, contacting the vehicle, no, I would not expect the shoe to come off. If it's something where the entire body is interacting with the vehicle, then yes, there's a greater likelihood that something like a shoe will come off, yes.
So that
I
is
love
consistent
it.
in general
Turn
terms
the
with
Commonwealth
pedestrian
theory
collision with
on
the shoe
them.
coming off, correct?
Again, based on the interaction between the two. I wouldn't say it's a blanket statement that, again, in all pedestrian interactions, you will have a shoe come off.
And that's not the question I was asking. So what I'm asking, is it generally consistent with pedestrian collisions, the shoe may come off during the collision sequence near the area of impact.
And he already said it depends.
Shoes can't come off in a pedestrian impact, yes.
Now, again, you were testifying earlier about the damage to the Lexus being isolated in the area of the taillight, correct?
Correct.
And that was based on the information that you were providing, correct?
Correct.
Now, with respect to any of the materials that you were provided, was there anything in the materials that you were provided that indicated that just the arm or an outstretched arm of Mr. O'Keefe interacted with the vehicle?
No.
And based on your review of any of the materials that you were provided, was there any information stating that Mr. O'Keefe had been struck in the back of the head by the taillight assembly of the Lexus?
No.
And based on any of the materials let me ask you, based on any of the materials that you provided, were you aware that Mr. O'Keefe is on video exiting from a bar minutes before crash occurs at approximately 12:11 a.m. holding a cocktail glass in his right hand?
I'm not aware of that video.
Consistent with him throwing the glass at the taillight and breaking it, but not
Now, other
consistent
than the
with
materials
getting
that we
hit in
just
the
went over,
arm.
as far as the 10 things that you were provided, you weren't provided anything else, is that correct?
That would be correct.
And so sort of the questions that you endeavored to answer, those were questions that you didn't know from any of the materials that you were provided, is that correct?
If I understand your question correctly, there was nothing in the material that indicated the questions we were to answer, if that's what your question was.
That is my question. So there was nothing in there, is that correct?
Correct.
If I may have a moment, Sean?
Yes.
You talked a bit about, you have some extensive background in human factors, correct?
Correct.
And as far as visibility, and in particular, have you ever conducted a visibility analysis?
Absolutely, hundreds of times.
And you talked a little bit about conspicuity, is that correct?
Yes.
And part of conspicuity, at least one of the factors, would be a reasonable expectation of, in particular, when you're talking about a pedestrian collision. Part of the conspicuity factors would include sort of a reasonable expectation that a pedestrian would be in the path of the vehicle. Is that fair to say?
I don't understand your question.
When you're talking about conspicuity or visibility analysis, in particular, you're talking about something called PRT, or perception reaction time, correct?
Well, that occurs after recognition. So first, a driver has to recognize that there's a pedestrian there before they can actually respond to it. So once they've recognized the pedestrian, then you start the perception response time where, again, the driver has identified what the hazard is. They're making a decision about what to do. They might be moving their foot from the accelerator pedal to the brake pedal. So again, kind of that's the action or the time frame in which the driver is undergoing action to potentially mitigate the collision.
And perception reaction time, that's a pretty commonly used industry sort of standard as far as crash reconstruction goes, correct?
Well, I would say that it's used in the field of accident reconstruction, but as I mentioned earlier in my testimony, there isn't a blanket number in terms of perception response time. As I mentioned, it's based upon the hazard that the driver is presented with. Again, if you've got a pedestrian crossing the roadway, that's going to be one particular perception response time based upon studies and naturalistic data versus a driver suddenly stopping in front of you, right? It's not the same perception response time in every scenario.
No, understood. And there's different variables that may affect that as far as someone's age, as far as the lighting that's available, other things. Is that correct?
Sure.
And one of those things might be the reasonable expectation of a pedestrian being present in the roadway as you're driving along, correct?
Expectancy can play a role, yes.
Expectancy, what we're talking about is sort of the disparity or the difference between driving along a country road where there's no houses for miles and miles versus an urban area where there's crosswalks every 15 feet, correct?
Sure.
Now, in that expectation of privacy, how high would that be if we're talking about a pedestrian that actually exited from the vehicle that then strikes?
I don't understand your question.
Let me ask you this. If the operator of the vehicle has a passenger who then exits the vehicle and goes towards the back, would there be a high reasonable expectation that the pedestrian would be located in that area?
I don't know if I would classify it as high.
What would you classify it as?
Possible.
I honestly don't know that I have a classification to it.
Now, you never looked at the defendant's vehicle in this case, correct?
Correct.
Are you aware that the defendant's vehicle is still in police custody and available for inspection?
I'm not aware of that.
Did you ever ask to look at the defendant's vehicle?
No.
Now, a typical pedestrian strike, for the most part, involves a pedestrian in front of a vehicle as it's coming down a street. Is that fair to say?
That can be one type of interaction, yes.
Is that more prominently seen as far as your field than a rear collision?
I would say that's fair.
And there are various types of sort of interactions that the pedestrian can have with the vehicle in order to cause and sort of sustain injuries. Is that fair to say?
What I would say is that there's certainly, in terms of how the pedestrian interacts with the vehicle, in terms of whether they're being wrapped onto the vehicle or projected forward, certainly there's different types of interactions, yes.
So there's like a wrap and forward projection type of collision sequence, is that correct?
Those are two common, yes.
There's also something called a fender vault, is that correct?
Correct.
And sort of how or where that pedestrian is positioned with relation to the vehicle is somehow or somewhat determinative of the injury sustained. Is that correct?
It can be, yes.
Obviously, you're going to see different injuries if someone fender vaults and goes over the top of the vehicle versus someone who is projected forward from the collision sequence with the front of the vehicle.
Just to clarify, again, in this matter, I was not assessing injuries. That was Dr. Rentschler. I don't have an opinion.
What I'm saying is based on your experience, though, that you understand that there's a difference in the injuries that you might expect based on the type of interaction that a pedestrian has with a vehicle.
Yes.
And then if someone is wrapping forward projected and then the vehicle overruns that person, there'd be a whole other host of injuries that you'd expect to see based on being overrun by the vehicle, correct?
There could be, yes.
Now, the testing that you did with respect, these are essentially experiments that you're doing, correct?
That's fair, yes.
And am I correct in saying that in scientific experiments or in the world of scientific experiments, there are certain things called variables that you're trying to account for? Is that correct?
I would say that's fair, yes.
And essentially what you're trying to do is control as many of those variables as you can in order to best replicate whatever the conditions were at the time that what you're testing to see actually occurred. Is that correct?
Correct.
Now, what, if anything, did you do to control variables in relation to
The
temperature?
weather.
So one of the things we did with all of the tail lamp assemblies that we tested is that we preconditioned them to approximately 28 degrees, that they'd reached a steady state temperature before we subjected them to the impact testing.
And where in your report does
She
it
made
say
him
that?
cold.
I don't believe that's explicitly stated.
Is it implicitly stated anywhere in your report?
Again, I'm telling you, that's part of what we did for the testing.
I understand that's what your testimony is, but you wrote a report, correct?
Right, and I don't know that I detailed every single part of the test. Again, we summarized it.
Understood. So what did you do to control any variable as far as wind?
Well, when you're talking about a projectile such as a glass, again, that's being projected at 37 miles per hour, again, there would be probably minimal effects in terms of the wind.
Even if there was a blizzard going on?
Again, what we're going after here is ultimately conducting a test such that the drinking glass arrived at the location of the taillight. So if you're trying to say that, okay, he threw it this way and the wind blew it towards the taillight, sure, that could be a possibility.
And sir, I'm not trying to say anything. I'm just asking, are you aware that there was a blizzard and that there were wind gusts up to 37 miles per hour during the time that this collision occurred, and that's not accounted for in your test?
Objection.
Were you aware of that, sir?
I'm aware that there was inclement weather at the time, yes.
Now, with respect to what type of glass did you use?
So we used a rocks drinking glass. So that's a glass that has a thicker base and a shallower sidewall.
And so what I'm asking, sir, was it a cocktail glass? Was it a pint glass? What kind of drinking glass?
He just told you it's a rocks
drinking glass.
And how tall is that rocks drinking glass that you used?
If I had to estimate, I think it was about 3 or 4 inches tall, probably.
And the thickness, did you measure that as far as the thickness of the bottom of the glass?
No.
Was the thickness of the bottom of the glass thicker or more thick or less thick than the top of the glass?
Are you talking about this in comparison to the sidewall of the glass?
Talking about in comparison to itself. So you have a glass, this rocks glass. Was the bottom
to
thicker
itself,
or the
he
top?
knows.
The sidewall would be taller, if you will, than the base.
And so when you're projecting this thing out of the device that you created, the whatever it was, are you facing sort of the top of the glass where you would be sipping out of, or the bottom of the glass at the tail?
So in the testing, the interaction between the taillight and the glasses was primarily between the base and the taillight.
Now, with reference to, I asked you a little bit about the video, and you weren't aware of Mr. O'Keefe exiting from the waterfall bar at 12:11 in the morning, about 15, 20 minutes before he struck by a vehicle. You're not aware of that?
I'm not aware of that.
Now, with reference to that particular establishment, was there anything stopping you or the other doctors that you were working with from going to that establishment, finding out what kind of glasses they had, getting an actual
Yes,
cocktail
he said
glass
no
from
outside
that
investigation.
I had
Why
no
didn't
idea
your
that video
police
existed.
do that?
Did you even know
Why
that
didn't
Mr.
your
O'Keefe was
police
at a
do
bar
that?
before he was struck by the vehicle?
I believe that in one of the incident reports we reviewed that there was, I think, a narrative about that they had been at a bar drinking, yes.
How is it that
I mean, thank you for
determined
reminding
where
us
on the
that your
taillight
cops could have done that.
assembly to aim?
So we looked at the fracture pattern, and what it appeared to be that it was emanating from basically where the clear portion meets the red cover. We kind of saw that the fracture pattern emanated from that. So that's where we targeted it.
Now, when you did this testing as far as the sort of breakage or the pieces that came off the taillight, is it fair to say that they were of sort of different shapes and sizes, the broken pieces?
Sure.
Consistent with the broken pieces that were found on the scene near Mr. O'Keefe's body?
Yes, I would say that's fair.
Now, I know you may not be the person for this, but just as far as your reviewed some of the autopsy report, medical findings in regard to Mr. O'Keefe, correct?
Correct.
And the injuries to Mr. O'Keefe were primarily on the right side of his body, correct?
Correct.
So there were injuries to his right arm and forearm, elbow area, correct?
Correct.
There was bruising to his right hand. Do you recall that?
Yes.
There was an abrasion to the outside or the posterior of his right leg near his knee. Do you recall that?
I don't know that I recall that off the top of my head.
And do you recall sort of the skull fracture or the laceration that immediately outside of the skull fracture was on sort of the right back of his head?
Yes.
Now,
And
from
so
the
what?
reports that you reviewed, were you aware that when Mr. O'Keefe's body was discovered by the defendant and two of Mr. O'Keefe's friends, that the defendant was the only one who could see him in the conditions?
Objection.
Sustained.
As far as the lighting was concerned in that area where Mr. O'Keefe's body was found, are you aware there was no overhead street ambient lighting or anything like that?
Objection.
I'll allow that.
I'm not aware of that.
And you didn't do any visibility analysis or anything in relation to this case, correct?
That wasn't a part of my scope in this case.
Well, as far as part of your scope, did you define that you indicated earlier that there were questions that you didn't find in the materials that you actually conducted experiments to prove or disprove, correct?
Well, again, the entity that retained us in this asked us to evaluate whether or not the damage to the vehicle and the injuries to Mr. O'Keefe were consistent with the interaction or in interaction between the two.
So you were at least somewhat restricted in the scope of what you could do based on the parameters given to you by the agency that hired you. Is that fair to say?
Sure.
Yes, they didn't have a blank check.
Now, as far as any statements by the defendant to investigating troopers either that afternoon or that morning when Mr. O'Keefe's body was discovered, were you familiar with any of those?
Objection.
I'll allow that.
I'm not familiar with.
Sure.
It has crossed my mind that with this, entity other than the prosecution or the defense, that in combination with his discussion that they do a lot of civil litigation, the jury could be over there thinking to themselves that it's the insurance company, that the insurance company is who hired these, John's or Karen's insurance company, not them personally. Possible implication they could be drawing from this. But a lot of these questions about things like the ambient lighting, the wind at 37 mile an hour gusts, that's not in evidence. That's part of the problem with that
You are
question.
unmuted.
It's assuming facts he hasn't proven. He never established wind gusts up to 37 miles an hour.
So, Doctor, with regard to the defendant's statements at any point, did you review materials or were you made aware that the defendant said to multiple people on scene, I hit him, I hit him, I hit him, I hit him?
I'm not aware of that.
May I have a moment, Your Honor?
Yes.
Now, within the reports that you and the other doctors submitted, there's an indication that if either Mr. O'Keefe's arm or head had interacted with the taillight, there'd be some expectation that either blood or DNA would be contained on that taillight. Is that correct?
I believe, yes, that was stated in the report.
And at any point were you made aware that Mr. O'Keefe's DNA actually was recovered from that taillight assembly from the defendant's vehicle?
No, I was not.
Now, as far as forensic reports, what, if anything, were you provided in reference to that, other than the initial crime scene report?
Are you talking about specific to the scene or forensic reports to the body?
Forensic reports specific to the evidence that was recovered from the scene and from the defendant's vehicle.
Only what would be listed in the report.
Now, you indicated one of the materials that you were provided and you reviewed was the EDR, event data recorded data?
The crash data retrieval report, yes.
Okay. Now, were you shown anything as far as a crash reconstruction report from a trooper from the state police?
No.
And the EDR data that you observed, did that contain any sort of usable data?
There was no events recovered on the black box.
And with respect to there being no events recovered on the EDR or the black box, in a pedestrian collision, is that unusual?
It does not.
And why not?
Well, because you're talking about, excuse me, a very large weight difference between the vehicle and the pedestrian. So ultimately, what the vehicle is constantly monitoring is acceleration, which gets back to a term called delta V. So when the vehicle doesn't experience a big delta V, typically the threshold for a non-deployment event where you're not firing airbags or any safety mechanisms, but the vehicle wakes up and says, hey, there was something that I potentially hit, and it's usually at a threshold of about 5 miles per hour. So again, given the weight difference, we usually don't see delta Vs that high with pedestrians.
And is that in some respects because what the EDR and what the safety restraint systems are designed to protect is the occupants of the vehicle, correct?
That's fair, yes.
I mean, there are more innovations as far as vehicles that are more modern or released earlier that have certain pedestrian or protections for other vehicles, but primarily what they're focused on is the occupants of the vehicle, correct?
Correct.
Now, at any point in time, were you shown any text stream data, Toyota text stream data from the defendant's vehicle?
No.
So you weren't shown any data indicating that the defendant's vehicle was being operated in reverse.
The objection sustained. Next question.
So with regard to the defendant's statements, were you also not told that the defendant told several people that she had just gotten into a fight with Mr. O'Keefe right before she dropped him off
Objection.
at 34 Fairview Road?
So that's sustained.
Doesn't change the mechanics, Mr. Lally. It doesn't matter if she thought she
Now,
hit
with
him or if
regard
they got
to
in a fight.
pedestrian collisions,
Or even if she
you're
wanted to
familiar with
kill
sort
him.
of the physics term.
Doesn't
Really
change the
doctor, as far as, like,
mechanics.
center of mass.
Yes.
And what kind of role does the center of mass for a pedestrian play in relation to the center of mass of a vehicle as far as how the two interact?
Well, it depends, again, on the vehicle structure. And again, when you're talking about where's the hood height, the bumper height, and the CG or the center of gravity of the pedestrian, that, again, will kind of dictate how they interact with the between the vehicle and the pedestrian.
Now, typically, a typical pedestrian collision, again, that we were speaking about before, is in relation to a pedestrian struck by the front of a vehicle, correct?
Correct.
And so in a typical pedestrian collision, that involves more of an assumption of the velocity of the striking vehicle than you would see occur in sort of a side swipe. Is that correct?
I'm sorry, can you repeat the question?
Sure. In a typical pedestrian collision, that would involve more of an assumption of the velocity of the striking vehicle by the pedestrian than you would see in a typical side swipe collision. Is that correct?
If I understand your question correctly, yes. If the vehicle is striking the center of gravity of a pedestrian as opposed to just, for instance, a limb, yes, the center of gravity or the body will be accelerated up to that speed.
Now, with respect to the defendant's vehicle, again, you never actually looked at the defendant's vehicle, is that correct?
It wasn't necessary.
And did you look at the actual taillight housing from the defendant's vehicle?
I had sufficient photographs of the taillight.
Did you ever look at the actual physical broken pieces of the taillight from the defendant's vehicle?
Again, I had sufficient photographs that documented the fragments and pieced them together.
And you're aware, at least, that the fragments that were recovered on scene were then sort of put back together and overlaid over the taillight housing that was taken from the defendant's vehicle?
Yes.
And through any of the pictures of the photos that you observed, did you ever see a piece of metal protruding underneath the broken and shattered plastic pieces from the taillight?
I believe it was a plastic chrome piece.
And when you were doing the testing as far as shooting the glass, the drinking glass at the taillight assembly, that taillight assembly was sort of held there by vice grips or something like that. Is that correct? It wasn't actually physically attached to a vehicle, the one that you were shooting at?
That's correct.
Now, as far as that, you're familiar with, there was a piece of a broken drinking glass that was recovered from the same area of where Mr. O'Keefe was found. Is that correct?
Amongst the fragments of the taillight, yes.
And are you familiar with Mr. O'Keefe's DNA being present on those pieces of the exterior of a broken drinking glass located near his body?
I don't believe so.
Now, as
Oh,
far
wait,
as
that
Mr.
matters.
O'Keefe's clothing, his fingernails, are you aware that there was DNA of Mr. O'Keefe and no one else recovered from both his fingernails and from a variety of areas of his clothing?
Objections. So beyond the
Sustained.
scope.
Now, from the crime scene reports that you reviewed, are you aware that there was human hair that was located on the right rear
You
quarter
already
panel
asked
near the
this.
vent that you were
Objection.
talking about?
Objection.
I'll allow that.
Yes.
It's
Are
asked
you
and
familiar
answered.
or are you
Bev.
aware that subsequent mitochondrial DNA testing found that the mitochondrial DNA profile for that hair was consistent to a probability of 99.895% with the mitochondrial DNA profile of Mr. O'Keefe?
I'm not aware of that.
I mean, just keep hammering that number.
Now, were you
Lally,
also aware that the
'cause
broken
it's
drinking glass with
300,000
Mr.
people
O'Keefe's DNA on it was
that would
found
match
to be
it.
consistent with the broken drinking glass pieces that were found in the street?
Objection.
I'll allow that.
Can you repeat the question?
Sure. Were you aware that the pieces from the exterior of the broken drinking glass found near Mr. O'Keefe's body with his DNA on it were then found to be consistent with pieces of broken drinking glass that were located in the street of 34 Fairview Road?
Yes.
And not the bumper sprinkles. Did you know the
Were you
bumper
also aware that
sprinkles were
pieces of
not
glass that
consistent?
you're talking about from the defendant's bumper were found to be consistent with pieces of glass recovered from the street in front of 34 Fairview Road?
Yes.
Were you aware that there were microscopic pieces of red and clear plastic, about a 16th of an inch by a 16th of an inch, that were recovered from Mr. O'Keefe's clothing that were then found to be consistent with the tailor?
No, I don't believe so.
Now, as far as, again, you weren't provided with any sort of reconstruction report from a Trooper Paul from the state police?
No, I was not.
You're not aware that he took measurements from the ground to where certain items were on the vehicle?
Objection.
The objection sustained. He didn't see the report. Sure.
He just keeps doing it. Lally keeps doing it. He knows what the limitations are. And he keeps doing it anyway. It's such bad faith. I don't see any of this doing damage. I really don't.
You are unmuted.
Yes.
He can't ask those kinds of questions. Does he have anything left?
My apologies, Your Honor. Just one moment.
Yes.
Now, Doctor, in the course of your analysis or review of materials here, were you ever provided with a video of the defendant backing out of a garage and making contact with Mr. O'Keefe's vehicle in his driveway at about 5:07 in the morning on January 29th?
No.
No,
Now, as
but
far
thanks
as
for
from
reminding us
your
that
review and your
happened.
testing and everything that you did in this case, if a collision occurred at a lower speed, say 1, 2, anywhere from 0 to 5 miles an hour, would that create the damage to the tail light that you observed in this particular case?
At that speed, no.
You said 37 miles an hour was what it took for the glass to create that kind of damage.
Then we can do our 2 o'clock.
Bev's over there whispering about her daily schedule.
So there were about 10 items that you were provided that you reviewed, is that correct?
Correct.
And a number of different items that I just asked you about that you weren't provided with or you weren't aware of, correct?
Correct.
And again, in your report, in the very first paragraph, you indicate, however, ARCA reserves the right to supplement or revise this report if additional information becomes available, correct?
Correct.
I have nothing further on.
All right, Mr. Jackson.
Thank you, Your Honor. Very briefly, Dr. Wolfe, you were asked on cross-examination a couple of questions about a hair, DNA on the outside of the taillight lens, the taillight housing, and glass material. You recall that?
Yes.
Does any of that change your opinion about your opinions and conclusions in this case?
Objection.
I'll allow that.
Absolutely not.
Absolutely not.
What is your conclusion as to whether or not the damage to the vehicle and the injuries to the human being are consistent or inconsistent with the vehicle interaction?
Objection.
Sustained. All right, Dr. Wolfe, you are all set, sir.
Thank you.
You are all set, sir. 45 minutes to lunch. We're going to get well into Dr. Rentschler. We're getting done today, guys. It's going to happen. It's going to happen. That's why Bev's over there chit-chatting about her schedule with the clerk and getting caught on the mic about it. They have a 2 o'clock that they'll do. Work it in. She's already got it planned.
Yes.
Your Honor, we would ask Dr. Andrew Rentschler to join us, please.
Okay.
Oops. We're not on redirect.
While he's coming in, just very quickly about scheduling.
You are muted.
Yes. We know that's what you were working out. Well, this one's Dr. Dude. If we just finished with Dr. Dreamboat, now we're gonna get Dr. Dude. I want to see him up there on the stand with his White Russian.
You are unmuted.
Can we go a little past 1 to keep going with this, if that's okay? Everybody's nodding. All right, thank you.
So we're gonna go a little bit past 1 today. Why do they think they're gonna get done with direct and cross?
And stand and face the clerk.
Could be.
You solemnly swear the evidence given to the court and jury in the case now hearing shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
May I inquire?
Yes.
Doctor, could you please state your first and last name, spelling your last name for the record, please?
Certainly. Andrew Rentschler, Rentschler.
And what do you do for a
Got the
living?
T.
I'm a biomechanical engineer and accident reconstructionist.
And who do you work for?
I work for a company called ARCA LLC.
How long have you been in that position as working for ARCA, first of all?
I've been with ARCA for about 16 and a half years now.
You indicated that you're the director of biomechanics and human factors, is that right?
I am. I'm a vice president and the director of biomechanics for the Midwest Division.
Can you tell us what education, training, and background qualifies you to perform your duties as the director for biomechanics and human factors?
Sure. Well, I've got my BS in mechanical engineering with a minor in biomedical engineering from Carnegie Mellon University in 1995. I then went on to get my master's in bioengineering and biomechanical engineering from the University of Pittsburgh in 2002. And then I went to get my doctorate or my PhD in bioengineering and biomechanics from the University of Pittsburgh in 2004.
Doctor, do you specialize in research and analysis to evaluate specifically the study of the relationships between crash injuries and crash forces?
I do, yes, sir.
And when I say
got a
crash
haircut.
injuries, we're talking about to human beings.
That's right. Injuries to human beings, whether it be, in a crash, motor vehicle accident, slip and fall, industrial, any type of setting where there's an injury to the human body, I evaluate basically that event and the mechanisms responsible for producing those types of injuries.
Doctor, does it also include the study of and understanding of human kinematics?
It does, yes.
As well as human tolerances?
Yes, sir.
We all know what tolerances mean. What does kinematics mean?
So kinematics is really just the motion of the human body, and it's the study of the human body, how the body moves under different circumstances, whether you're in a car that's struck from behind, what direction will your body move, slip and fall, how will your body rotate and move. It's really looking at the motion and the response of the body.
Are you certified by any professional associations?
I have a PhD. There's no professional licensure for biomechanical engineering. PhD is the highest basically certification you can get. And I'm also a member of SAE, Society of Automotive Engineers, as well as the American Society for Mechanical Engineers.
Have you received additional training and education in further beyond your PhD and the associations that we just talked about?
I have, yes, sir.
Can you describe, without going through all the detail, describe the kind of continuing education that you engage in?
Well, I attend seminars and professional classes with respect to biomechanics as well as action reconstruction, but looking at new technology and research with respect to injuries. For instance, motor vehicle accidents, if there's new safety measures such as airbags, seatbelt pretensioners, auto detection devices on vehicles. So really kind of staying up to date with the current research and literature that's out there.
So your specialty, your subfield, if you will, in terms of your engineering degree and education is literally in accident reconstruction and the effect that accidents and incidents can have on the human body. Is that right?
It is, yes. And biomechanics is really, it's looking at injury to the human body. So, we use traditional engineering principles and apply it to the body because an injury is just an engineering problem. Instead of looking at a piece of steel that if you know the dimensions and size and you apply a force, it'll bend and break. We look at the human body. How much force does it take and how does the force have to be applied to get a humerus fracture or an intervertebral disc injury or any type of injury? There's specific forces and mechanisms you need to produce those injuries. And that's what I do as a biomechanical engineer.
Is there a difference between a biomechanical engineer and a doctor?
There is, yes.
In terms of injuries?
Yes.
Tell us about that.
So we really approach injuries from two different directions. Someone has an injury, you go to the doctor, you go to the hospital, the medical doctor will diagnose that injury, determine the best way to treat it, and determine what the prognosis is. As a biomechanical engineer, I look at that injury from a different direction. Here's the injury. Well, how did that injury occur? What type of loading did you need to actually produce that injury? How much force was required? What happened to your body to actually cause that injury to occur? So we approach it really kind of from two different areas. And certainly the doctors diagnose the injuries and determine what they are. And then the biomechanical engineer will come in and we'll look at that injury. And not only how's it produced, but ultimately our hope is to mitigate and prevent injuries from occurring, whether in motor vehicle accidents, sports settings, industrial settings, anywhere there's an interaction with the body and the environment, we want to try and make it safer for individuals.
So you're not diagnosing an injury as much as you are trying to figure out the mechanics and the forces behind the injury. Is that right?
That's right. I'm not a medical doctor. I wouldn't diagnose an injury, but given an injury, I understand the mechanics of how that injury is produced and what you need to actually cause that injury to happen.
Are you also published in the field of biomechanics and or engineering?
I am, yes, sir.
Can you describe that?
When I did my graduate work at the University of Pittsburgh, I worked at a place called the Human Engineering Research Lab. and it was associated with the VA in Pittsburgh as well as the University of Pittsburgh. And so we looked at people with disabilities. Well, one of the big things that we did, or one of the major points, was people in wheelchairs. So if you have to propel a manual wheelchair, you put a lot of stress and force on the arm, the shoulder, the elbow, the hands, carpal tunnel. So we look at the injuries that are produced during those types of events. How can we reduce the force acting on the body for someone like that? So it's looking at, again, how the body responds, how we can set up a chair differently to actually reduce the amount of force someone might experience doing that type of an activity.
Have you qualified as an expert in the past in the area of biomechanical engineering and human factors?
I have, yes.
In furtherance of, let me ask it this way, were you asked to engage in an analysis, ARCA, to be engaged in an analysis of the incident that is currently before the court?
I was, yes, sir.
Did you produce, or did your team produce a report about your opinions and conclusions, including the testing and the methodology that went behind those opinions and conclusions?
We did, yes.
You were not hired by the defense in this case, correct?
No, we were not.
You were not hired by the Commonwealth in this case.
That's correct, we were not.
When you started your analysis, you didn't know who we were. You did not know who the Commonwealth was.
That's correct.
You'd never heard of the Karen Reed case.
I had not, no, sir.
You were contacted by my office after you provided your report, correct?
That is correct, yes.
Were you ever contacted by the Commonwealth?
Not that I'm aware of, no, sir.
And you and I have never discussed the substance of your testimony, correct?
That's correct, we have not.
Would you consider that your analyses, your conclusions and opinions in this case are completely independent of any party in this room?
Objection.
Sustained.
You've not been paid by the defense, is that right?
I have not, no, sir.
And you do not answer to us in any way?
I do not, that's correct.
You indicated that you and your team were asked to undertake a review of the circumstances. What exactly did you review in coming to your opinions and conclusions and performing the tests that you performed?
Well, we looked at, there was police reports with respect to the incident, medical records for Mr. O'Keefe, as well as the autopsy report, photographs of the evidence in this case involving the Lexus, the tail light, the incident scene where the evidence was found, as well as some other documentation.
And you also worked with Dr. Wolfe, who just left the courtroom, correct?
I did, yes.
Did you two have sort of a distinct role in, although working as a team, a distinct role in making determinations and conclusions about the incident?
That we did. There was a distinction. Certainly some of our work overlap, but there was a distinction with what each of us actually did and performed with respect to this case.
Following your review and your investigation and analysis, did you make any determination as to whether any of the injuries suffered by Mr. O'Keefe in this case were consistent with producing the damage that was seen on the SUV?
I did, yes, sir.
And what did you base your opinion on?
My opinion was based on certainly the medical records, the description of what the injuries were, the damage that we have to the Lexus, primarily the right rear tail light cover, as well as we performed testing to evaluate the strength of that tail light cover and look at the damage associated with different types of impacts. And also to look at the overall evidence of where everything was found, where Mr. O'Keefe was found, what the injuries were, how they may or may not have occurred based on the damage we have to the vehicle.
So did you look specifically to find whether or not you could determine the forces required for Mr. O'Keefe to suffer the injuries that you saw in the records, medical records, et cetera?
I did, yes. I determined in my analysis whether there was sufficient force with that damaged taillight and interaction with that taillight to produce any of the injuries that were listed or diagnosed in the autopsy report and the medical records.
What, generally speaking, what injuries would you expect to see in a vehicle-pedestrian interaction at, say, 24 miles per hour?
Objection.
I'll allow that, just generally.
Good.
Doctor, if you would, please.
Yes, Your Honor. So 24 miles an hour, once you get up to that speed, you start to see fractures. You see significant ligament and tendon damage, I mean, usually about 15 mile an hour impact is where you start to see damage to, for instance, the leg and the knee. At that speed, you're going to produce, if you impact the vehicle, you're going to produce upwards of 1,000 pounds of force on the body, depending on what part of your body impacts the vehicle. So certainly at 25 miles an hour, you start to see significant injuries occur.
Is that true for any part of the body that is struck, whether it's center mass or an extremity? 1,000 pounds of force because of the speed of the vehicle?
Well, force is equal, Newton's second law of force is equal to mass times acceleration. So the acceleration is going to be the same. It depends on the mass of whatever body part's being hit. So from the testing that we did at 15 miles an hour, we used a head form, which weighs about 11 pounds. And that produced almost 1,000 pounds of force, a little under that for the head. So anything that weighs 11 pounds is going to produce almost 1,000 pounds of force. The heavier the object, if you get hit center mass, that's going to be even greater force because that's more mass than just 11 pounds. So the acceleration is the same for each body part. It just depends on the weight of the body part and how heavy it is to determine the force that's actually exerted on the body.
Did you review, in furtherance of your conclusions and opinions, did you review records that indicated injuries to both a head as well as an arm, the right extremity, right arm?
I did, yes, sir.
Taking those one at a time, is the injury to the head that you saw consistent with having been struck by a vehicle at 24 miles per hour?
It is not, no, sir.
Can you explain why that is?
There's a couple of reasons. First of all, and the main reason is that to get the injury, it was a fracture at the occipital region of the head, which is basically on the back bottom part of the head. So in order to have that part of the head contacted by the tail light, you would somehow have to have a configuration or be standing in a manner that the rest of your body doesn't get hit because there's no other significant injuries to the body. If there's enough force to cause a skull fracture, then there's going to be certainly enough force to cause injury to the rest of the body. So first of all, you have to determine how could you configure somebody could actually be standing to have only the head impacted, the back of the head. And even if that was the case, if somebody positioned themselves in such a manner to have that occur, you're still going to see other injuries related to that. For instance, with the cervical spine, over 1,000 pounds of force acting on the head, you're going to get significant cervical injuries, fractures, disc injuries, tendon and ligament injuries. So the fact that we only have that head injury and only damage to the occipital portion of the skull is inconsistent in this case with being struck by that tail light. And then there's also the evidence that we saw when we did the testing. At 15 miles an hour, where we dropped the head form, so that would be akin or like a vehicle backing up at 15 miles an hour hitting the head. We had more damage to the tail light in that test than what we saw with the subject tail light cover. So if you're going 24 or 25 miles an hour, even faster, you're going to see even greater damage, greater fracturing of that rear tail light, and we just don't have that in this case. So both the physical evidence as well as looking at the biomechanical aspects of it are inconsistent with that head injury occurring due to impact with the rear of the Lexus.
Shifting to the arm, are the same forces at play if instead of the head making contact with the tail light, it's an outstretched arm, for instance, at the elbow area of a human being, the person 73 inches tall, weighing 215 pounds?
Objection.
The objection sustained. Ask it differently.
Sure. Shifting to the arm, are the same forces at play?
Were you aware
if
of
instead
his
making
dimensions?
contact with a head, you make contact with an arm, an outstretched arm.
They are. You know, I just explained the force is mass times acceleration. So if the arm weighs the same as the head, you're still going to get that same force, almost 1,000 pounds.
Does the arm weigh the same as the head?
It does, actually, almost identical, because your arm, just one of your arms, including the hand, forearm, and upper arm, is about 5% of your total body weight. So for someone who weighs 216 pounds, that comes out to about 10.8 pounds. So your arm, basically your whole arm, is about the same, weighs the same as your head.
So is your analysis the same then if the arm, close to an 11-pound arm, made contact with the taillight traveling 24 miles an hour, at 15 miles an hour, would you expect even more damage to the taillight at a higher speed?
Objection.
I'll allow it. Watch the leading though.
Sure.
Yes, you would. If it's higher than 15 miles an hour and you have an arm actually striking that taillight, you're going to get even more significant fracturing, more damage to that taillight at a higher speed than what we saw.
So was the taillight damage consistent or inconsistent with striking an arm?
It was, our findings was it's inconsistent for a number of reasons, but it's inconsistent with striking the arm. Yes, sir.
Okay. I want to
What other
shift back
reasons?
to the head injury that you saw. Was the head injury that you saw consistent with falling backward from a standing position onto a rigid surface?
That's certainly one of the possible scenarios. That would create the injury mechanism. You fall backwards, strike your head on concrete. That can produce thousands of pounds of force on the head. And so that's certainly a scenario where you could produce that damage if someone was standing, they fell backwards and struck their head on the roadway or on the curb or a hard surface.
So I was going to ask, I think you may have just answered my question. Those kinds of force multipliers require a hard or rigid surface or not?
They do, yes, sir.
So grass and dirt would not produce the same sort of force?
Grass and dirt, no, that would certainly not produce the same amount of force as hitting your head on concrete.
And if it was grass and dirt with a little bit of snow on the top of it, what effect is that?
That's going to dampen and lessen the force even more so.
What injuries, I want to shift back to the arm. I know I'm going back and forth, but bear with me. Talking about the arm, if presuming a strike at, say, 24 miles an hour on just the arm, what kind of damage would you expect to see on the arm, irrespective of the vehicle?
You can see significant damage on the arm, especially if it hits at that taillight. Enough force to actually cause fracture of that taillight, that force is going to be concentrated at an initial point. And you're going to see at that point, you're going to see probably the most damage to the arm and to the skin there. So remember, at 15 miles an hour, that's about almost 1,000 pounds. So 24, 25, it's even greater. So that amount of force on the arm, certainly you're going to see extensive subcutaneous lacerations, bruising, contusions. You're going to see most likely fracture of the arm as well. You're going to see significant damage. Just imagine having your arm out and being struck by a car at 25 miles an hour. There's going to be significant damage, more so compared to simply the abrasions that were diagnosed and documented on the arm in this case.
You did look at multiple photographs of the arm in this case, of the John O'Keefe's arm in this case, correct?
I did, yes, sir.
All right. Were the injuries that you saw on John O'Keefe's right arm consistent with having been struck by a vehicle in the manner that you just described?
Objection.
That's sustained, Mr. Jackson.
Why not?
You reviewed injuries specific to John O'Keefe, correct?
I did, yes.
Taking that as a hypothetical, would the injuries that you saw, generally speaking, hypothetically be consistent or inconsistent with having been struck by a car at 24 miles an hour?
Objection.
Sustained.
A reapproach?
Yes.
There's nothing wrong with these questions. Like he doesn't have to state it as a hypothetical. He evaluated this precise case, these actual injuries. And if he's an expert to be able to opine about injury causation, then yes, he gets to opine about the causation of these injuries. Don't know what on earth is wrong with these questions. Is this where she's getting into it needs to be a medical doctor? No, the medical doctor says she can't opine about force. It's just that everything is possible to the medical examiner. She doesn't have the physics training to be able to evaluate if this mechanism is possible or more likely or unlikely relative to the other potential mechanisms. Are we at cumulative? Because we've already heard multiple people say it's a dog bite and not consistent with getting hit by the taillight. I mean, Dr. Wolfe got to say? These linear patterned injuries without any bruising and so forth is not consistent with striking the taillight.
You are unmuted.
Yes.
Thank you.
Foundation?
If you were to presume, for purposes of my question, that an arm was struck by a vehicle taillight traveling at 24 miles an hour or thereabouts, would you expect to see patterned abrasions with no bruising?
Objection.
Or just what would he expect to see?
What would you expect to see?
So again, I would expect to see significant trauma to the skin, to the bone, to the tendons. I wouldn't expect to see just abrasions, pattern abrasions. I mean, abrasion by very definition means that it's trauma to the skin, which is created through rubbing or grinding or friction. So it's basically something rubbing against the skin that basically wears away that top layer of skin. It's not blunt force trauma. If you have blunt force trauma, that produces a contusion or a bruising. It's not a laceration type injury where you have a cutting injury that actually produces a cut or a significant laceration. It's really just rubbing along the skin. So that would be inconsistent. If you have an arm that's actually struck at 25 miles an hour, you're going to have significantly greater damage, especially if there's a taillight that shatters. So you have the taillight coming in, it's hitting the arm, and it's moving forward into the arm. So if that actually caused fracturing of the taillight, then parts of that taillight are going to be pushed into the arm and likely embedded into the arm as the vehicle continues forward and pushes the arm out of the way. I didn't see any of that, basically just superficial abrasions, which all appear to have a similar amount of force. There's not a difference. That's the other thing. If you had a taillight shatter and explode on an arm, you would have some areas where you would have very deep contusions or lacerations, others lighter areas. But when you look at the abrasions that were noted in this case, they all appear to be of the same force, generally the same direction and the same severity, which would be inconsistent, in my opinion, with being struck at 25 miles an hour.
Generally speaking, do you look for consistency in size of an object striking a body and the injury that the body suffers from being struck by the object?
Absolutely. Yeah. I mean, size is a big part of it, certainly. Yes.
So did you do any measurements of the size of the taillight, the width of the taillight that was shattered?
Yes.
And what was that width, if you can recall?
I think the width we looked at was maybe 6 inches or so.
In review of your, in coming to your opinions and conclusions, did you look at the arm of John O'Keefe just sort of laid out, straight out?
I did, yes, sir.
Did you see where the injury started and stopped, or began and ended, however you want to put it, in terms of size?
Yes, I mean, it started from the upper arm and then extended down into the forearm, which was greater than 12 inches of length, where you see those injuries and those abrasions occur.
Did you come to any conclusions or opinions concerning the size differential between the taillight and the injuries that you see?
Objection.
Sustained.
Generally speaking, would you expect if there was an injuring event that the size of the injury would be consistent with the thing that produced the injury?
Yes, generally speaking, you would certainly expect that. And again, you would normally and usually be able to see an initial point of contact, because that's where the most force is going to occur, where it causes that taillight to break. So you would have an area of severe damage, and then it would extend out likely to the edges of where it would contact the rest of the taillight.
From a biomechanics and or a physics standpoint, an engineering standpoint, is it reasonable if someone is standing with their arm extended to be hit by a moving vehicle at, say, 25 miles an hour, and the body, the center mass of the body, to be projected?
Objection.
Ask it differently.
Is it consistent, in your view, with engineering principles and physics principles that you know, if an arm is hit, extended, not the body, just the arm is struck, for the body then to be projected?
Objection.
I'll allow that.
It's not, no. So if we have contact, your arm's down, we have contact to the arm. I mean, first of all, it's a ball and socket joint, so the arm can move independently of the rest of the body. So with enough force, even if you're contracting your arm and trying to hold it out as tight as possible, it's going to overcome that muscular contraction and basically just move the arm. But secondly, it all depends on your center of mass. The center of mass is kind of the equilibrium point of your body of where your weight's distributed. And for most normal people, the center of mass occurs at your umbilicus or your belly button. Mm-hmm. So wherever your belly button goes, that's where your body's going to move. They teach this to football players, right? If you're a defensive back and a running back comes around the corner and it's you against him, they tell them or they teach them to watch the waist and watch the belly button. It doesn't matter what your head or your arms do or what their feet do. Wherever their belly button goes, that's where they're going to go. So that's what you want to tackle.
You watch the center.
So even if you had your arm straight out, again, we said it would move because of the joint. But let's assume you had a metal pole sticking out of your arm, out of your body instead of your arm, and that metal pole gets hit. What's going to happen to your body?
It's going to rotate.
It's just going to spin around, right? Because it's producing a moment arm, which produces a torque on the body. So your body's going to basically spin. In order to get that body, or the complete body, over, for instance, 10, 20, 30 feet into the yard, you need a force acting at the center of mass. You need an external force pushing the body that way. And that's not going to happen if you just hit the arm. It's not enough force. It's not the right mechanism to actually cause the body to somehow move that far over.
Assuming that a body was struck with enough force at center mass to project that body.
What kind of injuries?
What injuries would you expect to be produced on that body?
Objection.
Sustained.
There's nothing wrong with that.
A body that was projected a distance, what injuries from a car, what injuries would you expect to see on the body?
Objection.
I'm going to see you at sidebar the last time on this.
This is just making no sense. A distance. She did the same thing with Dr. Wolfe. Like, it's gonna depend, isn't it? If a body gets projected 5 feet, you would expect to see different injuries than if the body gets projected 30 feet. So they had to restate these questions in ways that make them basically nonsensical. The last time on this. What is that? What is that comment for the jury? When Lally's over here
you are
putting
unmuted.
in facts, not in evidence.
May I, Your Honor?
Yes.
Doctor, do you have my question in mind? You need me to repeat it?
Maybe repeat it, yeah.
Easy for you to say. Assuming that a body was struck center mass with enough force from a vehicle traveling at whatever speed to project the body off the ground, would you expect to find injuries on that body?
You would, and you would actually see that there's specific injuries because let's say you're standing forward and you get hit on the right side with a vehicle. You're going to get injuries and damage to the right side of the vehicle as that vehicle impacts you. It depends on the profile of the vehicle, how high the hood comes up, whether you're going to wrap up onto the hood, or if it's a van or the back of an SUV, it will project or push your entire body to the left. So you're going to get initial contact and injuries to the right side of your body. And then if it propels you into the air, you're going to get airborne and then you're going to contact the ground, usually with the left side of your body. So then we're going to see a correlation of injuries to the left side of your body as it slams down onto the ground as well.
Yep.
And at those speeds, normally you would also see more abrasions, greater abrasions or road rash along the entire part of the body as your body then would slide until it came to the point of rest.
And you did not see that in this case?
Objection.
Thank you. May I have a moment, Your Honor?
Yes.
We already know they didn't. I don't know what these limitations are. This is nuts.
Thank you, Your Honor. I have nothing further to say.
Hey, Mr. Lally.
Good afternoon, sir.
Good afternoon.
Now,
Did you consider that he wasn't flying
you,
through
in
the air and was
conjunction,
just
with,
moving his
the other
feet in a
doctors on your
roadrunner
team,
motion
that conducted
until he
the
came to
analysis and
rest?
testing in this case, you wrote a report, is that right?
We did, yes, sir.
And that report, was issued on February 12th, 2024, is that correct?
I believe that's correct, yes.
And within the first paragraph of that report, the last two sentences state, this analysis is based on information currently available to ARCA and is only to be only to be issued in its entirety. However, ARCA reserves the right to supplement or revise this report if additional information becomes available. Is that correct?
I believe that's correct, yes, sir.
Now, the
Now he's going to do
information
the
that
same
you
stuff
received
that he
and
did
that's,
with the last
you
guy
reviewed,
that was
either individually
objectionable.
or as a team, that included some state police reports. Is that correct?
Yes, sir.
Some Canton Police Department reports, correct?
Yes,
Some scene photos, is that correct?
that's correct, yes.
Medical examiner dispatch removal report, is that right?
I believe so, yes, sir.
Some videos from the location of 34 Fairview Road, is that right?
Yes, sir.
Some photographs of the defendant's vehicle, the 2021 Lexus LX 570, is that correct?
Yes, sir.
Photographs of evidence that was recovered from the scene, is that correct?
That's correct, yes.
CDR report from the defendant's Lexus.
Yes, sir.
And then essentially there were some other materials, whether they be literature or other things that you and your team of other doctors reviewed over the course of formulating your opinions in this case, correct?
That's correct, yes, sir.
Now, in regard to evidentiary materials that indicates within the report that were reviewed, you talk about the lens cap to the taillight assembly, the taillight assembly photographs of that nature, and then there's mention of a black straw that was found on scene, correct?
Yes, sir.
There's no mention in the report of either Mr. O'Keefe's shoe or his hat, correct?
Yes.
You are muted.
Asked and answer. We're gonna do all the same stuff again that we just did with the last guy, and we're gonna ask him a bunch of questions about what he didn't look at. That was already sustained, but here he is doing it all over again. But it's only Mr. Jackson that gets the for the last time. And it turns out that whole problem was foundation because he never said there would be injuries from projection. Good Lord, Bev, come on. Exercise some common sense here. We all know you don't need expert testimony to tell us there are likely to be injuries if somebody is projected by a vehicle. We already got it from the forensic pathologist. There's going to be bruising at the very least. Just ridiculous with the little technical nitpicky stuff that is just, it's just pointless. It's just pointless. That was not a necessary foundation. We can already assume that. Interesting. I saw from the chat, here's a story in the Boston Globe. Death of Sandra Birchmore was a homicide, prominent pathologist states. Wow, it's in several places reporting it now. Somebody has disagreed with the official suicide finding. And I believe this is relating to the civil case that the family has filed relating to her death. I'll have to read through some of that. If you've missed where we've talked about this before, this is a separate rabbit hole I've only just started to go down, but it's got significant overlap, mainly through the prosecuting attorney's office that's involved here. Suspicions of law enforcement, potential involvement. In this case, this young woman had been a police explorer, started a sexual relationship with a police officer, Matthew Farwell, when she was 15 years old. And then subsequently, years later, she gets pregnant with his child. He doesn't want that. He's married, has his own kids. So it's a problem that he wants to take care of. He's the last person seen entering her apartment. She ends up dead, and it's ruled a suicide, and that's pretty much that. No further investigation into it. So very troubling looking circumstances in terms of prosecution's seeming unwillingness to want to go down these investigative roads if it looks like there's evidence of law enforcement wrongdoing. It's the same district attorney, the Norfolk County District Attorney's Office.
You are unmuted.
So another one also where the feds have been asking questions about the investigation.
Do you need a couple of minutes, Mr. Lally, or do you need a minute?
No, it's fine now.
No.
Thank you.
Why, did they hopefully cut him off from a lot of this junk? What I've learned about the Sandra Birchmore case was from listening to the Case podcast.
Doctor, are you familiar with a term called
So if you're
compression
interested in
abrasions?
that, check that out.
Compression abrasions?
Yes.
Yes.
And am I correct when I say compression abrasions are essentially when direct pressure from a blunt object together with slight rubbing movements produce skin and epidermal crushing? Is that what your understanding of the term is?
Yes, sir.
And you're familiar with patterned abrasions?
I am, yes.
And pattern abrasions are injuries that show a distinct pattern that may reflect the shape of the impacting blunt objects that you may see with reference to injuries that are left by that blunt object. Is that correct?
That's correct, yes, sir.
Now, as far as in general terms, from what you reviewed, at any point in time, did you look at a state police reconstruction report?
I don't believe that I did, no, sir.
You weren't provided with that, is that correct?
That's correct, I don't believe so.
You weren't provided with any sort of forensic reports, DNA or anything like that, is that correct?
I don't believe so, no, sir.
And that's it. That's all he gets to ask. You didn't see them, period.
And you never actually looked at the physical car, is that correct?
I did not, that's correct.
And you're aware that the physical car, being the defendant's car, is still in law enforcement custody and available for inspection if you had wanted to? Are you aware of that?
I think I'm aware of that, yes, sir.
You never made that request, is that correct?
That was not necessary in this case to inspect the vehicle.
Whether it's necessary or not, you didn't make that request, correct?
Yeah, I don't remember if we made that request or
They
not.
didn't
We
pad the
obviously
bill,
didn't look
Mr.
at
Lally.
the vehicle, but it wasn't necessary in this case.
Did you ever look at the actual taillight pieces or the taillight housing, is that correct?
Not the actual, we looked at photographs of the evidence, yes.
Now, the injuries that you observed or reviewed in materials in regard to Mr. O'Keefe were primarily on the right side of his body, is that correct?
Well, sir, on the right arm and the posterior aspect of the right arm, yes. And then the skull fracture was a little bit to the right, the occipital fracture.
Also bruising on his right hand, is that correct?
There was bruising on the back of his right hand,
On the
yes.
dorsal aspect?
Yes, correct.
And there was also bruising on sort of the posterior of his right knee, is that correct?
There was a small bruise, I believe, yes, sir.
So what now? He got hit on the left side? And somehow
Now,
got all those injuries on the right from landing?
with respect to
He doesn't
within
know what he's
your
getting
report, you
at.
talk about the numerous linear abrasions on the posterior of Mr. O'Keefe's right arm and forearm, correct?
Yes, sir.
And in relation to those injuries, there is a sentence in which you or whoever authored this part of the report, I'm assuming it's you, indicate that furthermore, any such injuries would be highly improbable if Mr. O'Keefe was wearing a jacket, correct?
Yes, sir.
Are you aware that Mr. O'Keefe was not wearing a jacket other than a long sleeve sort of hooded shirt?
I believe that came to light afterwards. Again, it doesn't affect my actual opinions in this case, but it was a sentence added in there, yes, sir.
And so also within your report, same paragraph, you indicate blood and DNA transfer would also be highly probable under such circumstances, none of which were reportedly found on the tail lamp assembly or any of the fractured pieces, correct?
Correct.
Are you aware that DNA consistent with that of Mr. O'Keefe was actually found on the tail light housing from the defendant's vehicle?
I am aware after we wrote or issued the report that it became known to us that I believe DNA was tested and some DNA was found, I believe a small amount. I don't believe any blood evidence was located or found on any pieces, but there was indication of DNA on the taillight housing.
There was also DNA matching Mr. O'Keefe that was found on the exterior of a piece of drinking glass that was found right near his body.
I believe so, yes, sir.
And there was also pieces of approximately 1/16 of an inch by 1/16 of an inch of clear and red plastic that was subsequently found to be consistent with the defendant's taillight that was found embedded within Mr. O'Keefe's shirt.
Within the shirt, I believe, yes, sir. Not his actual body.
And so this is all things that you found out after you issued your report in February of 2024, correct?
That's correct, yes, sir.
Now, when you were talking about the injuries to the back of the head of Mr. O'Keefe, consistent with coming in contact with a hard surface, correct?
Yes, sir.
Would that hard surface include if the ground was frozen?
Well, you'd have to perform an analysis actually, because you'd have to determine how hard that ground was. You'd have to look at the freeze and thaw cycle, probably leading up to weeks of that. You can't just look at ground and say, well, it's below freezing, so that ground must be frozen. Is it a possibility? It may be, but you have to go through an actual analysis and procedure to determine how hard that ground is and whether it could have produced those injuries.
So it is something that's capable of being done by you, is that correct?
Performing that type of an analysis?
Yes.
You could go through and do it, sure, yeah.
And you didn't do it, correct?
No, I did not do it, no. Because, yeah, there's no need in this case. We don't know what happened in this case. There's no indication of, certainly, it's not consistent with getting hit by the car and ending up where he did, even if the ground is somehow hard enough to cause that type of an injury. Again, there's no movement and no force to get his body over there, and the damage with the car is inconsistent with him being struck by it. So whether the ground could cause it or not, the roadway could cause it, the curb could cause it, a bat could cause it. There's numerous different possibilities, and we don't really have enough evidence in this case to determine what one specific event actually caused that injury.
You didn't have enough evidence based on what you were provided, isn't that fair to say?
I didn't have enough evidence based on what I was provided, and even looking at the additional evidence that I became aware of after the fact, there's still no evidence. I mean, you can't deny the science and the physics as to what would have happened if he was struck by the vehicle. So anything past that, you have to somehow overcome that hurdle, which is very difficult to do.
When was it that you looked at this additional material and who provided it to you?
We were informed after a report was issued that DNA was found. And that was really the primary issue. I believe that some DNA was found on the housing, which, again, there's numerous explanations or ways that DNA can get on the lighthouse.
Lally?
Let me ask you this, sir. With regard to the materials that you were provided with, was there anything in there that stated that Mr. O'Keefe's skull fracture on the back of his head was caused by contact with the taillight?
No, I don't believe there was anything in those materials that stated that.
Is there anything in those materials that indicated or that anyone stated at any point in time that Mr. O'Keefe's arm was outstretched at the time that he was struck by the vehicle?
No, sir, there wasn't.
Was there anything in there indicating that his arm was tucked in at the time that he was struck by the vehicle?
You know, there's no indication in any of that evidence of what he may or may not have been doing, how he may or may not have been positioned. I mean, that's the whole issue. There's no evidence to indicate what may have allegedly occurred in this case.
Now, a typical pedestrian collision that you see through the course of your work involves a pedestrian being struck by the front of a vehicle. Is that fair to say?
No, I see all types of different people getting run over backwards, cars spinning, hitting sideways, frontal impacts certainly occur, yes, but we see pedestrians getting struck by all parts of the vehicle.
I'm sure you see all kinds. What I'm asking you is predominantly when you see a pedestrian collision, the typical pedestrian collision would be a pedestrian crossing a road in front of a vehicle as it's approaching. Is that correct?
Why does it matter?
That's certainly not uncommon, yes, sir.
Now, as far as maybe describe a little bit on your direct testimony, as far as there's differences in the type of injuries that you would expect or anticipate depending on how the vehicle interacted with the pedestrian in a pedestrian collision, correct?
Yes, sir.
And as far as you familiar with what's called a sideswipe collision?
Yes, sir, I am.
And am I correct when I say that in a typical pedestrian collision with pedestrian crossing in front of a vehicle, there are a number of different types of interactions as far as a wrap and a forward projection versus a fender vault versus a number of different ways that a pedestrian can interact with the front of a vehicle, correct?
It depends on the position of the pedestrian and certainly the profile of that vehicle and the speed of the vehicle. Yes, sir. There's many different factors involved in it.
And so in a typical pedestrian collision, when a pedestrian is struck by the front of the vehicle, that involves more of an assumption of the velocity of the striking motor vehicle by the pedestrian than you would expect to see in a sideswipe collision, correct?
Well, I mean, yes, generally speaking, a sideswipe means that the person or the pedestrian in the vehicle don't obtain a similar or common velocity. So if you're standing in front of a car and it hits you, it's going to speed you up to that same speed and then disengage. The sideswipe means that there's not this mass-to-mass impact. By its very nature, sideswipe has minimal forces. We see it even between vehicles that just rub against each other. So if there's a sideswipe impact with a pedestrian in a vehicle, there's going to be very little damage to the pedestrian. And similarly, there's going to be very little movement. There's really no force at all acting. You know, for instance, if a car came and swiped by your arm, but didn't have enough force or enough contact to cause any damage, well, it wouldn't actually cause any movement of the person either. So a sideswipe by its very nature involves minimal impact, minimal forces, minimal velocities.
And also contained in the report that you at least co-authored, there's an indication that Mr. O'Keefe's injuries, at least to his skull, the fracture to his skull, are consistent with him having been pushed or possibly been impacted by the subject Lexus and fallen backwards, striking his head. Isn't that correct?
Yeah, so that's another possibility.
Sorry, sir, yes or no?
No, let him answer. Let him answer the question.
So if we're saying that there's enough force if you fall backwards to strike your head and cause that skull fracture, well, he could have slipped and struck his head. The car could have backed up and not known that he was there and nudged him and caused him to fall. I mean, any event that would cause him to fall backwards obviously would result in him striking his head. So there's numerous, almost infinite possibility of different scenarios that could result in that type of an event.
Thanks.
Mr. Jackson? Okay. Dr. Rentschler, you are all set, sir.
Thank you, Your Honor.
Okay.
Defense
Jurors,
rest.
I want to see counsel for the last time at sidebar right now.
For the last time at sidebar, I think that's probably the case. We all know. Rebuttal from the Commonwealth. Will there be any? I don't see how there can be. They got to do their pre-buttal. It would have all been objectionable for them to be pre-bunking the defense case before the defense even puts it on. You don't normally get to do that. It's not responsive to anything, but they got that special leeway here to just go ahead and do it all at once. But that suggests you don't get a second bite now. No testimony from Karen is what's expected, at least based on what we've been told from the attorneys and everybody. It's the common wisdom. Don't put her on. There's no need for it. No real upside. Because all she can really do is just, I mean, she can tell us what happened, But none of it's going to change the mechanics here. That's why this witness was so brilliant. It's not going to change the physics involved. You can't get around that. It doesn't matter if the ground was frozen if he couldn't have been hit by a car.
You are unmuted.
Thank you, Your Honor. With that, defense rests.
Okay. Jurors, that is the evidence in this case after all
That's
these
it.
weeks. That's the evidence that you will hear in this case. The lawyers and I still have work to do for tomorrow. But tomorrow morning, we will have closing arguments of counsel. They'll get an hour apiece to be able to argue this case to you. I'll instruct you on the law, and then 12 of you will begin your deliberations sometime tomorrow. Okay, so with that, please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it. Let us know. We'll see you tomorrow.
All rise for the court, please.
So jury's gone, but we will probably get the jury instructions conference this afternoon. They'll be arguing about that. Yeah, the jury is definitely getting the case tomorrow. The question is, do we get a verdict tomorrow? Or will we come back? Have they had enough?
Jimmy, I love turning it on that way. I love turning it on a second.
So we're going to the fan. Doesn't look like they're going to tell us specifically if they're coming back, but I'm going to assume they are, I guess, unless Law and Crime here kills the stream, which I don't think that's likely to happen, but I guess we'll see. Yeah, I mean, before lunch, here I was optimistic that they'd get through it today, and they not only got through it today, they got it done. They got it done before lunch. How do we like Lally opening the door to that testimony that he had gotten excluded? Bev saying he can't opine on insufficiency. It was the conclusion number 4, not enough evidence to determine what caused the injuries. He just went ahead and opened the door for him to be able to say so many different mechanisms could have caused it, and there was no specific evidence. Not enough evidence to be able to narrow it down to what would cause that specific injury. It could be all kinds of things. It could be a bat. It could be a slip. It could be a nudge. A nudge with the car that wouldn't be enough to cause a bruise, but just maybe because he's really drunk, knock him off balance. That's really going to be the best they have at this point. That's going to be the best argument they have. They're going to have to backpedal off of this intentional murder. Not that they will. I'm so eager for Mr. Lally's closing, not because I'm looking forward to it, not that I think it's going to be enjoyable, but just because I'm dying to see how is he going to explain this? How is he going to make the case for intentional murder in light of all of this? He's going to have to just disregard everything that these experts have said. What's his pitch to the jury going to be as to why they should just disregard it? Just that they should? Well, because we heard from multiple people, and these ones said, I wonder if Mr. Yanetti is also going to do the closing like he did the opening. Not going to lie, I kind of hope he does. I mean, that opening, he absolutely knocked it out of the park. And I have a lot of confidence in his ability to do the same thing with the closing, where it's just it's a recitation of what you've seen, but now it's the opportunity to explain it all. And he's lived with this case for so long. He's been He's been involved in developing the theory of the defense from the very beginning, from the time when they still all thought it was possible maybe she did hit him. She didn't mean to, but maybe she did. Actually bought into that from all of this gaslighting. Maybe it's possible she did it and just didn't remember. No. Nope. The guys who are in charge of the laws of physics, interpreting that for us lay people, have told us it's not possible. She didn't hit him. That's really all I needed to hear. The rest of it, it doesn't matter. It doesn't matter if she had motive. It doesn't matter if she thought she did. It doesn't matter what she said. If it couldn't have happened, then it didn't. And that's really all that we need to know. Oh, guys, yes, this is where we were finishing when the jury came back. So first off, they'd have to recognize the people that were involved, recognize them as witnesses in the case. They'd be required to disclose that, and then they'd be questioned about basically what they saw and what it meant and what, if anything, they would take from that. So we haven't heard anything like that occurring. So I'm just kind of doubtful that any of that happened. Leslie Vasquez with the super chat. Thank you so much. Michigan Farm Boy, 13,000 would be about 2 a day, 5 days a week, 50 weeks a year for 26 years as chief, not counting training years. Yeah, I mean, there's a lot of way to break it down. We just broke it down. Jeff's math was like the straight if you worked every single day without a break. I mean, this is a lot. This is a lot of autopsies that this guy has done. Chad Hibbs, I asked my ER doc wife what her diagnosis would be if arm injuries presented in ER, and her immediate reaction was a large dog. She has no other context to the case. Yeah, I mean, I can see why. Nobody on the planet looks at that arm and thinks, oh, car accident. Just nobody is going to think that. Yeah, it looks like he got chewed up by a dog. Ahap, Andrea, is there an issue with YouTube? How do we takes forward to the ARCA witnesses? I don't know that I don't think there has been any issue with YouTube today. So I think everything is fine. Bad Biscuit, Chad is thirsty. Well, we don't often get eye candy as part of our trial, especially combined with such just intelligent, articulate. And he's just a dude. He gets to make cannons and shoot them at taillights. How awesome is that? Yeah, we definitely liked us some Dr. Wolfe. Entry required. They did space shuttle accident reconstruction also. ARCA. I'm assuming this means it wouldn't surprise me. It wouldn't surprise me. They've probably analyzed all kinds of different, just incidents like this. Sandra, Yanetti updated his Twitter bio to say he tweets about law, ... and stuff. King of Shade. I saw that too. That was good. Just that little dig on Trooper Paul. He bases his opinion on math and stuff. Wasn't it math and stuff? Yeah, these guys gave us actual formulas that they used and explained what they mean, explained how they work. How did we like Lally ask? Well, you weren't. It wasn't suggested to you. It wasn't in your materials that anybody was saying that he got hit by hit in the outstretched arm. It wasn't in your materials. Well, no, but your expert said that. Are you saying they shouldn't have considered that, even though your expert considered that? I mean, their goal here was to try to reconstruct it. Are we going to try to say he got hit on that tiny abrasion on the side of his knee? No, that doesn't make sense. I mean, the whole issue here is really, it's the projection. It's if the Commonwealth is saying he was projected 30 feet ish. I mean, really projected at all. Then there has to be a significant impact with the vehicle. It's a very heavy vehicle. It's going to at least bruise him. That's just the bottom line. It's going to at least bruise him. And there's nothing on him that would support that. The math and stuff, it just doesn't matter. I think he probably, Mr. Trooper Paul, related quite a bit more on the stuff than he relied on the math. Pine Rider, this is so enjoyable watching these experts and knowing that they did not come through the DEI system. Well, they clearly have, very, very good qualifications, but the proof is in their communication skill. I've said this before. It's just that common saying that if you want to test how well you know something, teach it. Teach it. Teach it to a child. Teach it to somebody who doesn't know anything about it. If you understand it well enough to be able to distill it down into those kinds of terms that you don't have to be an expert to understand, then that's because you really get it. You're able to simplify the very technical things into ideas and language that ordinary people can relate to. So this is one of the things I'm just going to go ahead and talk up my husband some more, because he knows all of this stuff about things I know nothing about, like string theory. He can explain this stuff to me in a way that makes sense that I don't understand. But physics and things like that. StreamYard just had a little stroke there. Not sure what all that's about. We'll keep an eye out for problems. So far, the camera is working again. I am a little, something's off with the color. We might have to tweak some settings or something like that, but fingers crossed. Everybody please knock on wood for me. The camera is not dying today. Greg, good luck on cross, Lally. Laugh my ass off. Yeah, good luck on that cross. I mean, this guy was ready. He was ready to be able to explain. It didn't matter. We didn't have to look at the car. It didn't matter. Well, but you didn't? Well, no, because it didn't matter. It wasn't necessary. I don't know. I don't know why Lally would double down on that and think it's some kind of a point to make that he didn't look at the car after he just told you he didn't need to look at the car. Why should he look at the car if he didn't need to? Just so he can bill somebody for it? No, that's a bad expert who does something like that. Plain Iron, buy some tea on me. Thank you so much. I will indeed. So last Friday, I went on stream with Legal Vices with Jeff. I really enjoy Jeff. He's from Logan, Utah, which is where my grandfather is from. It's a very, very small world over there. So we have a little almost connection with members of my family that are still down there, and him growing up down there and stuff like that. I'm sure I could tell him where my grandfather grew up, and he'd know exactly where that was. So I met, and now, of course, I'm not even going to remember his name. I've told you guys before, names are terrible with me, but I remember it's Dragon's Treasure Tea. He makes a lot of tea. He was on the show, on the stream. So I'm going to be checking out Dragon's Treasure Tea and see if they have a good white. Not that white is the only thing I drink. I started with green and then moved on to white. There's just something, I like the green. I like it's very fresh. It is a little grassy, but not like wheatgrass grassy is kind of overwhelming to me. It's much more subtle than that. But the white tea, I'm just so on it. I don't know how to describe it, except that to me, it tastes like roasted honey. It's just what I imagine that would taste like. It's got the sweetness, but it's got something a little dark and earthy to it. I just love me some good white tea. So I'm going to see what the Dragon's Treasure has for white teas. Stacy M with a super sticker. Thank you so much. Appreciate that. Rube, Wolfe talking conspicuity is giving me concupiscence. I have no comments about that. I will neither confirm nor deny. Lally wouldn't know what that one means. He would have to go and look that one up. I see you. Birchmore just ruled homicide. These same investigators going down. Yeah, I just saw that. I pulled up one of the reports that I saw. I don't think this is an official determination, like a medical examiner changing their opinion. Just a quick read over that I got was based on. I think it's based on the civil case and an expert that the plaintiff has hired to support their civil case. But I'm going to look a little bit more into that just to see if I can get some more details. They would have to. I mean, it would be hard. It's much easier to support a civil cause of action if it's a homicide than if it's a suicide. A suicide is typically going to be an intervening cause for, pretty much any wrong that you can point to the the law enforcement, the city. It's the city of Stoughton in this case. She was found deceased in Canton, but the police officers involved were from the neighboring town of Stoughton. So if they were going to try to attribute wrongdoing to like the Explorer program that appears to have maybe groomed her and perhaps other people as well, suicide, it's going to be pretty hard to show that the suicide was caused by that. Just because it's an independent action of a person. So in terms of them being able to pursue a civil suit, yeah, I'm not going to say it's strictly necessary, but for practical purposes, it really might be. But I would definitely be interested in knowing more about how they were able to reach that determination, if it's just based on injury, based on autopsy, or if it's based on surrounding circumstances and they just disagree about the significance of things like, oh, here Matt Farwell was the last person seen entering her apartment, her behavior as far as not engaging with her social media, just kind of going off the radar. Pretty much right after he left, she had been out clearing the snow off of her car. The last time she is seen on the camera, she's coming into the building, holding, a brush, a scraper for the car. But then when her car is found, it's all covered with snow, like she hadn't apparently gone anywhere. She was found a couple days. I think they estimate a couple days after she had passed away. So that will be, that will be interesting to see how that plays out. Ian Kelly, Andrea, did you see the waterfall video of BH and JO? Looks like BH saying some things to JO. I did. So this was a clip that I saw somebody had put out. I saw it on Twitter. Somebody had put it out on Friday afternoon after we finished with court. And it's just a specific section of the video from the waterfall. And yes, it does look like there is some kind of conversation that looks a little bit aggressive going on between Brian Higgins and John O'Keefe. It looks like Brian Higgins then indicates back, like with his arm, towards Karen, the direction where she is sitting. John is then goes back to where Karen is. I think this is when Brian Higgins is leaving the bar. John goes back to near where Karen is. She seems to just be having the conversation with whoever's at the table. She's still just sitting there. John is standing to the side and he looks a little high strung, looks a little anxious. He's not sitting back down and chilling with the rest of the conversation. Looks like there is just something going on with them. Raises some questions. It raises some questions. Didn't they ask? Didn't Mr. Higgins get asked very specifically in his examination, either direct or cross, if he had any conversation with John? And I don't think he said that he did, other than just those niceties when John first came into the bar, the greeting, which was general. It wasn't specifically directed to him. Pretty sure he denied having specific interactions with John. So it's not what it looked like on the video. Definitely not what it looked like on the video. James Brown with a super chat. Thank you, sir. Appreciate that very much. Fantastic Mr. Foxy Daddy. If I didn't know, I would have thought Lally was part of the defense team today. Thanks for your amazing coverage and insight. Well, you're very welcome. We could mistake him for the defense team really throughout his entire case in chief. He put on the defense's case. He put on their case. They didn't have to do it because he went ahead and did it for him. And that's just the downside. It's the downside of this pre-Buttle case that he put on. I understand the theory, the idea of we'll get out ahead of the bad stuff, right? But the problem was, number one, he was just very ineffective at doing that. He was calling all of the witnesses like the people at the waterfall and so forth, but he wasn't actually getting out ahead of the bad stuff. The butt dials, the deleted Google searches, all that kind of thing. He was just leaving it there for the defense to stand up and dunk on witness after witness after witness with all of this bad information. So it really wasn't an effective getting out ahead of the testimony in the first place. But then the other just kind of head scratching I have with this strategy is there is something to say for making your best case, all of your case, and then that is what the jury has in mind as they turn to what the defense has to say. You don't address the defense case really more than you have to when you're putting your own on, because now you're just leading them bit by bit towards your direction, the conclusion that you're going to want them to reach, and then they've gotten that point by the time the defense comes on. So if they have bought into, at least in theory, your case, your explanation for how all of this happened and why it happened, they're going to look at the defense's case a lot more skeptically. So I don't understand. I've said from the beginning, I really don't understand this theory of how the Commonwealth decided to go forward here. It just doesn't make sense to me from a strategic standpoint. It certainly doesn't make sense substantively. It's not in your interest to put this stuff on. And you didn't do a very good job of trying to handle it. Take the explosiveness out of what so much of that evidence was. This is what we just looked at. Anton Ivanov, I think what we are seeing is Lally's future political career aspirations taking a long jump into the sewers. I don't know that I agree with this. I honestly don't. If the reason why he's pursuing this case and proceeding with this case is to protect the people that are involved, that could be implicated, that maybe participated in, I don't know, messing around with the evidence, passing information to people that maybe shouldn't have had it through the Canton Police Department, those conflicts and stuff like that. If he ran the case as a defense of the McAlberts and the Canton Police Department and the Massachusetts State Police, that's going to help him. That's going to help him with his political aspirations because he went to bat and he showed what team he was on. I feel like as a defense lawyer, I'm often saying, look, I'm not a magician. I can't control what the evidence is. I can't control whether you got caught on video, what you said to police, what witnesses saw, what witnesses describe, what corroborating physical evidence there is. I can't control any of that. And I feel like that is oddly the position that Mr. Lally is in here. He can't control all of the sketchy stuff that happened. It just is. For whatever reason, all of these phone calls between the participants at 34 Fairview that they didn't want to acknowledge, the searches, the text messages, the timeline that doesn't fit. That's even before you get to the sketchy stuff with why did they so badly mess up the chain of custody here? Leaving all this evidence out unattended, not secured. The reversed video? Such an own goal. How do you do all that stuff? That one I would argue maybe coulda and shoulda been controlled by Lally. Surely he's been to that Sally Port. He knows what the orientation is. He would have recognized because Karen and her team recognized it immediately. You could see her mouthing. It's the wrong way. It's the wrong direction. They saw as soon as it went up that this was a problem with the video. So that one is maybe one that Mr. Lally could have gotten out ahead of. But as far as the decisions that people were making early on in the case and in the investigation, he's just stuck with that. So he's in this defensive position. And yeah, I think if you look at the trial as a perspective of him running defense for those people, it definitely makes a lot of sense. It makes a lot of sense. And that's something that's going to advance you politically. Because those people aren't in a vacuum either. Those people are where they are because of the connections that they have. So, yeah, I don't know that this is going to hurt him from a political standpoint. I think it solidified his friendships and his relationships. And to the extent those people have and continue to have power in these communities, that's only going to help him. Desert Cat, starting review of my notes. Unsung hero is leaf blower guy. Without him, we wouldn't know taillight pieces had to be placed later. It is true. In retrospect, you look at some of these things and how they played out. I mean, it was Sergeant Good. It was Sean Good who was so emphatic about how good the taillight, the leaf blower was at being able to move the snow. What an effective way that was to accomplish what they were trying to accomplish, which was to get down to the bare ground and see if there was any evidence there. And there wasn't. That was very effective. And yeah, had they not done that, it's not that it precludes them from being able to argue that it was planted later, but it just helps them out so much because they have that point in time, right after John is found and is taken to the hospital within like the next hour, where they specifically went looking and couldn't find anything. The other thing like that too, that just works out very serendipitously in my mind, is that 1231 text from Jen McCabe. We got a photo of people outside the courthouse. I'm just trying to monitor what's going on law and crime here. There's Karen and her team leaving. Nope, I guess that was all they were going to show us for some reason, and now they're skipping over to another trial. So I don't know if we're going to get to see the instructions conference. Maybe not. I don't know. I'm just going to keep it up just in case to see what happens. But yeah, that 1231 text from Jen McCabe, pull behind me. She would have already been gone. If she's back at John's house by 1236, she would have already been gone. And that just gives away. It gives it away what was going on here. Right? Trying to create the cover story. Just funny how that stuff works out. It really is. How serendipity has smiled on Karen Reed in many ways in terms of being able to reconstruct all this. All the times that taillight was caught on video, completely bright red. Yeah. Yeah, she got lucky in a lot of ways, I think. JM, Karen left John at the Alberts because her stomach was hurting, allowing her lawyers to use a Jay Cochran move. If Karen was taking a shit, you must have quit. I don't think they're going to go there. Don't think they'll be making that argument. But yes, it makes sense as far as why she wasn't inclined to sit out there all evening and wait for him. He was supposed to be in and out, or he was supposed to be in contact right away to let her know if he was going to be able to get a ride, and then the minutes pass, and they're there at 12:34. Doesn't take that long, right? You sit and think about it. If she's gone by 12:27, 12:28, 3-4 minutes is kind of a long time to be just sitting in your car waiting. It's plenty of time for John to be able to go in the house. Hey guys, just here to stop by. Don't know if I can stay. If anyone can give me a ride home, then I can hang out. Someone says yes, someone says no. It isn't going to take that long. So yeah, I can see how she's not real inclined to hang out there for a long time waiting for him. That's how it could go down. Kyle Murphy, it's interesting to me to witness the confident demeanors of actual experts. Dr. Wolfe is ready and willing to answer questions and show his work. And the same thing too that we got from Richard Green. He's so eager to explain. He was ready and willing and happy to explain his reasoning, and it was Mr. Lally who had to be like, no, we don't want to hear that. we don't want the jury to hear that. It just it makes him look like he's afraid. It makes Lally look like he's afraid of what that explanation is going to be. He can't have the jury hear that part. Just the very limited tailored answer that responds to how he has formulated the question and nothing else. But these guys did seem very confident. Didn't get shaken. I mean, yes, there's other things they didn't look at. It didn't matter. So there's no reason to be scared or intimidated or defensive or anything about that. It didn't matter, didn't shake them at all. That was like the closest thing I think they got to a hard challenge. Well, did you know all this other stuff? No. No. Doesn't matter. Lots of explanations for how little bits of taillight could end up in somebody's clothing, particularly when that clothing is sitting out unsecured in a room for several days, which seems to also be the same place where these pieces of taillight were being kept unsecured for several days. Yeah, I can think about that. Patrick Henry, I haven't heard anyone mention anything about road traction. Is it possible that her tires were spinning in snow and registering a higher speed? I think that's what the defense is going to argue in closing. It certainly makes sense to me that that's what the vehicle data shows. I don't know that it even matters because they can take it out of the time frame of the accident anyway just by that counting the key cycles. It doesn't work with the number of key cycles. We know at a very minimum, they had to, before they did their testing, they had to turn the car on to get it off of the flatbed. And before that, they had to turn it on to get it on to the flatbed. That takes you to where the Commonwealth is saying the accident occurred. So we haven't even gotten to Karen driving from Dighton to John's house, or to her from John's house to Dighton at her parents' house. She would have had to turn the car on for that. Karen driving from Jen McCabe's house to John's house would have had to turn the car on for that. Karen driving from her own house to Jen McCabe's would have had to turn the car on for that. Like there's just all of these. It doesn't fit. It doesn't fit. So yeah, that is a logical explanation. They just saw a situation where the wheels spun in the snow and decided that that was going to have to be it. That was the closest thing they were going to have to work with. Is it unexpected or unpredictable that when you're trying to reverse in heavy snow, the wheels would spin? No, I think that's perfectly predicted. And you kind of even see it in that video where they're loading her car onto the flatbed. When you see it at her parents' house in Dighton, they had a massive amount of snow there. They got very good snow there. I was okay. I've been really poo-pooing the snow and the reports of the snow. That was Tahoe quality snow right there. Very, very deep, very fresh powder. And you can watch them backing it out. And yes, it has a hard time getting traction. You can see it right there. You know, I wouldn't rule out that that's the point that they were looking at. So I think they're if they're going to argue that at all, what this key cycle means, it seems like a pretty good inference. But honestly, I think they're just going to probably focus on it doesn't even matter what it was, because it could not have been this key cycle. It couldn't have been that key cycle. Norma F., if you're riding shotgun holding a drink and go to get out of car, are you still holding glass in right hand? How can they prove glass in right hand? They can't prove it, right? They just have to put it there hypothetically to try to come up with some explanation for what happened, to try to reconcile the evidence on the ground, the injuries with John, the damage to the vehicle. And that's really all that they could come up with. I mean, yes, you would think you're riding shotgun, you open the door with your right hand, right? This is the point the comment is getting at. You open the door with your right hand. You don't reach across your body to open the door with your opposite hand. So he'd be opening with his right hand. If he's opening it with his right hand, he's probably holding it in his left. Gets out. At what point does he change hands with the drink? I don't know. Maybe before he throws it at the taillight? I mean, no. We know that he didn't. We know that it would have to be about 37 miles an hour. I guess actually we don't know that he didn't, but that hasn't been reported, and that wouldn't be consistent with that piece of the glass being found underneath him. I don't know, unless they found it in the street or something. Yeah, I don't know about that. The fact that they weren't able to find the rest of the glass consistent. The street glass that they found was not consistent with the glass that he was on. The bumper sprinkles were not consistent with the drinking glass. So we still have pieces of glass missing, right? We don't know where the rest of the glass is. If he just fell on it, it should be right there. It should all just be like crushed underneath him. That really doesn't make a lot of sense. Let's consider the fight scenario. There's a fight somewhere. He's holding a drink. What do? You drop it. You drop it, right? Because your priority number one is defend and then be ready to throw. You're not going to do that with a glass in your hand. Somebody comes at you, hits you while you're holding a glass. What are you going to do? You're going to drop it. So if there was a fight, yeah, it would make sense that the rest of the glass would be right there where the fight happened. And then maybe, you know, when you're dumping his body out on the front lawn, you go ahead and throw the glass out there along with his phone. Just put him in the same general place. But the rest of the glass isn't there, and that's a problem. That's a problem. They found, a couple taillights worth of plastic, still as best as I can tell. But didn't find the rest of that glass. Rigid tactical. Lally really trying to tango with Crash Daddy about science and testing. He needs to stick to Trooper Paul level science and testing. Haha. He was trying to get technical with them. I think this was Lally trying to make it sound like, well, the Commonwealth. See, we can do science too. We can be technical. We can talk about reaction times and stuff. And I loved how that just didn't faze Dr. Wolfe at all. He's like, well, yes, but you have to perceive a pedestrian before reaction time is going to have anything to do with it. Because you're not going to react until you recognize something is there. I'm really not even sure what Lally was trying to get at with that. Is he trying to imply? I don't know what he's trying to imply. What reaction time wouldn't matter if your argument here is that she did it intentionally. Then she knew he was there and she did it on purpose. So reaction time wouldn't have anything to do with it. And then the question of, well, what would you do? Well, you would apply your brakes, right? You would brake, but your own theory is that she didn't do that. That didn't happen. That's why they decided this particular key cycle must be the pedestrian collision, because there was a small drop in velocity without any change to how much, how far she was pushing down the gas pedal. So there must have been some impact. Or I don't know, the car was starting to get purchase. It was starting to get grip. Could be that too. But yeah, he was just trying to sound like, look, we're sciencey too. We've considered these things. It's just by implication, but it didn't help him because the expert really made it clear that his points were sort of pointless. Red Forensic. How well did defense establish on cross that the driveway video clearly showed an intact taillight? Seems dispositive, not presenting directly. Maybe they will do it in closing. They're going to have access to all of these videos. They're all in evidence. And so anything that's in evidence, they can use it in closing. They can show it to the jury. They could do a whole montage. They could do a whole montage. And I think, frankly, something like that, it would be helpful because, man, boy, do I ever want to just show the jury step by step what I have seen myself from watching this trial, which is, let's go ahead and just start from that reconstructed taillight, right? And then let's look at what's missing. Let's look at what's missing from the reconstructed taillight. That one tiny little chunk up there at the top. They never found any of those pieces. But boy, then when you go and you look at that 8:30 a.m. dash cam video that the Commonwealth has been so excited about, you go and look at that. That's pretty much where it looks like the damage is. Okay, and this testimony about, well, but the rest, it was full of compacted snow and stuff like that. No, you can look at it. You can look at it on the dash cam, and it is not full of compacted snow. It's just the same light, smooth covering that falls over everything else. No, it does not look like a bunch of compacted snow in here in this taillight area. You'd have shadowing. You'd have changes to just the surface. It would not be a smooth surface. But you look at that dash cam video, yeah, it looks like a smooth surface wrapping right around the edge of that car, pretty much right like the other side. It's just that one little spot where that tail light could be missing. Very, very then consistent with that Ring camera video, right? So yeah, now go back to the Ring camera video and look at all the other pieces of the video that they saw and just show the jury. Here's the part that the Commonwealth is telling you is missing from when she hit John with the car. But here it is still lit up on the car at all of these different moments in time. The one in the driveway, yeah, it's the best view of it. by far. It's clear, it's right there in your face, and that whole big chunk is lit up red. Now we know too from the defense experts, the outer casing plus the inner parts of the taillight were all destroyed. Can't see how that's going to light up red. So I would like to see that. I would like to see that in closing. Tie some of those loose pieces together. Because I agree, I don't think it's been, like, it hasn't been overtly said, but there hasn't really been an opportunity to do that. It's just not, that's not what this phase of the trial is really for. I suppose they could have gotten at Trooper Paul with it, but since he's the one with the theory about the case and how all this happened, but he's just going to double down. The man clearly didn't mind looking ridiculous with his theory. We already saw Sergeant Buchanan gaslight us to our faces about the number of drinks Karen was taking on the video. Well, we were watching the video saying, yeah, that's not happening. What the words you were saying out coming out of your mouth, it is not what is happening on the video. We can watch with our own eyes and see that. So they wouldn't expect cooperation from Trooper Paul. He's going to say what benefits the Commonwealth. He's going to say it looks to me like that taillight's broken. So there's no real upside to doing that. These reconstructionists weren't under their control to be able to provide them with that. Now, could they have done that on the fly, on the stand, show them the video? Maybe. I don't know, maybe. But it would be a little bit of a high-risk scenario. You don't know the answer to the question, then it's very risky to ask it. So you just stick with what's there in the report. That's already helpful enough. You don't need to open the door for the possibility that they might look at the taillight video and be like, yeah, to my eye, that looks like maybe it's busted. So this closing is really going to be their first opportunity to really make that connection, I think, and call that out, to be able to comment on it and what it means. Joshua Frost, Lally just trying to use this cross to reiterate all the evidence, not even asking questions relevant to his findings. Yeah, with Dr. Wolfe, that was definitely a problem, and it seemed pretty clear that Bev yanked the leash on that when they got to Dr. Rentschler. You're not going to be able to do the same stuff. Jackson objected and took him to the bench, and immediately when they got back, Lally had to shift his whole direction. No, you're not going to be able to go through that same script of reiterating the stuff that you would like them to have looked at, but they didn't. So argue it to the jury. Don't argue it to the witness. It was not a good cross. I said when it was happening with Dr. Wolfe, it's just not in good faith. The objection is continuing to be sustained. It's a circumstance where it seems pretty clear why the question is objectionable. If he doesn't know, he didn't look at the forensic reports, then of course he doesn't know what the content of the findings was. So it was just him backdooring, trying to reiterate what the Commonwealth's evidence was. Automata, am I the only one? Can't help but think of the 1 if by fan, 2 if by read line every time they cut to it. Heard that one of the first days of trial. I haven't heard that, but I like it. I like it. 1 if by fan, 2 if by read. Sentient Dreamer. I was so neutral at first. Now KR not guilty. I'm with you. I came in thinking, well, maybe she did. Maybe it was an accident. Maybe it was just a bad investigation that gave her some leverage to be able to make these arguments. No, she didn't do it. I am, after hearing all of the evidence, I am in camp. She didn't do it. I couldn't agree more with Dr. Rentschler. The physics are what they are. You can't get around that. I mean, from day one, the skepticism for me has been, I look at John, I look at his condition, I look at the injuries, and no, it doesn't look like a car accident. No, it doesn't. It just doesn't make sense how that would work. So I was waiting for the Commonwealth to give me some kind of reasonable explanation for how that happened. And instead they give me the moment arm that wasn't. I love how Dr. Rentschler brought that up too. Yes, let's give us some more physics about the moment arm and how that would cause rotation. It would cause torque on the body. Oh, I loved it. I love that explanation. Even if his arm is like a stiff metal bar connected to his body and not a ball joint that would move. Because no, you are not going to, okay, I don't care how much time you spend in the gym, you are not going to be able to resist 1,000 pounds, coming laterally in on your elbow like that. No, it's not going to happen. It's just ridiculous. His arm is going to move, and that's going to be it. His arm is going to move. They don't have a coherent theory for how this happened. They don't have an explanation that satisfies me as far as the condition of the evidence. Where's the rest of the glass? Where is the bare grass under where John was found? Why was he found on top of compacted snow with his blood dripping on top of the snow? They never did get into where is the rest of the blood. I don't know. I mean, maybe it's just a nothing because there could be an argument that if he had bled onto the bare ground, like it would just mix with the mud and they wouldn't find it or something. I don't know. But that is a big question. It seems weird that you see the little splatters, but not the blood that you would expect from that massive laceration to the back of his head. You didn't see any of that. I'm not satisfied with the condition of his clothes. The blood splatters down the front, just like it happens when you start bleeding during a fight. Drips right down your front, down the front of your pants, onto your shoes. Yeah. Not satisfied with that explanation, with that evidence. If he was knocked onto his back, and now I hear from the pathologist too, he would have been unconscious. This doesn't surprise me, but I mean this is a extremely grievous head injury. Of course he's going to be knocked unconscious. But we got the medical confirmation of that. So this rules out the possibility that he got hit and then stumbled around for a while, and that's how the blood dripped down him. None of that still explains how did he get cut over his eye? How did he get cut over his eye? I mean, I'm sure there's other ways to get a cut over your eye besides being punched in your eye. Being hit with something else over your eye. What would have hit him in this accident? This accident mechanism. What hit him over the eye? No, I'm not satisfied with any of this. And that's just even before we get to the sketchiness and the things that we shouldn't even have to be asking questions about. We shouldn't have to be asking questions about the chain of custody. And that's why it's particularly problematic, because if there is any case where you would expect all of that to be just I's dotted and T's crossed, it's the death of a law enforcement officer. You would expect them to do it perfectly and not this half-assed leaving things around, not booking things in, things getting all messed up. Too many pieces of plastic in the one evidence bag compared to what you put in your report, compared to what was reported to other people that they then reported in their reports. No, those would not have happened in a careful investigation of a law enforcement officer. And so, yeah, that's just before you even get to the butt dials and the alternative explanation of what happened. Yeah, it would have been nice to have definitive proof of exactly what killed John O'Keefe. I'm sure the family would have appreciated that. But we don't know. And a big part of the reason why we don't know is because the investigation never bothered to look down those roads. They just never bothered to. And the problem is what they have delivered here, not at all consistent with Karen hitting him with a car. That's the bottom line. Every single charge that the Commonwealth is presenting to the jury is dependent on her hitting him with a car. And that's why Mr. Lally, when he did that motion for the directed verdict after the Commonwealth rested, that's why he focused it on that. It was never going to meet that standard. But it's planting the seed. It's a practice. We know where it's going. That's going to be the argument to the jury. All the other stuff is noise. It's extraneous. It doesn't matter what she said, who she said it to, how much they fought, who she flirted with. Nothing matters if the evidence shows she did not hit him with the car. End of story. Karen Reed is not guilty. I'm with you. Duncan, Idaho, the old ME dealt a major blow to the Commonwealth case. Also, the huge majority of us see 0, maybe 1 or 2 dead bodies in our lives at funerals. Crazy how much death that man has seen and carries. It has to change someone significantly. Yeah, I would think it would. I would think it would. I had a friend who was a state trooper. The stuff those guys see, okay? I mean, just over the course of a career, the number of high speed, like highway accidents, collisions, ejectments, pedestrian, people hitting animals. I mean, all kinds of that stuff. The amount that they see is just overwhelming. It's just overwhelming. I think going through medical school, I would just expect you probably get a little calloused to that already. Like they do, the cadaver work and things like that. Although I understand that's changing now. Like people don't work on real cadavers nearly as much. But I'd expect there's a desensitizing process to that, just because there would have to be. You can't go into the surgical theater and never have seen, somebody's skin opened up with a scalpel. Like it can't be the first time because you don't know how you're going to react. You need to be a little bit desensitized to that in order to be able to function under those conditions. But I imagine, I would think that much contact with death, probably would change you. Probably would. But he was a wonderful witness. Wonderful witness for the defense. Let's even just take that beautiful accent aside, the Dubliner. Let's put that aside. He was not generous with the possibilities he would consider, like Dr. Scorty was, like Dr. Scorty Bello. If it's not possible, he's going to tell you it's not possible. It didn't happen like this. No, it did not. I'm not going to entertain that it's possible, because in his opinion, it's not. I mean, that's great. That doesn't get more, you're not going to get more definitive than that from a medical expert. It did not happen that way. All of the different things he's seen too. We say how seeing all this stuff would affect somebody. When he was talking about the incidents of the animal bite, when the 2 dogs, he got very specific about one of the cases where the dogs had attacked and killed the children. It seemed like he had emotion related to that. You know, not enough to like prevent him from being able to talk about it or to make him cry about it or anything like that. But not in the sense of, oh, this guy is completely detached, completely dispassionate, like maybe, you know, psychopathic almost in his lack of response to it. No, he seemed to still have a human response to like how terrible that was and maybe connecting with that memory of having to think about that and remember what he saw. That would just be terrible. That would be terrible. That would be such a hard thing to see. So I do. I think to be able to make a career out of something like that, it probably takes quite a bit of strength. You know, if you're not like a psychopath or borderline, you know, no empathy type of person, I think it would be very hard. It would be very hard. Theory neutral. Lally demonstrates why critical thinking, informal logic should be mandatory in high school and college for all. Fallacy after fallacy on cross. He has to. I mean, that's all that he has. He can't challenge these guys on the merits of what they have to say because one, they are so much more qualified than he is, and two, the facts just aren't on his side. So he's got to rely on rhetoric. That's all he can really do is try to rely on rhetorical tools. The absence of the dog DNA is a big one. This is going to be he's going to hit it in closing too. There's no dog DNA whatsoever on those clothes. Well, absence of evidence is not evidence of absence. You're not disproving that a dog bit him. You can't establish that there's no set of circumstances where a dog would bite somebody through the shirt and not leave any DNA, or that there would be no DNA that could be recovered subsequently days later after the treatment that these clothes got. So I mean that's a very classic fallacy there. He's arguing, well, if there's no evidence, that must prove that the dog didn't bite him. No, it doesn't. It doesn't at all. The things that he didn't see, you know, the pieces of evidence that he didn't see. I mean, to me, all of that, it's because you're implying that somehow that would be necessary for them to reach the conclusion that they reached in the case. But when the guy is evaluating the physics, it doesn't matter who said I hit him at the scene. It doesn't matter what microscopic bits of taillight were found where. And the glass, the DNA on the glass, you know, he's putting these questions out like it implies that there's a shortcoming in his analysis, but that's because it presumes that those pieces of evidence would be relevant to his analysis at all, and there's no indication that they were. It doesn't change the physics if John drank out of that glass. It doesn't change the physics at all. It could it be less relevant? Thinking to myself, could it be less relevant whether John drank out of that glass or not? No, it doesn't. It doesn't matter. Okay, so we've proven that it's not a random glass that just happened to be there on the yard. I guess. I don't know. But yeah, there is kind of an assumption built in there that the jury isn't going to be able to spot the logical problems with it. You hope that's not the case, but that's going to be what closing is for. That's the defense's opportunity to point out, here's the problem with what the Commonwealth is trying to sell you. And they don't have to put it in technical terms of, you know, it's this fallacy or that fallacy or whatever. They can just point out it doesn't follow. If it wasn't necessary for Dr. Rentschler and Dr. Wolfe to look at these particular pieces of evidence, then it means nothing at all significant that they didn't look at them. James Brown, Dr. Wolfe thinks Lally's a whack job. Yeah, he did kind of. There was one moment, I don't think I understand the question. It was about as polite, what are you talking about? kind of diversion as you could get, kind of explanation. But yes, he clearly was not particularly impressed with Dr. Lally's The Wind, right? So the eliminating the variables, that was that line of attack that Lally took to try to seem sciencey, in their approach. So first, they chilled the taillight to 28 degrees. I love that came out. Well, but you didn't put that in a report. Well, you don't have to put every single detail in the report. You don't have to put every single detail in the report. They chilled them to 28 degrees. I love that. And then for something like the glass, a glass that you're throwing, come on, how is wind really? We're not talking about, we're not talking about polar winds. 37 miles an hour, is that fast? It's not an evidence, right? It's not an evidence. He tried to sneak that in. That was sustained. That was very objectionable. Is that going to affect a glass? I'm not sure that it would. I'm not sure that it would. Is that going to be Lally's explanation now? Well, a gust caught it. No, because the Commonwealth hasn't told me anything about John throwing the glass at the taillight anyway. Like, it doesn't matter anyway. This isn't your theory. I mean, unless your theory is now shifting to John threw the glass at the taillight and broke it. Is that going to be their theory now? Heck if I know. Thomas, pee on the fire, call in the dogs. This hunt is over. I mean, I think the hunt was over when the Commonwealth rested, and now we were just putting nails in the coffin the last 2 days. It wasn't a car accident. It didn't happen. And by the way, those things on his arm, those are dog bites. Those are dog bites. Oh yeah, and that Google search, it happened at 2:27. When you look at this version of iOS and you try to recreate it in this version, yeah, that's what happens. That's how you get that artifact. You get it after you do the Google search. It was done when the Commonwealth rested. Duncan, Idaho. I think J.O. was hit by the Lexus at 25 miles an hour in reverse. It hit him in both the back of the hand and forearm, hard enough to cause dog bite injuries / launch him 30 feet, but gently enough to not cause bruising except on his hand. How do we explain it? How do we explain the no bruising? We can't explain the no bruising. That's why I love Dr. Sheridan. It's definitive. There's no bruising. He didn't get hit by a car. He did not get hit by a car and projected anywhere, like Trooper Paul told us. No, there would be a bruise. At the very least, there would be a bruise. At 24 miles an hour, there would be tissue damage, tendon damage. Yes, you'd blow out your knee or your arm or whatever if you didn't straight up, fracture the bones. It's all incoherent. I don't know what else to tell you. It's all incoherent. Kieran both drove to 34 Fairview in the morning and didn't for purposes of the accident reconstruction. She did because we really want her to look like she's guilty, like she had consciousness knowledge of the fact that he was already out there in the snow. But she also didn't because it doesn't fit the mileage in the accident reconstruction, and it would not fit. You can't work that in. You can't work that in. So it's all incoherent. This is why, as much as I'm not looking forward to Lally's closing, I am looking forward to it. I mean, what a challenge. What a challenge to try to turn all of this into something coherent that's credible at all. Is he just going to dump it back on the jury like he kind of did in opening? You're going to hear all this stuff. Ladies and gentlemen of the jury, you heard all of this stuff, and some of what you heard suggests that Karen hit him with the car in reverse and then drove away. I mean, is that what we're going to get? Where he just disregards the problems with his evidence, the holes that were poked in his own evidence, let alone the affirmative stuff that the defense brought. I just don't know how he can he can give us a theory that incorporates everything. I don't know how he's going to be able to do that. Marcelo Frias, I never thought Lally would be worse than you're looking for your 15 minutes of fame, but from Elaine, but he is. My God, I cannot stand him. He's pretty bad. I'm not sure yet I have him in the worse than Elaine category. Elaine was one of the worst I've ever seen. I mean, just terrible. Just terrible. Completely unable to adapt. They're on the same level just in terms of their maliciousness, you know, the shady ethics with what they're trying to do, the trying to elicit stuff that is clearly problematic and offering excuses, you know, that don't really fly. Not that we heard excuses from Mr. Lally, but we have to assume when they get called up to the bench, he's offering some explanation for why he's doing what he's doing, and it's just, you know, his explanation is getting discarded. But just the sheer incompetence of Elaine, from my perspective, it's close. I mean, don't get me wrong, it's close, but I think just a little bit of an advantage goes to her on that one in my mind. And in part of that is because I just come back to Depp v. Heard. That was a winnable case for the defense. It was a winnable case for the defense. And really all they had to do was not put her on the stand. I just keep coming back to that. All they had to do was not put her on the stand, and then they can rely on perceptions, different views. You know, everybody sees things a little bit differently. Relationships are gray areas. Conflicts are gray areas. Could she reasonably think that he abused her given, you know, these text messages and these the statements and so forth? I think you could win that case on actual malice. I'm not going to say easily, but there was a reason why going into that case, all of the legal minds were like, it's a nearly impossible hill for Johnny Depp to clear because of that standard for defamation. It's nearly impossible to clear. I knew what we were going to see. So I thought from the outset he's going to win it, even though it's very tough. You can't put a high confidence on it because it is very, very tough. But I think that's why I would put Elaine slightly worse on the incompetence scale relative to Mr. Lally, is because she had a winnable case and blew it. I don't know that Mr. Lally, from what we've seen here, has ever had a winnable case. I just don't. You have to start from the standpoint of being able to prove your version of events: a car accident, a collision with a pedestrian, and you just fell abominably short in being able to do that. So the rest of it's just flailing. The rest of it is kind of, I don't know, tantrumy a little bit. Like he's having a temper tantrum or something. But just not sure he ever could have won it in the first place. So yeah, I gotta give him a little bit of credit for that fact that he might have been handed an impossible task. Sandra, same officers who investigated Karen Reed investigated Sandra Birchmore. There was some overlap. A couple of the same officers were involved. Lank was involved from Canton PD. Trooper Guarino was involved with the cell phone extractions from Massachusetts State Police. I don't recall if Proctor was involved. I think he might have been. Not 100% sure on that. So yeah, there is some overlap. There is definitely some overlap with the people involved. But again, the one at the center of all of it that has the connections with both cases, District Attorney's Office. That's the hub. D. Marie with a super sticker. Thank you so much. Really appreciate that. Mad World, I'm actually going to miss this case, chat, Andrea. I'm going to kind of miss it too. We're already getting into that sort of nostalgic stage of the case of, gosh, remember when? I mean, it has been a wild ride. It really has. I didn't expect to be here. I didn't expect that by day 8, I was going to be so captivated by what was unfolding here that I had to be like, okay, I got to just stream this myself. I got to watch it while it's happening because I'm watching it anyway. I'm paying attention to it anyway. And it's just getting crazy. It's just getting crazy. What I appreciate about being able to watch a case like this with everybody is having that shared perspective and being able to validate each other in what we see and what we perceive. We're not crazy. Yeah, we're not crazy. We're not bad guys. We're good faith people trying to look at evidence and come up with good faith interpretations of it. That's it. We're not going to be gaslit by people telling us that stuff is happening that didn't happen, that doesn't make any sense. We're not going to just roll over and put our common sense aside because that's what the Commonwealth wants us to do. Backed into him with the tail light and it hit his arm and projected him 30 feet and scratched his arm. I mean, no. We're not going to buy that. So it is enjoyable to have that experience and to understand you are not alone. If you watched all this and you wondered why the Commonwealth brought this case, you wondered how did this ever get to murder in the second degree? How did any of that seem like a good idea to a prosecutor? You're not alone. You're not alone. Thomas, Paul looking like a lost puppy. I was not watching Paul. I didn't see. I don't really, I mean, I understand the interest in the family and in watching the reactions and so forth, but I don't really like it. You know, I would like them to be able to have a little bit more privacy in their processing of all of this. I recognize they're choosing to be in the courtroom and in the kind of just public eye of it, I suppose. But I don't know. It makes me uncomfortable. I know this is a very difficult situation for them. I'm sure that they have had every reason to think, you know, they've wanted to have faith in the Commonwealth. They've wanted to believe that their understanding of what happened was correct and that the charges were going to be justified and so forth. And yes, we have to wonder how the past several weeks have landed with them. But personally, I would rather just wait unless and until they decide to tell us. You know, I don't want to read things into people's expressions and stuff like that. This is just me personally. I'm not saying, you know, anybody's wrong for doing that or whatever. This is just my preference. I am going to, you know, give them grace and assume that anything really is possible unless and until they choose to tell us what their mental process is here. James Brown, 3 hours deliberation, not guilty. Well, let's set the over-under. Let's set the over-under on 3 hours. Chat. I know there's a way to do a poll in here, but I haven't figured out how to be able to do it. Ugh. Man. That would be a good poll for the over-under. Guys in the chat, over-under on 3 hours. It's set now. Truth Seeker with a super chat. Thank you so much. Really appreciate your support. Farrell Drake, could Lally be in trouble with these FBI results? I don't know that I don't know that we know enough to be able to say in terms of what the FBI is looking at, who the FBI is looking at, how far the scope of their investigation has really gone. If we assumed hypothetically that it is the DA, it's Michael Morrissey, it's that district attorney who was the target of this investigation, would that then extend to subordinates in the office? I'm just not sure that it would. Like, I don't know that they'd be like wiretapping Lally or whatever. I think there would be a problem with intruding into confidentiality with some of that anyway. Not attorney-client stuff, but work product. I think getting into the prosecutor's work product and how they have developed their case and their theories and so forth, could potentially, be protected. That would be an issue as far as if the FBI was getting into that type of thing. But that said, you gotta have some questions about who knew what when. And I mean, this mirrored video alone raises questions about how did it happen and why did you present it like this? Why did you allow the jury to have that misinterpretation, that misunderstanding of what was going on? That's not good. I don't know that that's FBI level stuff. It should raise some bar questions. I mean, that's candor to the tribunal kinds of problems there. Deliberately proffering misleading evidence that you didn't bother to explain. I don't see a direct path for him to be getting in trouble with the FBI, even if the FBI investigation is into the Norfolk DA's office. He's too far down the ladder. You know, he's relatively speaking, not that important in terms of the power and decisions and stuff like that. He's kind of just a peon. So I don't think it's likely, but we don't know. Don't know until we know more about the scope of that FBI investigation. Ever Age, not gonna lie, I'm afraid of a hung jury. You will never go broke betting on the jury not seeing things the way that you do. I mean, getting 12 people on board with anything, it's not as easy as it sounds. It really isn't. So it's possible. It's possible there could be a holdout on the jury for any number of reasons. Just don't buy. Just can't bring themselves to conceive of the possibility that somebody would fabricate evidence, that they would plant evidence. Just hang on. If the taillight is at the scene, It must be because the taillight was broken at the scene. And if the taillight was broken at the scene, that means there must have been some type of impact, some type of altercation at the scene. And it's just too great a coincidence that that's then where we find John, dead of these serious injuries. That is a possibility. It's a possibility that people on the jury that are from this town don't even need to see the video of what happened at C.F. McCarthy's last night to Turtle Boy to understand maybe certain people in this town you don't want to get crossways with. You're better off to just go ahead and give them what they want. Really, it's hard to rule that kind of thing out. I'm not super afraid of it just because I think the evidence is so clear here. If you put the gaslighting aside, the evidence is pretty clear here. Wasn't a motor vehicle collision. So when you take that out of the equation and you add in the dog-bitten arm, what do you have left? Just not a whole lot left to work with. So I'm not super afraid of it, but you can never say it's not going to happen. You just don't know. It's very hard to predict what juries are going to do. Tony tries, nervous, Zach Anderson, innocent, jury convicted. Yeah, same thing. You don't know what they're going to do. You just don't know. And things that you look at and you think intuitively, there's just no way that a reasonable person could think this way. Well, a jury can think that way. And at some point, they probably have. Lousy David, it's my month anniversary on the channel. I joined on day 19 of the trial. 30 days later, day 30. That's some Trooper Paul math and stuff. Well, welcome. Congratulations on your anniversary. Glad to have you here. Yeah, day 19 already seems like a lifetime ago, doesn't it? Let alone all the way back to day 8. Feels like we've been living and breathing this case for half of our lifetimes. Sandra, if a car did not kill J.O., then there had to be a cover-up and all of that evidence was planted. What is next for these bad faith actors? We'd love to know. We'd love to know if there's going to be a sequel here. The FBI investigation, that's a pretty clear sequel. If that materializes into indictments, into charges, that's a big sequel. That's one of those situations where possibly the sequel is better than the original. Because now we just have hints of it. We just have possibilities. An FBI investigation with all the tools and resources that they have available to them that the defense doesn't have access to. Even in the best case scenario, let alone when you're dealing with having to go to Judge Bev and get permission to do your basic discovery. Yeah, the feds don't have to do that. So I think part of the problem too is just figuring out exactly who and how and why. Taillight got back to the scene. We can theorize who and how and why, but there were an awful lot of people in that Canton Police Department Sallyport. Awful lot of people. And the mystery 3 plainclothes officers that were there at the scene. A lot of possible people that could be. So it's kind of one of those scenarios where it's almost like by having that access, that accountability becomes diffused. It's very difficult to narrow down. Well, who's the one in charge? Who's the only one that could have done it? It could have been a ton of them, And so unless you can prove that they're all in on it, like it legitimately is a conspiracy, Which does seem, that does seem hard. That seems hard to prove, that all of these people would be willingly involved in going along with a cover-up. It just seems hard to prove. It seems so much more likely that no, it would be limited. It would be one person or two person, and the rest of the people just turn a blind eye. They just like, well, that's his business. I'm not going to worry about that. It's his case, whatever. Hard to say what they can prove, but we just don't know what they have. We don't know what they've been looking at. Michael Dicha. Einstein said, if you can't explain your theory to a child, you need to work on your theories some more. I like that. I think it's a very good observation. Even dealing with concepts on the advanced level of things that Einstein was dealing with, you have to be able to kind of drill them down to basic things and show how they make sense in terms of our own experience of the world. I think that's a good general idea for how well you understand a particular subject. Anthony Zappin. This case sets a dangerous precedent for the zombie prosecutor that can ruin a person's life on the most tenuous theory. Lally should at least face ethics investigation and potential criminal charges. I do have grave concerns about the ethics here. Some of it, honestly, like maybe I'm just jaded as a criminal defense lawyer. Like it's so normal. It shouldn't be. I totally agree with everybody. It shouldn't be normal for prosecutors to routinely try to elicit things that are clearly not admissible, et cetera, et cetera. But they do, and they've done it for so long without any consequences that it's hard for me to anticipate that there would be consequences in this case. But that mirrored video, that one is the real problem for me. That one is the real problem for me. You knowingly elicited and put in front of the jury something severely misleading. That is a candor to the tribunal problem. I would hope that somebody in charge of ethics would be concerned about that. I just, from experience, don't have a high expectation that that's going to happen. But this particular guy too, Lally's not elected. He's not accountable to the populace the way that the district attorney is. The district attorney can be held accountable by the voters, but this guy, he's just staff there. So we're going to get the instructions conference now. I went ahead and didn't take my lunch in the expectation that this is not going to be a super long session, because it's usually not. They're just going through and comparing who is offered what, and if there's any overlap. I don't know. I still haven't seen if the defense has offered any instructions at all. I haven't seen if anything has been filed. But typically, they're just kind of comparing notes, and then you go through them, identify if there's objections or exceptions, and then it's finalized, and that's pretty much that. So, I'm not expecting this to take all afternoon. Hopefully that was not a bad call on my part. Don't know how can how can he lallify the jury instructions? Shouldn't rule that out as a possibility, but that was just kind of what I was guessing. So I think everything is still on mute here. They're just up at the They're just up at the sidebar. But it's not common. Like even if you have you have a bad DA and people are outraged and they vote him out, it doesn't mean you clear out the rest of the staff. I don't know if they have civil service protections for these employees in Massachusetts, and in some places they would. If you're just a staff attorney, they can't necessarily, fire you for kind of political retaliation reasons. That can be an issue when a new prosecutor comes in. If they come in and clean house, that can open up arguments that it's retaliatory. Sometimes you'll see employment related lawsuits, related to things like that. So I don't know. But it's not common, in part because how are you going to replace those people? These are the ones in the office that are doing the day-to-day work, the grind. They know the people, they're experienced with it. If you go in and you clean house, it's going to be difficult to replace that. I think there's upsides and downsides to potentially, just starting fresh, but you lose the institutional memory with something like that. So just a little bit of a tricky situation. Karen got to be at the sidebar for that one. Oh, that tan.
You are unmuted.
That tan coat dress is fabulous.
All right.
I like that a lot.
So the charge conference, the first question I have is regarding I'll go through them in the order that I have them in my very rough draft, but there's no request of the lesser included offense of voluntary manslaughter to the second degree murder charge. Is that what the Commonwealth's intention is, not to request an instruction on voluntary manslaughter as a lesser included of the second degree murder?
I'm sorry. That's correct, Your Honor.
Okay. And neither side has requested an instruction of a lesser included of OUI?
It's correct as well.
And the defense is not requesting that?
So no straight DUI is the compromise.
All right. So
not clear then. Are they saying not requesting? Are they withdrawing the request for the involuntary manslaughter altogether?
So
or
the first instruction,
as a lesser included,
the request from the defense is that I split the charge, and it's written that way. I'm not going to split the charge. So the way it'll be is the defense will argue first, then the Commonwealth, and then I just go through all the instructions. So aside from that, the first instruction is presumption of innocence. I have one that I typically give, but I will give the one that's requested by the defense. Next instruction is our reasonable doubt instruction. Then function of the jury, the arguments of the lawyers and the judge's comments, function of the judge, functions of the lawyers. Verdict must be based on the evidence. I've incorporated some of what you've both included into that. I have language here that similarly, as you review the exhibits, you may find that some information has been removed because it is not relevant. Please ignore that and don't try and guess what may have been removed or why. I think that came from the defendant's request. Any information that you may have read, heard, or seen about the case outside of the courtroom is not evidence. My instructions to you and any comments I made, the lawyer's opening and closing statements, and any comments they may have made are not evidence. Answers that I struck from the record and told you to disregard are not evidence. Only the testimony of the witnesses, that is, their answers to the questions and exhibits, are evidence, with a more robust instruction, but that's what I've added. And I do have a line about sympathy. Then I do the view. I should say right off the bat, I am not going to give a Bowden instruction. You can argue it. You've been able to put in a tremendous amount of evidence. I've given you a lot of leeway with that. But there is something in this case that and I'm fully within the law to do that. So
Sure.
I have here some language that I think is appropriate based on issues that were raised about the credibility of witnesses. Did the witness have any bias, reason, or motive to give false or shaded testimony? If so, you may consider that bias or motive in your deliberations and ultimately as to whether or not it impacts the credibility of the evidence presented. So I cover the bias part of that. And we'll go through and you can tell me who's going to argue this for the defense. Okay, so we'll go through and we'll do each one.
Great.
The limiting instructions, I give the defendant's bad acts instruction. I'll give a similar instruction on the digital evidence that I did during the trial. Photographs and testimony with an emotional impact, humane practice, and as of today, hypothetical. I had hoped that both of you could suggest something. I said that this morning. Do either side have anything for me on hypotheticals?
I'm sorry, I don't, Your Honor. We're going to be getting back at a fairly early hour. I'm happy to work on it.
That's fine. I mean, I can do it, but I wanted to give you both the opportunity. Yeah, go ahead and do one and send it to me.
I'm happy to do that.
I'll have one to you by the end of the day.
Okay, thank you. All right. Opinion testimony, evaluation of exhibits, direct and indirect, and circumstantial evidence. So I received today defendant's request, a late request for the law allows both direct and indirect evidence, and there is no distinction to be given. A conviction, however, may not be based upon the piling of inference upon inference or on conjecture and speculation. I don't think that's exactly the language from the case law here that you've cited.
I actually quoted it, Your Honor.
So from which one? From Haunch or?
From Haunch. Haunch quotes McCormick, and McCormick takes the law from Dustin.
Yeah, so.
Multiple cases that.
Right, and the language that is typically given on this piling that I haven't really seen in years is you should not pile inference upon inference until the pile gets so high that it tips over logically or the chain gets so weak that it doesn't hold together anymore. When you run through your inferences, check the starting point and the ending point to make sure they're still reasonable. I mean, I could give that old language. All right. That's, I haven't given that in years, but I'll give that part of it. And just to finish off that paragraph, when the evidence tends equally to give rise to either of two inconsistent propositions, the Commonwealth has established neither proposition. In order to convict the defendant, you must find that all the evidence and reasonable inferences that you have drawn taken together prove that she is guilty beyond a reasonable doubt. Okay, so that rounds off that.
That language will work for the defense.
All right, so now we'll talk about the indictments and the lesser included. So the second degree murder instruction that was provided by the Commonwealth and the one provided by the defense are just a little bit different. So if you take what was provided, there's one section that the defense incorporates that I think is missing from the instruction, and I'm going by the SJC instructions. So when you get to the second element of second degree murder, the defendant intended to kill John O'Keefe, the second element first prong. So the second element is that the defendant intended to kill John O'Keefe. As you can see, the second element has 3 sub-elements. I'm reading from the Commonwealth's proposed instructions, which I shall call prongs, and the Commonwealth satisfies its burden of proof if it proves any one of the 3 prongs beyond a reasonable doubt. The first prong is that the defendant intended to kill. Now here, I am going to insert, because if you go back to the SJC instructions, I think it is appropriate to go back to the instruction on deliberate premeditation, which is the second element of that, is the language that is offered here by the defendant, that the defendant consciously and purposefully intended to cause the death of John O'Keefe. So who's arguing this for the Commonwealth? So Ms. McLaughlin, does that make sense there?
Yes, ma'am.
Okay, so I am going to put that in there. All right.
No challenge to the other sub-elements?
And the defense has the language of accident there, but Mr. Yanetti, that really goes at the end. That goes, as you'll see if you look at the instruction on extreme atrocity or cruelty, where you have to go. So that'll go at the end. That will go after the third prong definition. Then I will include the language that I think the Commonwealth put in its request. It goes there. If you have a reasonable doubt as to whether the victim's death was accidental because the death was caused by a negligent, careless, or mistaken act of the defendant, or resulted from a cause separate from the defendant's conduct, you may not find that the Commonwealth has proved the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have created a plain and strong likelihood. Then you have in deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. You may consider any credible evidence that the defendant suffered from a mental impairment or was affected by her consumption of alcohol or drugs. That goes there.
That's fine, Your Honor, with us.
Okay, does that make sense to you too, Ms. McLaughlin? Okay. All right, do you want both the mental impairment or consumption of alcohol and drugs? Oh, do you want to just leave the whole generic sentence?
I think we can, yes.
Is there any objection from the Commonwealth on that?
I don't believe there's any evidence of mental impairment, but.
You sectioned her.
All right.
You sectioned her.
There's no evidence of drugs either, so do you want it to just be alcohol?
I suggest that would be most in line with the evidence, just to have intoxication under alcohol.
All right, it makes sense to me, Ms. Yanetti, if we focus just on the alcohol, but if you wanted the mental impairment, I'd include all, but.
I would prefer, Judge, just to keep it in this jump as
All right, so I will think about this one tonight, okay?
You sectioned her. It's in evidence.
Okay, then manslaughter while operating a motor vehicle under the influence of liquor. So, Mr. Yanetti, you have included in the language, what does it mean to be under the influence of alcohol? That paragraph that starts after the third element? Yeah.
So guys, this other prosecutor arguing the instructions, I do not think that means that she is going to be giving the closing argument. It's just that instructions tend to be more pure legal issues. It's setting things up for appeal. And that's kind of the role that she has played in this so far as the briefing and stuff like that. So I think she's handling that, but I think I'm going to guess that Mr. Lally is still going to do the closing argument.
I have it, yes.
All right, so you have included, it means that a person has consumed enough alcohol to reduce their mental clarity, self-control, and reflexes, and thereby left them with a reduced ability to drive safely. Where is that language from?
This particular portion of it, I thought was from the model instructions. If I'm wrong, then we're fine with model instructions on this issue.
All right. What does the Commonwealth say?
The Commonwealth's language comes from the model and jury instructions, I believe from the most recent 2024 instruction on intoxication.
And that's not in the Commonwealth's request, correct? That sentence I just read?
On page 5, the third paragraph, it's either a similar sentence or a...
Yeah, it's a similar sentence, and I was just having both. It was, a person is under the influence of alcohol if they have consumed enough alcohol to reduce their ability to operate a motor vehicle safely by decreasing their judgment, alertness, and ability to respond promptly and effectively to unexpected emergencies. So we don't need both, Ms. Yanetti?
I agree.
So you had both, so I'm just not going to do that,
We're perfectly fine with that.
okay? So under the second theory, so the Commonwealth is proposing the theory of the 0.08 or greater. The evidence supports that. I'm going to do that. So in the language from the Commonwealth, the fourth element, now then we talk about wanton and reckless. So for the fourth element, Ms. Yanetti, this is where your language you have language for 5 that actually belongs in 4, I think. I'm just going to find it. On the foreseeability, I think that belongs under 4. And that's where I'll have it. Okay? Belongs at 4 instead of 5. Do you agree with that, Ms.
No, yes, that's fine.
Okay, do you agree with that, Ms. McLaughlin? It belongs under 5?
Yes.
Okay. All right, so I'll keep it, it belongs under 4. I'll keep it at 4 and not have it at 5 where you put it, Ms. Yanetti, okay? All right. I am going to give the lesser included offense of involuntary manslaughter.
So as a lesser to manslaughter while operating under the influence.
So there's an additional language that I have found helpful in other cases. When I discuss the language and the cause of death, remember, Ms. Reed caused John O'Keefe's death if her actions directly and substantially set in motion the entire chain of events that produced the death. And then the next sentence is a defendant's act is the cause of death where in a natural and continuous sequence results in death and without which death would not have occurred. Okay, so those 2 sentences I find go better together, Mr. Yanetti. Is there any objection to that?
No, I understand the question.
Okay, any objection from the Commonwealth? So, Mr. Yanetti, you have in here a police officer's opinion about a driver's sobriety, like that testified to in this case. A police officer didn't testify as to the defendant's sobriety. So,
I think you're right.
so okay, so that paragraph that begins with that, we'll just cross that out.
I think that's fine.
Okay. In this same instruction, I have included in the paragraph, in deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another. Some portion of the sentence that I'm going to think about tonight, I have, you may consider any credible evidence that the defendant suffered from a mental impairment or was affected by her consumption of alcohol. Okay? Any objection from the Commonwealth on that?
No, Your Honor, that was requested by the Commonwealth, if you could consider it, please.
Yep, so that will be in that last paragraph of that offense, Mr. Yanetti. Okay, then the lesser included offense, motor vehicle homicide, felony OUI, liquor, and negligence. I'm going to give that. So I don't have anything because the defense didn't propose any lesser included. So I didn't see anything that was inappropriate about the Commonwealth's instruction, Ms. Giannetti. I've added, I think, one line that a person acts negligently when she fails to use due care. That is, when they act in a way that a reasonable person would not act. This can happen either by doing something that a reasonable person would not do under the circumstances, or by failing to do something that a reasonable person would do. It's obviously the law, right?
She pulled that from another form instruction.
And I do understand the law of lesser included and,
Okay.
right, I give that.
All right, thank you. So leaving the scene of an accident resulting in death. So what the Commonwealth has provided is basically just the six elements with nothing further. They're pretty much 1 and 2 have already been defined for the jury many times at this point. 3, the defendant knowingly collided with John O'Keefe. I think that's self-evident. So, Ms. McLaughlin, why don't we start from here? Why did you just give me the 6 elements?
Your Honor, as you suggested, the first 2 have been defined extensively for the jury, and I believe the other 4 prongs are self-evident, and they don't need further instruction.
Yeah.
I think it would be sort of redundant or unnecessary to explain to a juror, what failure to provide documentation of registration and things like that does not warrant additional instruction.
Do you think they need to listen to me any longer than necessary, Ms. Giannetti?
We're in complete agreement, maybe for the first time in this.
All right, so we'll just leave it. You've offered 6, 2 pages or 3 pages of definitions, so we won't do that.
It's fine.
Okay. All right. Ms. McLaughlin, the use of a dangerous weapon, a motor vehicle, I agree that's an appropriate statement of the law. Tell me about your request to have that.
Your Honor, the request goes to the defendant's state of mind. Also, it would go to any intent or any understanding of the jury of what would be reckless conduct or negligent conduct or intentional conduct. If they understand that the use of a motor vehicle to commit a crime could be a per se dangerous weapon, and in using that to strike an individual, that could be used in their deliberations, assessing the defendant's intent or state of mind at the time of the collision.
There would be nothing.
It seems to make sense, Ms. Giannetti.
My position is it's unnecessary, but I'm going to waive argument beyond that.
Okay. All right. I think it makes sense, and I'll just leave it sort of as a catch-all at the end where it appears
It
on the
doesn't make
Commonwealth's
sense to me.
request. All right, so that's basically it.
Seems
The
deliberately
first,
inflammatory.
The longest part maybe is the general instructions in the beginning. Anything specific from the Commonwealth that I did not include?
Do you intend to give a consciousness of guilt instruction?
Oh, I'll hear you on that. I don't, but you can try and convince me if you want.
Your Honor, the Commonwealth would put forth that there's been sufficient evidence that the defendant has engaged in actions that go to a consciousness of guilt. There's an inference that the defendant deleted portions of the Ring video, a narrow area of Ring video.
There's a lot more evidence of Bowden than there is of consciousness of guilt.
They begin with Mike Camerano picking up his daughter at 11 a.m. They resume at 5:07 when the defendant backs her vehicle into John O'Keefe's. Then there's a period missing where the defendant shows the broken taillight to Jennifer McCabe and Kerry Roberts, and then the video resumes again.
And
when
they failed to
the
show
victim's niece gets
any
back.
access
But
that she
not only
had.
the missing Ring videos, but also the
Proctors
defendant's
who had
behavior.
access.
What began as the As testified to from the Dayton police officer, the defendant's father called the Dayton Police Department and requested a ride to the Good Samaritan Hospital due to the weather conditions. He then drove himself to Brockton to pick up the defendant and perhaps bring her home. What they do in the middle of a blizzard is now Dayton to Brockton is half a distance. Then they travel further all the way back to Canton to retrieve the murder weapon, along with the defendant's brother. They all meet at the victim's residence to remove the murder vehicle and bring it all the way down to
The
Dayton,
murder
Massachusetts.
vehicle.
That would go to concealing evidence and intentional. There's also
Heidi,
evidence,
if you're watching, please draw
of
the murder
defendant's
vehicle.
statements going to her consciousness of guilt within hours after John's death. The victim's sister-in-law calls the defendant, reaches out, wants to make sure she's okay. The defendant says to her, "I only have to remember the bad times. You'll likely never hear from me again." Erin O'Keefe testified that she tells the defendant, "Of course we are, we're friends." She's never heard from the defendant since. So I think that goes to the defendant's state of mind in the hours after the death. But in addition to the ring video, I think there's strong evidence of consciousness of guilt to move the murder vehicle within hours of John's death.
The murder vehicle.
Mr. Yanetti?
Well, first of all, with regard to the ring video, Trooper Guarino, who was certainly no friend of the defense in this case, testified that there was zero evidence that Karen Reed had access or had access
Yes, he did.
anything on that computer, and the Commonwealth utterly failed to prove that she had any access to delete anything. So I would say that that is a red herring. This is the one case, I think, a very rare case where there's much more consciousness of guilt evidence with regard to the Commonwealth's own witnesses than there is with regard to the
That's right.
case. With regard to the other arguments, I'm having trouble following.
So the moving the car extra distance during a blizzard.
Ridiculous.
That part of the argument that the Commonwealth made.
Right. I mean, the evidence was that my client maintained a residence in Mansfield. She didn't live at One Meadow. She spent time there. To say that moving her car to her own home, where the police later found it because she was there and picked up the phone and said that the police were coming, and she stayed there. And
Yeah, it's not like she ditched the car.
That does not rise to the level of consciousness of guilt.
Okay.
But the defendant actually moved her vehicle to her parents' residence, so that indictment, not her residence in Mansfield, which would further support an inference that she was concealing evidence.
She hadn't gone back to her house yet.
She's no longer dating John O'Keefe because he's passed away.
Consciousness of guilt if she didn't go home alone by herself that day.
Parents' house or own house again does not rise to the level of consciousness of guilt.
Nor does she stay at the home of her boyfriend to grieve with the family who just lost John. She quickly
Because the family
comes back to the house,
sucks.
brings her family
They were
members,
blaming
goes upstairs
her.
for about 20 minutes by herself with her father.
Why did you
and
drop
quickly
him
leaves the
off?
residence.
How could you have dropped him off?
There's no evidence that she did anything upstairs or that she had access or the ability to change anything.
Okay. It's a little bit more robust argument than I expected from the Commonwealth, so I'm going to think about this. I'll let you know before closing argument tomorrow, and if I don't instruct on it, Commonwealth's still able to testify to it.
It's ridiculous.
Witness pretrial preparation, that came out on both sides. I'm going to give the second alternative. Okay, Mr. Yanetti, I'll hear you on your instructions.
So I believe that we covered the vast majority of it.
I'll give you the opportunity to argue the Bowden one, just so you can make a record.
Sure.
Yes. It's a form instruction.
I'll find your page.
Okay, so yeah, I mean, with regard to the Bowden evidence or instruction, Your Honor, having done this for as long as I have, it's requested a lot and not given, a large percentage of the time. And I do recognize that the court has discretion to give it or not give it, and that we also can argue this is court document.
Right.
But, you know, I think that if there's any case where a voting instruction should be given, it's this one. You know, we start with the conflict of interest that existed at the start of this case, and the fact that Michael Proctor was allowed to not only continue with the case, but to be the lead investigator or case officer during the whole pendency of the case, despite his obvious conflict of interest with the Albert family. We then move to the fact that, you know, he never, as a lead investigator, went into the house at 34 Fairview. He never looked around. He never checked for any signs of struggle. He never checked out the basement. He never looked for a weapon that could have been used to do the damage that was done to the back of John O'Keefe's head. He never once asked about Chloe, the German Shepherd, despite the obvious injuries to John O'Keefe's arm. With regard to the witnesses, Your Honor, witnesses were interviewed in a very relaxed manner at their own homes. There was testimony that they were interviewed together, that they were not separated out on numerous occasions. Brian Albert, Paul Albert, John McCabe, Matt McCabe, all interviewed en masse. Later, everybody in that group, except for Nicole Albert, was also interviewed at the same time. Chris and Julie Albert were interviewed together. And then we have all this, you know, evidence, the way it was handled, or I should say mishandled. You know, starting with the leaf blowers and the solo cups and things being pictured on the floor of garages, but not being properly handled, and the fact that there are no chain of custody laws for the evidence before March of 2022. So I just highlight those, Your Honor, as examples.
The failure to talk to the eyewitnesses.
Okay, so you satisfied you've made a complete record on this?
I mean, so.
All right, but I did include some specific bias language that I read to you early on that sort of ties into this. Okay, so nothing else?
So I have one question. The defendant requested a missing witness instruction.
Yeah, you're not.
I've withdrawn that. That was crafted as the trial was ongoing. I didn't know if we were going to have that or not.
Thank you for bringing that up, Ms. McLaughlin.
I agree that it's not appropriate in this case.
Okay. All right, so I will see you tomorrow morning.
Question, Your Honor, is that, and I haven't tried with this book before, I don't think. Do you typically send a copy of your instructions to counsel prior to?
If I have it finished, I expect I'll be up late tonight and won't have it finished in time for you tomorrow. I do give 2, maybe 3 copies to the jury afterwards.
There was some question as to the use of chalks for closing argument.
Permit the use of chalks for closing argument?
So can we focus on this? So does the defense intend to use chalks?
Two.
What do you intend to use?
Photographs of the vehicle and photographs of the taillight. So 2 side-by-side photographs of the taillight that are in evidence, photographs of the vehicle, still shots of the vehicle that are in evidence.
Okay. Okay.
And that's the extent of it.
So that sounds like Jackson's going to do the closing.
Okay.
It does sound like they're saying chalks.
Commonwealth have any objection?
No, but the Commonwealth also intends to use chalks.
What do you intend to use?
Also side-by-side photographs and video, but also a timeline that summarizes text messages and voicemails and significant events from January 28th through January 29th.
Okay. Any?
The request is I'd like to see that.
Sure, you should both exchange them, okay?
Judge, my other question is that at one point during the trial, there was a changing of 2 jurors, their seats, just for purposes of their own comfort. The way I pick alternates is by seat number.
So I'm going to ask you not to pick them by seat number, Jim, by juror number, juror card number. They may not remember what that is.
No, I have absolutely
no. They may not.
Okay. They may not know their old juror number?
Their actual 3-digit number.
Right. They may not know that? Do you want me to use it?
No, if they know it, we'll use it. We'll talk about this.
Okay.
All right. Why did you want to move them into? We'll talk about this.
Okay.
All right.
No, when is that done?
At the end of the instruction, before I give the instruction on be fair, the SJC instruction on be fair.
Can I ask a question?
Yes.
You pick a four-person.
Yes. Yeah.
So they pick a foreperson, not the jury themselves.
No, so, right. In Massachusetts, it's supposed to be chosen by the judge. So I know. All right. Anything else? Yeah. All right. Thank you. We'll see you tomorrow. Jim.
That's kind of wild. Never heard that before. The judge picks the foreperson. What do they pick them based on? I don't know. I might have to look that up. Might have to look that up tonight, because that's quite strange to me. The Bowden instruction. I got it. I'm going to go ahead and read it to you guys. You tell me if you think this should be given under the circumstances of this case or not. It's entitled Omissions in Police Investigations. You have heard some evidence suggesting that the Commonwealth did not conduct certain scientific tests or otherwise follow standard procedure during the police investigation. This is a factor you may consider in evaluating the evidence presented in this case. With respect to this factor, you should consider 3 questions. First, whether the omitted tests or other actions were standard procedure or steps that would otherwise normally be taken under the circumstances. Second, whether the omitted tests or actions could reasonably have been expected to lead to significant evidence of the defendant's guilt or innocence. And third, whether the evidence provides a reasonable and adequate explanation for the omissions of the tests or other actions. If you find that any omissions in the investigation were significant and not adequately explained, you may consider whether the omissions tend to affect the quality, reliability, or credibility of the evidence presented by the Commonwealth. All of these considerations involve factual determinations that are entirely up to you, and you are free to give this matter whatever weight, if any, you deem appropriate based on all the circumstances. Interesting. So these instructions, they're always followed by notes that kind of relate back to the case law and why you have this instruction, you know, where the language came from and all of that type of thing. Note number 1, instruction is optional, but preferable. It's based on Bowden. It's permissible in the judge's discretion. It just, you know, the appeals court, while recognizing such discretion, has suggested that it might be preferable for the judge to inform the jurors that the evidence of police omissions could create a reasonable doubt. You're supposed to err on the side of the defense on this one. It's preferable. The defense must be permitted to argue. They have a right to argue to the jury that they should draw an adverse inference against the Commonwealth from the failure of the police to preserve and introduce material evidence or to perform probative tests. What might that include? Well, you didn't swab his arm for the dog DNA. You didn't do any of that evidence. You didn't do any DNA collection to do comparisons to the other profiles that were found in the bloody parts of John's clothing. The other profiles that were found on the taillight, the only ones you tested against were Proctor and Buchanan. But what about the Alberts? What about all that? Didn't even ask. Mr. Higgins didn't even ask. Who else's blood or DNA or whatever is all over John's clothing? Didn't even ask to do that. Didn't talk to the witnesses. Now that one might cut against giving the instruction because of the fact that they ultimately did anyway. It was more just that they dragged their feet in talking to Lucky Loughran, talking to Ryan Nagel, the other people in the car, rushed right off to talk to those Aruba girls, but didn't talk to Tristan Morris until, trial was already underway. Because of the fact that they ultimately did do it and that evidence came in front of the jury, that might cut against giving some of this evidence. But yeah, other tests, other questions they should have asked, other steps they should have taken, like separating witnesses, not accepting a self-selected extraction, screenshots of text messages from Brian Higgins, as opposed to asking for the phone itself. A lot of these things in here. That really seem to apply. I gotta tend to side with Mr. Yanetti on this one. If there's a case where you give it, yeah, it's the ones where they put the blood in the red Solo cups. It's probably that one. It's probably that case where they're opening up their biological evidence right there behind that taillight. Yeah. This might be the one where they failed to maintain the chain of custody for all of these plastic pieces that are pretty critical to their determination that it was Karen, it was from her taillight, it was there at the time. Seems to me like if there's a situation where you're going to hold that against the Commonwealth, yeah, it would be this one. So the reason why she's not giving it in terms of why does she feel safe from an appellate standpoint, she's making it clear because I'm letting you argue bias. She's included language about bias. And so therefore, they're not going to be precluded from arguing that the police favored the Alberts, favored the McCabe's, had their tunnel vision, focused in on Karen, and just selectively targeted their investigation accordingly. But I don't think that fully encompasses the sandbagging of the case that it just really looks like the Commonwealth did here. Not just in terms of what's normal procedure in any case. You maintain a chain of custody, you use proper evidence handling procedures, you document who has access to it, etc., etc. But in a case where it's a dead law enforcement officer, you go above and beyond you don't just do the bare minimum. So they not only didn't do the bare minimum here, they fell short under a circumstance where it's just highly suspect why they would do that. Why would you not be completely by the book in this case? I don't like it, but that's what the appeal issue would be, well, did it deprive them of the opportunity, the ability to be able to fully argue their defense? The Commonwealth, based on her comments, is going to say no. They weren't really restricted from arguing anything. They're going to be able to say the investigation was lousy and that the people were biased and so forth. So it's really a no harm, no foul situation. But that specific instruction about being able to hold that against the Commonwealth, yeah, I feel like that one is kind of important here. So, very interesting decision. Obviously, all of that is only relevant if the jury convicted anyway. And where we're sitting at this point, that does seem like a bit of a long shot. Not impossible, of course, but it does seem like a bit of a long shot. Entry required says Jackson should have asked ARCA reconstructionist, have you ever heard of a lawn and leaf blower being used in a CSI investigation to retrieve evidence? Yeah, I don't know if he's quite the guy for that. They're not the law enforcement evidence handling people. I mean, I suppose they could offer some thoughts about why that might not be a good idea given how leaf blowers work and the potential for disturbing the scene and so forth. But I don't know. Honestly, these guys have heard of a lot. Might run the risk that they have. Somebody elsewhere, might have done something like that. Sylvia's daughter, in your opinion, what will happen to Proctor and his merry band of liars? My suspicion, if I were going to predict the sequel here, it's going to be that Proctor will get he'll be the scapegoat for all this. He'll be the one that suffers the IA consequences. Nobody else will. Nobody else will. Even though they were also involved in the the chain, the group chat, even though they're responsible for the failings in so much of this stuff. Tully, who is not only running the search and in charge of the evidence, but is also the evidence clerk, the person with the least excuse for not booking that into evidence immediately and preserving that chain of custody. They're not going to suffer any consequences for it. What's the worst case scenario? That they have to go to additional training. Let's recover some basics on some of this stuff. Is anybody going to be actually punished for it? No, I sincerely doubt it. Trooper Proctor might be, just because it was so egregious. It was so extremely unprofessional, the way that he was talking about her, disclosing stuff about her, personal information about the investigation to people that have nothing to do with it outside of the department, giving his friends special access to treatment to information that's not supposed to be public. So I can see him being thrown to the wolves. He's the scapegoat, and that's it. Nobody else would suffer any real significant consequences. As far as the Fed side of things, I just don't know. It depends on what they've had access to that they could come up with that we don't already know about. I already talked about kind of the problems of nailing down the who, what, when, where, and how of evidence planting and stuff like that. You can't really try somebody if it's just could have been them. If it could have been one person of a group, then you don't have proof beyond a reasonable doubt that it was that person. So that's my prediction. Investigate internal affairs will take care of Proctor. He'll be the scapegoat. Nobody else will suffer any consequences. Base 4241. Timeline plus physics plus injuries plus Jen's lies equals not guilty unless the McAlberts got to the jury. I don't see a good pathway to guilty here myself. I really don't. Proof beyond a reasonable doubt when the informed people are saying she wasn't hit by a car. The people who know how to do this type of work and can explain it in very simple and easily understandable language are saying she did not get hit by a car. Who is saying she did get hit by a car? The guy who doesn't know basic physics. The police officer who doesn't know, one of Newton's basic laws. I don't see it, but yeah, you just don't know. You don't know what people are bringing into that jury room in terms of their personal perspectives and leanings and allegiances and all of that stuff. Nunzio, now that defense has rested, can you talk about that video from the bar where Higgins was taunting J.O. and why it was left out of evidence? So I'm not sure that it was left out of evidence. I think they have just selectively published portions of it to the jury. So this, remember, back to Depp v. Heard, is very similar to what happened with those audio recordings. There was hours and hours and hours of audio recordings of just Amber behaving in these horrifying, abusive, all these different ways, and only a small portion of that actually got published to the jury during the trial. But what happens is the entire exhibit goes back into the deliberation room with them. So they're free to look at any or all of it or none of it as they choose. If they think it's going to be helpful to them, it's there. They can look at it. It's available to the parties to use in closing. I don't know why we wouldn't impeach Higgins with it at the time unless he's just going to deny or make some kind of excuse about what was going on. That isn't gonna help your case. You know, he's either going to deny that it's John, or he's going to say, "Oh, we were just talking about, sports or something. We were arguing about the Stanley Cup." I mean, I don't know. he could just potentially explain around, or just minimize it. My recollection is he said he didn't have like direct conversation with John, so this would tend to impeach that. But he could get around it. Oh yeah, I forgot because it was just in passing, and he was mostly, talking to somebody else standing there anyway. Don't even remember what it was about. It wasn't a big thing. He's going to have some kind of explanation like that anyway. So that's why I would think it didn't come up. It didn't come up in cross. They don't know what the answer is going to be, so they didn't bring it up. They can bring it up in closing if they want to. Doesn't sound like they're going to. If all the defense is going to present is the photos of the taillight. I mean, again, it might be all they need. It might be all they need. Focus on the proof that she didn't hit him with the car, and all the collateral stuff. It's helpful. It raises your suspicions, but it doesn't ultimately matter in terms of getting the verdict you want from the jury. There's no lesser included on just the straight DUI. So they got to prove she hit him with a car. Every single charge going to the jury requires them to prove she hit him with the car. So focus on the proof you have that she did not hit him with a car, and you'll get the not guilty. I could see that. I could see that being the strategy here. Rudoka, the last thing the jury heard, there's numerous, almost infinite possibilities that can result in that type of event. Is that enough for reasonable doubt? Yeah. I mean, all of it has been enough for reasonable doubt. That was a pretty bad place, I think, for Lally to end it with the evidence. They're talking about the number of ways he could have fallen backwards and hit his head. Yeah. How many ways can you think of where somebody could fall? They can be taking a step back and trip over their feet. They could slip on a piece of ice. They could be jump startled by a large noise, a loud noise, and lose their footing and fall back. Nearly infinite scenarios for how someone can fall back and crack their skull, and get a skull fracture. So, was not a helpful place, I think, for the Commonwealth to end. If their burden is to prove it happened this one particular way, well, no, the skull fracture certainly doesn't get them there. A car accident sure could do that, but now we just circle back to the testimony where they started, where this is not a car accident. He doesn't have those types of injuries. From the forensic pathologist, from the accident reconstructionists, very clear and unequivocal, and even the Commonwealth's own medical examiner, they're not typical injuries that you would see from a motor vehicle collision. Jesse Golightly, hi Andrea, why is it incriminating that Karen jumped to the "did I hit him" conclusion when I'm sure JM told her right away he never came inside? It's what they have. It sounds like an admission. And of course, remember, they're taking off the "did" and the question mark at the end. They're just going with the "I hit him, I hit him, I hit him." So it sounds like a confession. It sounds like she's saying this is what happened. If it was just the question, I think that would be far less incriminating. Because it does seem like she's just thinking out loud. She's thinking of the possibility of what it could be. "I hit him" is definitive. It's a much stronger statement of that's what's happened. So doesn't still rule out her being mistaken that that's what happened. But yeah, I agree. She's sitting there in the car with Jen, and that's going to need to be one of the first things they talk about, because clearly that's where Karen left him, dropped him off outside. And she's saying, well, he never came home. she wants to try to retrace his path, Jen's going to have to tell her, well, I don't know, I can't help you because he never came inside. It absolutely seems like one of the first things that that she would have told him. So, yeah, I agree with that. Be rational and nice within this global sandbox. Commonwealth needs a hung jury, only way to tamp down outrage. They would take a hung jury as a win, I think, at this point. I really do. The question would be, if they get a hung jury, do they retry her? Do they take their losses and run, or do they continue to try to get their pound of flesh? Guys, I honestly think they probably continue to try to get their pound of flesh. The process is the punishment. Make her pay for a whole extra trial. That could potentially be a win for them. Get to hold on to her car for that much longer. I think the risk of that is the federal investigation. If it's still ongoing, you can make another TUI request. You can find out, hey, have you guys gotten anything else in the meantime that might tend to be helpful to the defense? That's really the only risk of a retrial, and they would have notice of that, because it would go to both of them just like it did the first time. I think a hung jury would be a win for the Commonwealth in this case. It usually isn't. Usually you would consider that a win for the defense, but in this particular case, yeah, I think that would be a win for the Commonwealth. D-Pat, will Hallie say back the blue in closing? No, not allowed. Not allowed to appeal to the sympathies and prejudices and biases of the jury. It is not about back the blue. That would be very improper. That would be prosecutorial misconduct. I would expect them to object to that. Probably get some kind of a limiting instruction to disregard it. It is not about backing the blue. It is about what the evidence proves or does not prove. Michael Corey, the fact that they can't put the Commonwealth's theory to their experts is ridiculous. How does one defend oneself when they can't contest the Commonwealth's theory? This was just so confusing about what Bev was sustaining on those objections, like what her thought process is on the ruling. It just goes back to the opaque nature of how these objections are being handled. Once he got back and rephrased it, it seemed like they were foundational questions. Jackson wasn't going to be allowed to ask him if this very specific kind, this accident under these conditions at this speed involving this vehicle, etc., would cause the injuries you'd seen on John if they didn't first establish it would cause injuries. Like, it's just, it just was a little bit ridiculous. Once it became clear that's what the problem was. As soon as he came back and just started with establishing there could be injuries, then she let him go further with it. But yes, they had to keep it all in hypotheticals. I don't understand that at all. I don't know why you would have to keep it in hypotheticals. Is it because it goes to an ultimate opinion on guilt or innocence? Not really. I mean, it's just going to an ultimate fact. And you're going to get all kinds of opinions on ultimate fact. The medical examiner's conclusion as to the cause of death is an opinion on an ultimate fact. I mean, it's something that you have to know in order to reach a determination of guilt or innocence. So I wish I could explain the judge's thought process here to you. I can't. Perhaps at some point we will get the transcript that includes the sidebars, and then we can read what she's telling them at sidebar and try to get a sense of her reasoning there. But for me to just guess out of the blue, I can't make sense out of that one. It doesn't make sense to me. Michael Corey, Birchmore case is literally the premise of the new Apple TV show Presumed Innocent. Lol, very freaky. I'm not watching this. I heard about the remake. And isn't this? It's the Scott Turow novel, if I remember correctly. Scott Turow wrote this book, Presumed Innocence. It's a fun novel. I read it years ago. Like, I think I was in high school when I read that book. And I think there has already been a film made of this one. Might have been Michael Douglas. Am I remembering that right? I just can't remember for sure. But it is a great story. Yeah. There's interesting twists and turns. If it's the same, book, I'm not going to give you guys any spoilers, but it's exciting. It's a on the edge of your seat type of story. Debbie O, they're supposedly coming back at 2:30. Will you be covering that? Wish I'd caught this earlier. Yes, here we are. We covered it. We watched it. Did not want to miss that instructions conference. Alec Collins, video orientation thing, surely stupidity, not deception. So obvious. Anybody point me to the waterfall set 2. I don't know that it's not stupidity versus deception, because if it was just stupidity, somebody would have noticed, and you just would have mentioned, oh, this looks weird. I see this. It's just strange, how this exhibit is showing here, because that's not actually how the orientation was. The fact that they did nothing to correct it and call it out is what speaks to the deception, not so much the fact that it happened. The fact that it happened is pretty sketchy to me, insofar as the timestamp didn't get reversed. Somehow just the video image gets reversed, but the timestamp looks okay. That looks pretty deceptive too. So I don't know if I'm going to agree that one's stupidity. Under the circumstances, I don't know that I can agree with that. James Brown, favorite white tea. I'm on the Silver Needle. Silver Needle white tea is my favorite right now. There's been a couple others I've tried. I can't remember off the top of my head. I used to get my tea from Upton Tea. It's just another, place online. We've got a local tea shop here now where I can get some tea, and they have a few different types of white tea, but I am I'm stuck on my Silver Needle. It's kind of basic as a white tea goes. Like I get that, but I just enjoy it. It's large. So I like to rebrew my tea a few times. It holds up real well to that. When you use it, I've used different types of pots, like brewing methods and stuff. When I would use a Japanese pot for a while, and the size is good for, you don't get like little, pieces of tiny little bits of tea leaf down there in your tea. You don't get dregs in your cup. I don't like dregs in my cup. So those are like my main reasons why I stick to the Silver Needle. But I will check out Dragon's Treasure and see what they have for white. And if I find a good one, I will let you know. Steve F. 1, ineptitude. 2, intense unlikability. 3, a cockamamie case for which we still have no coherent theory. There's no way Lally could get this done. I mean, what could a really charming prosecutor pull this off? Maybe. Could they just get the jury to want to believe it so much that they would overlook what seemed to me to be just fatal, obvious problems with the evidence in this case? Maybe. I don't want to underestimate how much the jury's perception of the participants and who they like and who they trust, the role that plays in the ultimate decision that they've reached. I've seen a whole bunch of studies of jury decision making. These are usually based on reports and things like that. But there's different ways that these studies can be done. But often they'll suggest the case is decided in opening, and it's not based on the relative evidence, the strength, stuff like that. It's who they like. and who they trust. If the jury wants to believe you, they can often find a way. So it's easy for me to look at this case from just the pure evidence standpoint and say it's not winnable. Nobody could win it. But when I kind of stop and sit back and think about the psychology of the decision making, I'm not actually sure it was completely unwinnable. I'm not sure I could say a very charming prosecutor couldn't have convinced the jury to want to believe it, and to just think the alternative explanations are so implausible that means this one was proven beyond a reasonable doubt. But yeah, those other factors didn't help. Lally being inept and very unlikable definitely did not help. Terry B. Birchmore was pregnant also, correct? In the UK, you'd be charged with double homicide. Yes, she was pregnant. She was pregnant. There are some states in the United States where you would be charged with double homicide also. I don't know about Massachusetts. You can be charged in my state in Washington for a separate homicide charge for causing the death of an unborn fetus. So yeah, that can definitely happen if there were murder charges on the table. Track worker, heard Bev had an interview with feds. Attitude changing today. I don't know if that happened or not. I haven't heard anything about that. I don't know if we would hear it or not. I can't say I've seen a big change in her perspective. If she was suddenly becoming pro-defense, she would give the Bowden instruction. I mean, it's so bizarre to me why she wouldn't give it anyway, like with the presumed innocent instruction, for example, or the beyond a reasonable doubt. She's like, yes, I'll go ahead and give the defense's instruction on that. Because then they can't argue its error. If you give what they ask you to, they can't argue its error. They can definitely argue if you give instructions, you refuse to give instructions that they've requested and that the evidence supports. Yeah, they can argue that's error. So it's such a strange decision to me when it seems so clearly to be supported by everything that we've seen. Of course, these are not standard procedures to collect blood in solo cups and use leaf blowers to collect evidence. And even just basic things like we heard from the accident reconstructionist today, the way he's used to seeing crime scene photography happen. You have the broad overview and then the step in so that you can just kind of gradually improve your perspective. And then you're able to see, yes, where are things in relation to all the other things? Not just, here's a piece of taillight way up close in the snow. That doesn't give you particularly good information. So that type of decision too, with how you choose to document and preserve the scene. No using crime evidence markers, things like that. It's just hard for me to see a way of looking at this case where that's not called for by the evidence. She seems to be relying on, well, it's my discretion, so I don't have to. I mean, okay, I guess not, but you're opening the door there for that to be an issue if, heaven forbid, she was convicted. You can be sure they're going to raise that. Of course they would raise that. I can't say I see a significant change to her attitude. Z, was there any ruling on Commonwealth's June 18th motions? We did not get a specific, explicit ruling on the record. What she did tell us was that it was based on a discovery violation, and so in light of that, the issue, she did find there was discovery violations, not because there was any wrongdoing on the part of the defense, but just because technically speaking, yes, there's a deadline. Stuff was disclosed. After the deadline, stuff was disclosed in a limited fashion. Not necessarily what the Commonwealth was entitled to. But that was all cured. The issue was what remedy was the Commonwealth going to get for that? And it was cured by having the voir dire. So she didn't specifically say she's allowing the motion, she's denying the motion, but ultimately she did deny it for all practical purposes because she let that evidence come in. Lori J, even if KR did it accidentally or intentionally, the Commonwealth did not prove it beyond a reasonable doubt. I don't think they proved a vehicle collision. I don't see it. It's the basic problem here with this case. If you're going to argue she killed him by hitting her with the car and then by hitting him with the car, and then we're going to argue about the degree of culpability depending on her mental state, you got to get past that initial hurdle if she hit him with the car. I don't see that beyond a reasonable doubt at all. Michael Behan with a super sticker. Thank you so much, Michael. Appreciate that. RB0426, charging conference 230 per Ted Daniel. We are on it. We are on it. We caught it. Entry required for MIT interactive McAlbert Canton butt dial study. That would be quite fun, wouldn't it? Having some butt dial experts brought in onto the stand. Were you able to recreate these conditions through your own testing? But did you also have the glasses in the bed during the intimate moments? Because you need to eliminate all those variables. Stephanie H. The fact he said blizzard conditions and we saw the library video, that doesn't equal blizzard conditions. Yeah, very true. The overstating and just the conflating of what was going on in different places at different times throughout the course of this day. And just the exaggeration of it, like even Dighton was the worst. And so clearly they would like us to think, oh, it was like that everywhere. It was like that the whole time. It was like that in Canton too. I don't know if it was like that in Canton too. Storms can be, remarkably localized in terms of how much, rain gets dropped, precipitation and stuff like that. I think that's a matter of common sense and experience. I can be on one end of town and it's raining on me, and the other end of town is still having, blue sky and sunshine. You don't really need an expert for that. But even in Dighton, where it's that bad, we still got Trooper Buchanan is going to have to try to tell us the snow was up to his waist. The snow was not up to your waist. It wasn't even like over Karen's tires in the driveway. No, it was close. It was kind of getting close to the top of her tires, but no, that's not your waist. That's about your knee. You had about knee level snow. It's a good powder day. Very good powder day by, I think, pretty much anybody's definition. Definitely by East Coast standards. Holy cow. Anybody who was skiing that day or the next day over there on the East Coast, that was glorious, unless that powder was just limited to Dighton. But yeah, they really want us to think, well, because it was really bad later on at some point, that it must, that must have been how it was at the time. But we can see how it was at the time. And frankly, even the next morning on the dash cam, after it had supposedly gotten a lot worse, really doesn't look that bad. Really doesn't look that bad. We can hear stuff from the dash cam, from the recording, the recording of the voicemail that accidentally got picked up on Karen's phone. Like, we can see with our eyes, like, things are not getting blown that hard. No, it doesn't look like, it's just more of the exaggeration of the conditions. Bev, odds that Commonwealth slips in witness intimidation. Well, that's going to go to the consciousness of guilt stuff, right? They didn't argue that. Kind of surprising. The one thing they didn't argue for consciousness of guilt in support of that instruction was the terrible harassment. And maybe that's because they couldn't definitively say it was Karen that did it, but they did get Jen McCabe to volunteer. Well, they think. Jen McCabe thinks Karen's behind it. it's speculative. You can't prove that. Certainly not in the context of this case. But yeah, none of that harassment of the witnesses as part of the consciousness of guilt. So I don't know how it comes in otherwise, without that. Now, if they get that instruction, honestly, I can't believe on that showing that she's even considering. She's like, I'm inclined against it, but I'm going to let you, Commonwealth, argue. I'm going to let you argue it. And then she's like, I didn't expect such a vigorous showing, or whatever she said. What did the Commonwealth add that you didn't already know? You already anticipated the ring camera video, and the problem there is, never proved she had any access to it at all. Never proved she had any access to it at all. The only access appeared to be from John's phone, and she didn't have his phone. She didn't have her own access. So you don't get there from the ring camera video. So what was new to the equation? She picked up her car and took it home. Took it to her parents in Dighton. This is somehow consciousness of guilt. What did she not do? She didn't take it through the car wash. Why would she have gotten in the car in the first place if she had consciousness of guilt? Why would she have gotten in the car that morning anyway? Why wouldn't she just be like, Jen, come get me. Come get me at John's house. So because she drove to her parents' house in Dighton after she had been released from the hospital, where she is, severely stressed and everything, because she didn't go home alone and sit by herself? That's consciousness of guilt? It's just ridiculous. Did she go look for replacement taillights? No. I mean, I'm just not seeing what the consciousness of guilt here could be, because you drove the car to a place where you were then known to be and told police where you were and where you could be found. I don't get this at all. Consciousness of guilt would be something like ditching the car, listing the car for sale, trying to repair the damage on the car, etc., etc. None of that. None of that. Not, I drove it to Dighton where then I told the police I was and they could come there and talk to me. So I don't know why Bev has to think about this, but this is just her once again kind of bending over backwards to the Commonwealth to sort of, compliment them unnecessarily and undeservedly on things that they've done in the case. It's stupid. No, if she wasn't considering giving it before, that should not change the equation at all. Z, how do you feel now about cover-up? Well, it's the most plausible alternative explanation is the problem that accounts for the sketchiness. It accounts for all the sketchy behavior with the butt dials and the searches. And he wasn't out there, according to Lucky Loughran, at the right time, but the Ford Edge was. And he should not have been on top of the snow. He should have been down at ground level, but he was on top of the snow, so the timing doesn't work. Yeah. Looks a lot like a cover-up. If you can't put him there at the 12:30-ish, 12:45-ish time frame, when there wasn't any snow on that grass, then where was he the whole time and how did he end up back there? The cover-up starts to seem a lot more plausible. What's the alternatives? Oh, he wandered away and never went inside, but then just happened to make it back there hours later and happened to, fall down and die of what? How? Right at that particular place? Nope, not plausible. We're back to, it looks like he was in a fight and something happened and he was left out there later, much later. Joe Mendoza, but did any of the experts bring the muffins? Lol. Yeah, well, Dr. Curry, that was the impeachment by muffins. I'll give that to Mr. Lally again. If we're doing that side-by-side comparison, who is more incompetent? At least Lally did not try to impeach the experts with muffins, having brought muffins to their part of the examination. Yeah. Anita E., do you think conjecture could be that John threw the glass at the vehicle? That could explain the "did I hit him" question. It was the glass. They were touching on that today. It makes some sense, doesn't it? Because the missing piece that we don't know what it's about, is Karen saying they had a fight. You know, she said that in the interviews. Her last contact, they had a fight and she dropped him off outside. That could be consistent. That could be consistent with having a fight. So we get back again to kind of the motive and the time frame and how this would have unfolded and what we can see from the evidence. We see that interaction between Higgins and John O'Keefe on the video camera at the waterfall, where, yeah, they are having some kind of conversation. Yeah, it does look exuberant, for lack of a better way to put it. You know, can we see a situation where Higgins is suggesting something like, maybe you want to look after your woman, maybe you want to see what she's up to when you're not looking? And then John's all antsy around Karen once he goes back to the table. Why? Because he wants to ask. He wants to know. Not necessarily want to ask her in front of everybody, because, you know, that's embarrassing. Oh, hey, I'm a cuck in front of all these people. Hey, Karen, did you cuck me? Yeah, no, he's not going to do that. He's definitely not going to do that. But then alone in the car? Would you have that conversation? Maybe. Maybe. And have a fight about it? Maybe. Maybe. And then would he maybe be really mad and throw the glass at the taillight? Maybe. Yeah, he might. And then go in hot to the house, all ready to confront the people that are there, that already know. They already know the story. Higgins has told him. This is his best friend. Higgins has already told him. He comes in hot to the house. Could have had a conflict with anybody. Could have been Colin. Mouth off something smart. Something smart to him about his girl. And that's it. Now they're throwing down. I can see this scenario a lot of different ways along those lines. And yeah, I could see that. That could make sense. That could make sense. Just an alternative explanation for how the taillight got broken. Maybe it didn't get broken backing into his car. Maybe it didn't. Maybe he really did. He threw the glass at it, and that's what broke it. Fairly consistent with the size of that piece. The problem, though, is then they actually would have had that plastic at the scene that they could recover. That would be part of the problem. Maybe that's what caused the gouge in the back. He didn't hit the taillight, but he hit that back part, caused the dent, the glass chip. I don't know. Maybe. Duncan, Idaho. Ever seen the 13th Warrior? I think he was attacked by a Wendell Lexus, which appears and behaves like a dog, wears a dog hide, and attacks with crudely made dog teeth weapons. I have not seen that, but we definitely need to have some fantasy / sci-fi explanation for the Transformer car that turns into a dog. that bites the arm while it's striking him in the taillight. I mean, there's just no plausible real world explanation that I can think of that reconciles all those things. Chloe gets out and bites him while he's laying on the front unconscious, but before he dies, maybe. But we still have no vehicle collision here. He's not bruised, he's not broken, he did not get projected into the grass the way that they're describing. Joe Mendoza, doesn't that make Lally worse than Elaine, though, if he incompetently thought he could win this case if nobody made or coerced him to prosecute the case? I mean, maybe in terms of not knowing your limits, not knowing your skill set, I just go back to could a very charming prosecutor have won it? I don't know, maybe. Elaine's case was certainly winnable, but the problem is that they were caving to what she wanted, what Amber Heard wanted. She was bound and determined to get on that stand. She was bound and determined to show us all, her voice, her testimony, her inability to generate tears as the acting coach testified to. God, that was funny. So, in some respects there, I can see Elaine being somewhat limited also. You think, and at least in theory, the attorney gets to control that. They get to control the strategic decisions in the case. And most clients, even if they have very strong opinions, they will defer to you as the expert. I'm just not sure. Not sure that Amber Heard would have left that open as an option. And that kind of seemed to be why Elaine was such a good fit for her as an attorney anyway. She was willing to file this ridiculous counterclaim, that certainly from a timing standpoint kind of looked like maybe Roberta Kaplan wasn't willing to do that. Timing-wise, that's kind of how all that went down with the bot report that Roberta Kaplan was the first one to tell us about, the 13 bots that Mr. Boozy, Christopher Boozy, found that appeared to be inauthentic. Yeah, that's not a widespread, influential conspiracy headed up by Johnny Depp to publicly smear her. That would have no influence at all. It would not explain the millions of signatures on the Aquaman petition, which is really what she had her big problem with. So Elaine could have been, constrained for all practical purposes. You do the trial Amber's way, or you won't do the trial at all. And Amber's way was inherently always going to be a losing way. It's just, that was not the approach to take in this case strategically. Mr. Lally may have had more freedom in terms of whether to pursue it or not to pursue it. So I could see that argument. I just don't know is the problem. I don't know to what extent he had that discretion. That can differ a lot from prosecutors' offices. Some of them, the elected is kind of a micromanager. We had, it's been a decade or so now, but I remember one of the jurisdictions I practiced in, they get a new elected prosecutor, and he starts handing down all these rules about, they're going to review the individual prosecutor's decisions. They're going to review plea bargain offers. There's only going to be one plea bargain offer in the case. And if they don't accept that, then it's trial or nothing. Just very micromanaging of how the deputies do their jobs. Most offices, in my experience, are not like that. These are experienced prosecutors. They're deputies for a reason. You authorize them to make those kinds of judgment calls. If you don't want their judgment, then you don't need experienced prosecutors. Just hire them all and get people fresh out of law school to do what you tell them. That will be a lot cheaper than keeping on some, 15, 20-year veteran if you're not going to take advantage of those skills that presumably they've acquired over that period of time. So I just don't know to what extent this was a decision that Mr. Lally had to himself, but it would be interesting to know. That would be interesting. Kamala Norris, don't y'all know how important the McAlberts are? Well, I mean, I feel like I saw it on video last night. They feel pretty important in terms of being able to decide who gets to go where in Canton, who's not allowed to step foot there. Yeah, that's not America. That's not how we roll here. Lori J, create a poll from the bottom of chat window, tap create a poll, create your poll, and then select ask your community. Thank you for the instructions. Little late in the day. Maybe I'll remember this for tomorrow. We'll do the over under that Mr. Brown set at 3 hours for us. So let's see. Create a poll on the chat window and then ask your community. All right. I got the note. Thank you so much for that. I'll see what I can do tomorrow. Joe Mendoza, verdict takes 2 hours and 27 minutes. 2:27. That would be fun. Wouldn't that be fun? That would be ironic. Jay Richardson, as a former Marine artillery officer, I agree with Crash Dad. Cannons are indeed awesome. Thank you for the legal analysis. I start L1 in August. Well, good luck to you. It's I enjoyed law school. That's a weird thing to say. It's probably an uncommon thing to say, but I really did. I enjoyed law school in a way that was just far beyond undergraduate. And maybe it's because I was on my own in terms of like I chose to do it. I was paying for it. It wasn't like mom and dad expected or anything like that. But I did. I just found it very engaging and fascinating to start to get this window into this world that I had no idea existed. Just all of these rules and processes and ideas that imbue everything, every single thing. I sit here and I look at this camera and I think about the trademark that goes into it's a Sony FX30. I think about the trademarking that Sony has, associated with this camera, the branding, the manufacturing process, the employee, liability issues on a factory floor, the potential for implied warranties of fitness for what I'm using it for, like when the camera, shuts down during stream when it's supposed to be specifically there for streaming, that kind of thing. Thinking about the land use that goes into the mining to get the minerals, to fabricate the manufacturing process for the plastic and the regulations that they have to comply with. I mean, every single thing is just imbued with so much law. And I had no idea until I went to law school. So, but I agree. That would be, what a fun job. What a fun job Crash Daddy had. Make a cannon to shoot things at a tail light. I mean, the smile on him. Yeah, we all felt that. We all appreciated that. We all had a little bit of envy and wish that was our jobs too. JB with the super chat. Thank you so much. General, are the experts' reconstruction reports available to the jury? They are not. They are not in evidence. They are hearsay. The report is technically hearsay. This is why, generally speaking, the reports don't come in. The witness is there to testify firsthand so that it's live in court and it's not hearsay. They can refer to their report typically to refresh their memory of what they did and the conclusions they reached and so forth. But the report itself generally does not come into evidence. Joe Mendoza, imagine the ethics guy is besties with DA plus Albert. I mean, you can't rule any of this stuff out. Ethics are typically going to be at a state level. So they may not have the local capture that somebody in this particular community would have. Now, that said, the overlap between internal affairs and law enforcement, that I don't know about. I don't know if internal affairs is your own department or if that's going to go up to some kind of higher level. But typically with the attorneys, the ethics are state level because that's who does the licensing. You know, it's not Norfolk County that licenses him or polices him or anything like that. It's the state of Massachusetts. So you can hope that his political reach doesn't extend that far, but I don't know, because if he gets his political reach through Mr. Morrissey has been a state legislator before he was a district attorney. So we got to assume he's got connections that extend beyond his little corner of the state. The crypto tax lawyer. Does Yuri testifying re number of drinks KR had not go to sobriety? Oh, it definitely does. I don't think there's a question about whether the instructions should have included the language about alcohol affecting her ability to operate safely, her ability to perceive and form intent and things like that. They were really arguing over that mental condition language. The defense, wanted it to stay in. I tend to agree with them, even if you're not going to argue it. You leave it there if there's evidence that justifies having it in there. They sectioned her the next morning. Okay, that is evidence of at least somebody thinking she's got a mental issue. Proctor's up there saying she's a whack job. Okay, they went out of their way to try to suggest that she's like pathologically jealous or something like that. Well, you live by the sword, you die by the sword. You want to try to argue she's a whack job, then you get instructions that contemplate maybe she's a whack job. And if she's a whack job, maybe that undermines your ability to be able to prove your case. The whole interplay with intent. So you don't normally get to say, I'm not guilty because I was drunk. It's not an affirmative defense in that sense. But you typically can always argue what I call diminished capacity is the way we talk about it in Washington. We get a specific instruction here for voluntary intoxication, and it basically says drunkenness is not a defense, but you are allowed to consider evidence of alcohol consumption to the extent it may have affected the witness's ability or the defendant's ability to form the mental state required to commit the crime. So, if you're really drunk, how coherent are you? Like the line between negligent and reckless and intentional can potentially become a lot more blurred under those types of scenarios. And then that also includes like, what if you're in a blackout state, and the limitations on your ability to perceive and exercise judgment and stuff like that. So that's kind of what that instruction is really limited to. It's not saying, it's not like insanity where just I'm drunk and therefore that's exculpatory. No, it's not. But it can relate to those mental state elements. Sobriety and as far as, Yuri's testimony is just going to go to the weight of whatever the jury thinks that testimony is worth. And if they go and watch the video for themselves or watched it for themselves in court while he was testifying to it, should not be giving it much weight. The crypto tax lawyer. Also, what does it say re Lally that he did every single direct and cross, assuming Ms. M didn't refuse to do any of it? Also, Bev almost gleeful. Well, he was clearly running the show in terms of the presentation of the evidence and the theories and so forth. And his assistant, Ms. McLaughlin, was there to help with the briefing. That's not a real uncommon division of responsibility in a trial team. We see a little bit of a similarity with the defense where Ms. Little was clearly involved in doing the preparation of the expert witnesses and just sort of taking that part of the case was really assigned to her. But they were, certainly more generous in terms of let her have some time on the stage, so to speak, get some practice actually questioning the witnesses and doing cross-examination and so forth. Mr. Lally, what should we infer from that? I can see it two ways. I can see it that he's kind of like Bev, maybe, and a bit of a control freak. It's going to be done his way. I could see it as he's going to be the one taking responsibility for whatever the outcome is. You know, if it's a situation where he's the fall guy and he knows the fall guy, he knows he's the fall guy, he knows he's drawn the short straw in terms of taking this to trial, but it's going to be a favor to people, you know, he'll look bad, but it's gonna serve him, then he gets both sides of that, right? He'll be the only one responsible, but he'll also get all the credit, you know, with the political allies and stuff. Just a couple ways I could see that being interpreted. Eric Wolfrook. Her father came to pick her up after she had been sectioned as a possible self-harm person. Yeah, I mean, this is going to, why'd they go back to her parents' house, or, you know, after her dad had called for the ride? Well, yeah, she's not going to be able to come get you. They are involuntarily taking her to the hospital. So yeah, you got to come up with a plan B to get there. And then the possible self-harm, yes, this goes to a mental condition. That would go to a mental condition and justify that part of the instructions. So Michael Corey, for the non-lawyers, the consciousness of guilt evidence that was mentioned is laughable. That usually looks 10 times worse. Kind of like disposing of your cell on a military base before you're arrested. Yeah, the military base that you cut through, like everyone does. Who doesn't go through the security needed to get onto a military base just as a shortcut? And you just happen to stop and use their dumpster to get rid of your phone while you're there. Ugh. Pretty ridiculous. I think that was, yes, a great point that Mr. Yanetti made, and I agree with him completely. In fact, I would have liked to have seen it explicitly stated. If we're going to give a consciousness of guilt instruction at all, let's make sure we also include the witnesses in there, because there is as much, if not quite a lot more, evidence of consciousness of guilt on the part of the Commonwealth's witnesses than there are on Karen Read. They're the ones who got rid of the phones. They're the ones who were keeping an eye on the investigation and reporting back in their group chat. They're the ones who were denying the calls that are there in their call log. They're the ones, because they know, you know, it looks bad if you're chit-chatting with people after you're supposed to have gone home and gone to sleep. They're the ones that there is evidence of deleting, you know, extremely incriminating Google search. That might have been a way to turn it. If you're going to give it as to the defendant, you need to make sure you include the Commonwealth witnesses in that also. He didn't make that request, but he certainly made the point that the evidence as to her is extremely marginal compared to the evidence as to them. Tin Cat, Judge thanks the prosecution for everything they raise, including implying looking for a lawyer is consciousness of guilt, but admonishes the defense. Yeah, we've definitely noticed this. Definitely noticed this. The whole consciousness of guilt for trying to call a lawyer is just appalling. It's appalling that she would compliment them on raising that. It really is. And then if the defense has anything to say, third party culprit, you know, we're in shock and horror. I haven't had that one for a while. Shock and horror that the defense is raising what the evidence seems to pretty clearly indicate as a possibility. Entry required. Bowden instruction, you may consider police tunnel vision. It's, yes, it's really that you can hold that against the defense, against the prosecution. You can suggest that in and of itself is reasonable doubt. Their failure to go down these roads that they reasonably should have gone down. If we could conclude that they would have gotten different evidence had they gone down those roads, yeah, that can be reasonable doubt in and of itself. That's the part of it that I think the jury should be hearing in this particular case, but apparently is not going to. James Casatelli, would Lally get fired if this wasn't bizarro world after this trial? No. No, this is normal prosecution, how they behave, how there's no consequences, not just for underperformance, but for straight up potentially being misleading, being ethically on the edge. There are certain places where the culture is, you would applaud that. They would applaud this guy for going to such lengths to try to get the conviction at whatever cost. He would be regarded as heroic in certain circles. So no, he would not get fired. Prosecutors suffer almost no consequences even for things that are far more egregious and in your face than this. 74 Hodag. Why did Commonwealth bring this case? Because otherwise they'd have to charge a cop. They would have had to look at him. Can't conclude they would have to charge a cop, but they would have had to have made the cop's life uncomfortable because it's the cop's house. So they would have had to make him uncomfortable, and that would have made them uncomfortable. And so they thought it was easier to just avoid all that and go along with the story that they were given. Story they were given is Karen did it, even though we initially thought domestic and he was hit in the face with a cocktail glass. There's an interesting idea I hadn't thought about. If we're positing that that John maybe threw the cocktail glass, possible that these people looking out the window, they saw a cocktail glass. They saw it being thrown. They saw that happen. That's how they knew to suggest that's what happened. That it got thrown. Maybe it hit him. Wonder if they saw that and watched it happening, and then somebody got smart with John when he came in hot through the door. And that's why they got in that fight right off the bat. God, I wonder. Track worker. She'll give bias Bev instructions guilty because I said so. I don't like her ruling on the Bowden, and I don't like that she's even considering the consciousness of guilt. But other than that, I'm not sure that I take too much of an issue with the instructions that she's given or the decisions that she's made about it. She is giving in a lot of the places where there's options to choose the defense's language versus the Commonwealth's language. In several places, she is choosing the defense language. There was that one instruction that she talked about where she says, I haven't given that particular language, in years. But if the Commonwealth wants, or if the defense wants it, I'll go ahead and give it. And so she did. I think that it was the piling inferences on inferences language that went to, direct, indirect, and circumstantial evidence. So she did give the defense, a fair amount of what they want, which is really the smart thing to do with instructions. If they're legally correct and the evidence supports them, you should give them. You avoid creating appeal issues that way. Entry required. I come here into other law tubers seeking knowledge. I learned a lot, Mr. Entry required. Well, we're glad to have you here. I learn a lot too from a lot of the people in the chat. Great little brain trust we've got going on here. And I hope this isn't the end, with this case. I hope that we find some other stuff to follow and that we get to keep doing this into the future, because I just find it very, very invigorating on an intellectual level. Mavka, the biomech pointing out the DNA on taillight wasn't blood was huge to me. Still wondering the answer to Hoslong to die in cold. Yeah, I would have liked to have known Hoslong to die in cold myself. It was just one of those unanswered questions, the process of the hypothermia and the absence or precursor to frostbite, that was just all very unclear, and what you would really expect under those types of circumstances. I'm sure that the accident reconstructionists don't get to go there because that's not involving force. That's not involving the engineering kinds of principles. That is a little bit more into straight medical / forensic type of testimony. I don't need to know, but yes, it would have been helpful. Even if it's just to clear up, like, you can't know, it doesn't help you with the timeline. I would just like to know that, because I'm always going to wonder. I'm always going to wonder, was there something here about the frostbite that could have helped the case? But yeah, I did like that, how Dr. Rentschler was just straight on. Yeah, I was aware that there was DNA found on the taillight, but there wasn't any blood. And it was a small amount, as I recall. Yeah, that's very consistent with trace, very consistent with contamination. It's consistent with, poor, low quality DNA, which is not what you typically find in blood. So no evidence of blood is pretty big, because it suggests alternate pathways for that DNA to be able to get on that tail light. I just realized I still got the banner going. We don't need that anymore. Corruption ledger. One good repercussion of a guilty verdict would be heightened awareness of police corruption. Maybe some citizen action that effectuates change. Well, there will be outrage if there is a guilty verdict. I have very little doubt about that. The public perception on this seems pretty clearly to be in favor of Karen Read, notwithstanding efforts of certain outlets, hello Court TV, I'm looking at you, to try to put their finger on the scale. The people that are watching and that are paying attention see what's happening here and see the problems with this case. So yeah, I think there would be some outrage. Would it be enough to really spur a significant change? I don't know. What really is the power that the citizens have to change the system? There's a lot of power to change the actors in the system, right? People can get voted out, but the problem is that can just be a Band-Aid. You vote out one guy, and you vote in another one who's just as bad as the first. You haven't solved anything. There's just an underlying problem here with the power, the decision-making responsibility, the rules for the grand jury process, and how easy it is to be able to get an indictment. There's just issues with that whole process that aren't necessarily going to be solved by a change of personnel. I don't like to be too skeptical or too pessimistic, but I do. I just have very serious questions. This would not, if there's a guilty verdict, it would be far from the first unjust guilty verdict that we've ever seen. And yet none of those seem to be effective at producing any kind of significant material change. If somebody's got an example, a counterexample, I would definitely love to know about it, love to think about it, but I can't really think of examples off the top of my head. I mean, look at like the Duke lacrosse case, right? What happened there? Well, the prosecutor got disbarred and he got criminally charged, as he should have been. Was there any big institutional change? No. No, as a matter of fact, Rolling Stone magazine is still out there perpetrating rape hoax stories on campus. Like, they're bound and determined to push this narrative. So they're going to do that to the extent of getting sued and losing for defamation for it. I mean, I guess maybe it's an upside that nobody got charged in that case. But I don't know if that's like an institutional change. I don't know if we can say, well, because of Duke lacrosse, that's why that happened. I don't really think so. I think maybe it was just a little bit more fortunate in terms of the personnel involved and the incentives that they had as far as whether to pursue or not pursue criminal charges in a case like that. So yeah, I don't have a lot of optimism about any particular case being a source of significant change in the system. I would like to be wrong, I really would, but I just can't say that I've seen that happen, and given that, I can't predict that it likely would. Joe Schmo, why did Lally run the trial solo? Has very capable co-counsel. Judge Bev today, Commonwealth's argument is more robust than I expected. Have to think about it. Yes, that was the word she used, robust. It was more robust to add in that little part about, well, but she drove the car as being consciousness of guilt. Ridiculous. Ridiculous. I think his co-counsel, seemed to get maybe a little bit of that favorable treatment from the judge that Mr. Lally didn't quite as much. I'm not saying he didn't, because I definitely think he did. But she would also, get short with him, lose her temper with him a little bit, hold him up when he's pretty clearly crossing the line. But yeah, she did sure seem very complimentary of Ms. McLaughlin, didn't she? So maybe that was a strategic misstep. Should have let her get her hands dirty with a little bit more of the stuff, especially the stuff that's a little closer to the edge where you want to push the limits. I don't know. It's hard to tell whether it's control, whether it's wanting to steal the spotlight, have it all to himself, whether it's wanting all the credit for whatever political advantage accrues from having gone forward with this prosecution, or taking all the responsibility for the outcome. I don't know that I'm going to attribute noble motives to Mr. Lally in that decision, but it could also just be a combination of all those things. Coffee addiction, murder vehicle assumes facts, not in evidence. Boy, and then some. You're not going to be able to call it the murder vehicle in front of the jury. I can't imagine. That's assumes guilt, assumes facts, not in evidence. It's extremely inflammatory and prejudicial. You were there. You got to see the murder vehicle with your own eyes. Like, no. But for purposes of shorthand legal argument to the court, well, it's over the top. It's about as much of an exaggeration as the waist high snow that we heard from Buchanan. But it's not improper. It just kind of cuts against, from my perspective, it cuts against your general credibility as an attorney. The murder vehicle, really, it's silly. Alec Collins, okay, agreed. We re-footage inversion. That it looks malicious to me. It does not look like just an oopsie. It looks like a deliberate attempt to deceive. Not saying I'm 100% right on that, but that's just, I have a hard time making sense out of those circumstances. If it's not, they were trying to get one over on the jury and hoping nobody would notice. Debbie C., why did the defense not address the Life 360 data? I have to assume they're going to get there in closing. I don't know if Mr. Green did anything with the Life 360 data. They got out what they needed to get out through Jen McCabe. The fact is out there. It's in evidence. I think the question then becomes, what else are you able to do with that? I don't know. I mean, I suppose, yeah, theoretically, maybe Mr. Green could have gone into the Life 360, looked at what's its sources of information for being able to produce these types of reports. Does Life 360 have studies of its accuracy, similar to the Apple Step stuff does, like he was talking about? Have forensic examiners evaluated that with respect to Life 360? It could just be that there isn't much there to go on beyond what they already had. And it could be too just that it's collateral. It doesn't go to the main issue of did she hit him with the car. They really did want to focus on that Hoslong to dying cold at 2:27 a.m. search because that is so damning. It's so damning. It goes directly to your knowledge of John O'Keefe potentially being outside in the snow, left to die. The rest of the cover-up stuff, it looks bad, but it can be consistent with other things. It could be consistent with just general, you had something that you were trying to hide, but not necessarily this accident. Some reason why, you were trying to scatter like cockroaches and pretend like you didn't know anything about what happened. The Hoslong to dying cold goes directly to what happened here, which is somebody dying in the cold. So I could see that too, just in terms of priorities. That part was really essential to get into. Karen doesn't have an unlimited war chest. She doesn't get to take a money is no object approach to preparing her defense. Money is an object. They have to consider that. So they have to prioritize. And that could have just been too collateral under the circumstances for that to land as a real defense priority. Ron Little, microscopic shards is not 1/16 of an inch pieces. It requires a microscope to see. Why was Lally allowed to use microscopic? I think just because it's descriptive. It's just more exaggeration. It's just more exaggeration. I mean, the jury heard the evidence. They can argue that in closing if they want to. These are not technically microscopic. It's not dust. It didn't require a microscope to see. They were small little shards. Small little shards of taillight plastic. If they want to make a point out of that, I think they can. But that's your explanation. It's just his characterization, and it's an exaggeration, and it's consistent with how they've exaggerated this stuff throughout, and that just goes to the weight and credibility of what they have to say. Rain Man YYC, it's a Lexus Mimic. Okay. I'm not sure what a Lexus Mimic is. Lily Smith, the Alberts ordered their police dog to hold him while they all beat him up. It was unclear to me whether this dog had had any kind of police training or whether the dog had started in training but didn't finish the training. That happens a lot, by the way. A lot more dogs are evaluated, and so you'll have somebody that breeds potential police dogs. They will not, it's generally not the whole litter that is going to pass their screening just in terms of temperament and physicality and all of these things that they're looking for to make a good police dog. They're going to select out, the best puppies in the litter, send them on to start doing the training and the development. But all of those puppies are not going to ultimately end up being good police dogs either. Some are going to be too distracted. Some are going to have, not a good work ethic, not focus. They're really trying to pare down, the pool of puppies that they have to just the ones that possess all of the necessary qualities that they need to be a good police dog. It's not going to be all of them. So that was very unclear to me what exactly was going on with Chloe. I don't think she had been a police dog, but it wasn't clear to me if she had maybe had some training as to be a police dog, but wasn't suitable. But then we also heard that it's mostly male dogs that are used for police work. When I think back on it, yeah, that's my experience. I can think of one female dog, but most of the dogs that I remember hearing about were always males, and they tend to be pretty young too. The oldest one was he was 8 when he got retired. He was The dogs are pretty general purpose, especially in small departments. But they would bring him out mostly to sniff, not so much necessarily to like track the suspect and bring him to ground or whatever. But I'm sure he could. I mean, those dogs are pretty tough. And 8 is not really that old as far as dogs go. McRae, why do you think the reconstruction experts weren't asked how the taillight pieces ended up where they did? Because I don't think they have a good record of where the taillight pieces ended up. I think that was probably part of the problem. When Dr. Wolfe was describing that, the issue being the evidence preservation and documentation here was not what he was accustomed to seeing, because you couldn't tell where things were in relation to the other things. That's the real problem here. They don't know where the taillight pieces ended up and how they ended up in relation to each other. They just have a few photos. They have like those 3 photos from the search. And then a whole bunch of other pieces with no real documentation. So, I think that's really what the problem is. They can't possibly have an opinion. They could have an opinion on the lack of documentation, but not the mechanism of how they got there, because they don't have good enough information. It's a garbage in, garbage out scenario. And my impression is these guys aren't going to offer a garbage opinion. They're just going to point out, no, it's garbage. It's garbage coming in. So you just can't draw those conclusions. Stephanie H., I will need rehab from not spending every day with you. Aw, sweetheart. Well, thank you. That's a very, very sweet thing to say. I don't intend to vanish by any means, but I will confess, I'm not heartbroken to not be getting up at 5 every single day. It will be kind of nice. Get a little bit of a break, maybe even walk around, get some exercise during the day, some time outside. I might enjoy that, but I will find something else to cover. I don't have any doubt about that. I'm kind of looking at Baldwin. I've been kind of looking at that one. I mean, it's intriguing, but I'm not really sure if I want to get down that rabbit hole. But yeah, we'll see. And I will be back, even if it's not like right away. It's just a temporary, lack of your fix. I will be back. Michael Behan, loving this thread and chat from Dublin, Ireland. Well, welcome. Welcome, sir. We appreciate you from Dublin as well. Oh man, I so enjoyed getting to hear that accent today. So musical. I'd love to be able to hear you say that to me live. James Casatelli, just FYI, BH is talk about Otis Air Force Base on Cape Cod. That's the base where he did his cut through. 20 years ago, I went to school there. Townies were allowed to drive through. I believe there were a few facilities they were allowed to use as well. Okay, well, that's interesting information. That's definitely different from, what I would think of. It's not like places, Air Force bases and stuff like that I've been to. What's the one in Tacoma? That's the one that I remember. McCord, I think. Yeah, I can't remember the specific name, but I think that's what it is. Anyway, yeah, you definitely can't go in there as a civilian. I'm used to seeing on the East Coast when we've just been on road trips or whatever, and you do drive past a military installation. There's like a gazillion warnings, restricted area ahead, and you drive by and there's the gates and the guard towers and stuff like that. So it's definitely good to know if this one in particular is not like that, because I would just ordinarily, assume that it is. So maybe it's not so implausible then that he just drove through and that happened to be a convenient place for him to use the trash dumpster. Just happened to be a convenient place for it. Marcelo Frias. In my opinion, the Commonwealth tried to get that Google search by Karen because they saw how Bev would Oh, S their D. If they ask her to and decided to give it a try. Yeah. I mean, they saw they had an advantage, so why not try to push it? Makes absolute perfect sense to me. It's just so out of the bounds. Like what's crazy, it's still crazy to me that it really looked like she not only contemplated it, you know, she not only considered going along with it, but she actually praised them for raising it and for the good argument they made in support of it. It's a terrible argument. It's a terrible argument, and they should be ashamed of even bringing that up. Consciousness of guilt. But yeah, I think you're absolutely right. They thought they might be able to get away with it, so why not? Why not give it a shot? Mavka, Lachlan is a lady, aka whack job, can't have it. Yeah, fair point. Fair point. Can't have a smart, intelligent woman presenting stuff, even for the Commonwealth. Boy, imagine her on direct examination of Proctor. Well, I can't answer that question. That's a question a whack job would ask. No, of course he wouldn't. Of course he wouldn't. But yeah, that's a funny point. All right, guys. That's it for your chats and your comments. Closing arguments tomorrow. Closing arguments tomorrow. I'm expecting this to be good. I am expecting gold from Karen Reed's defense team. They have had weeks to think about this and to prepare and to put the pieces together. This is just the culmination of everything they have worked on for all this time. The same thing is true, of course, for the Commonwealth. It's just that their raw material is so inferior to what the defense has to rely on. The Commonwealth is going to struggle with reconciling all these conflicts in the evidence, presenting a coherent theory that accounts for everything that the jury has heard. And if they are not going to account for everything the jury has heard, then they are going to have to persuade the jury, why should you believe this version over that version? It's a tough challenge. Very tight little needle for the Commonwealth to thread in this case. And I really don't have a lot of faith in their ability to do that, because I haven't seen much in the way of an ability to do that at all so far. We didn't see it in opening. We haven't seen it in adjustments made as the trial has progressed. I mean, literally one witness, you know, like a couple days later, we got one witness trying to put Karen Reed at 34 Fairview, and like the next day, a witness saying, yeah, got to have this very specific mileage calculation for the crash reconstruction to work, and that does not include a trip to Fairview. So they just have tried to have it all, and it's not going to work at this point. It's no longer going to work to just throw everything at the jury and hope that they can make sense out of it. This is put up or shut up time, because the defense is going to be there pointing out all of these discrepancies, all of these holes, and your lack of ability to explain them. So I am expecting gold from the defense. They have been looking forward to this for a long time. You look forward to closing for a long time as the attorney. You're thinking about closing before you ever even get to trial. You know, as you're figuring out what the evidence is, as you're figuring out what your theory of the case is, your strategy, what you're going to emphasize, what you're going to de-emphasize. Yeah, you're thinking about this really from day one. So if the Commonwealth has been doing that, it doesn't seem to have helped them so far. But we'll see. I could be wrong. We'll see. Maybe this will be the moment that finally, at long last, Mr. Lally has some inspiration and is able to give us a little bit of magic. I'm not going to hold my breath, but I'm not going to say it can't happen. Poppet 2, thank you for listening from Wales, UK. Well, thank you for joining us from Wales. Beautiful country I'd love to visit someday. I've seen lots of photographs, but never been there in person and would love to. Another lovely accent as well, that Welsh. All right, guys, gonna wrap it up. Really appreciate all of you joining me again today. It's been another big day, another big crowd. Very exciting conclusion to the trial. No more evidence, and now we are just moments away from it going to the jury. So this has just been a great experience having all of you here. I've really enjoyed all the questions and interactions and stuff. For me, it's just kind of normal. Because I've been doing this for so long, it's not really that extraordinary to look at a trial and think about what's happening and the strategies and so forth. But I really appreciate how much you guys appreciate that from me. So it's just a blessing to be able to have this time together and this sort of group mind that we can bring to these issues and see what kind of consensus or not we all come to. Everybody's got all of these different perspectives, and so you just kind of notice when they start to align. There's probably a reason for that. So we'll look forward to seeing what we get tomorrow. I did see, by the way, just the last thing, I did see some comments that Bev had mentioned something about the defense going first. I don't believe she means the defense is going to go first in the arguments. Either she misstated or she was talking about the order in which they give the instructions. She was talking about splitting the charge. And so sometimes what I understand them to mean is just how the instructions are divided up in terms of like giving all of the charges, giving defenses to that charge, giving the general instructions, like how all of that fits together. That's what I understood her to be talking about. My expectation would be, as normal, the prosecutor is going to go first, the defense will go second, and then Mr. Lally may have a rebuttal argument if he reserves some of his time for that. So that's what I'm expecting process-wise. But we'll see. I could be surprised. It's just that would be what's normal. So I'll look forward to seeing that tomorrow, guys. And we'll start off our day with some instructions and some Mr. Lally. And then that gold from the defense. And then I think the jury will have it by lunch. And then the countdown begins. Looking forward to it, guys. Thank you so much again for being here. I look forward to seeing you guys tomorrow. Take care.